I think I figured it out how to make the AV sound come.
Bhavna, we can start.
Ladies and gentlemen, a very good morning, and it is my pleasure to welcome you all to the second edition of the BW Legal World's Global Legal Summit and Legal Leaders Awards. Well, the theme for this year's event is Conquering Opportunities in 2021 through Legal Tech, Talks, and Compliances. Well, ladies and gentlemen, my name is Bhavna Bhatia, and I am glad to be your host for today. Well, with a view to bridging the gap between the business and the legal sectors across the globe, and to get stimulating discussions on the road, BW Legal World brings business leaders and legal giants from all verticals of the legal fraternity, law firms, in-house departments, jurists, independent practitioners, writers and researchers, law institutes, legal tech innovators, and more together on one platform. While pushing forward the vision of BW Business World, BW Legal World prides itself on covering the revolution in the legal landscape worldwide to bring its readers latest trends and information and being the common thread that ties them all in opportunities to build a brighter future. Well, set up in 2019, BW Legal World is an offshoot of BW Business World, a fortnightly magazine launched around 4 decades ago that has since consistently ranked amongst India's largest and most respected business magazines. Well, BW is a brand known for its independent, incisive writing and opinions backed by a competent team of professionals. Over the past few years, BW staffers have won almost all major business journalism awards, including the Red Ink Award twice, the Polaris Award 4 times, the Indian Express Journalism Award, and the Sri Ram Award, amongst others. While BW has created it to its credit, marquee events like the Most Respected Companies Awards, Magna Awards, and the BW Young Entrepreneur Awards, and many more. Well, moving on with the summit, championing the cause of the change, BW Legal World is delighted to bring the distinguished legal luminaries on one virtual platform today for an enlightening dialogue to discuss pressing issues that need our attention. Well, let's spread the word outside and share the experiences from this platform with a wider audience. And I'd request everyone to join us in the online conversations by using our hashtag BWGLS as one word. Also, you can watch us live on Facebook as well. Well, before we start, it is now time to request and invite, ladies and gentlemen. It is going to be a great day filled with power-packed keynotes and panel discussions. And I'd now request Ms. Ashima Ori, Managing Editor, BW Legal World, and the Senior Editor, BW Business World, to join us and give us the inaugural address, and also therefore introduce our chief guest for this Global Legal Summit. So thank you so much, Ashima, for joining us today live. Over to you.
Thank you so much, Bhavna. Like you said, celebrating the champions of the legal ecosystem right at the beginning of a new year sets the remainder of the year with unparalleled optimism. At BW Legal World and BW Business World, we aim to recognize the right talent with a view to fueling excellence in the legal and business ecosystem. We feel honored to have a distinguished jury panel for this year's BW Legal World Legal Leaders Awards. We are grateful to our August jury, comprising of Honorable Mr. Justice Deepak Mishra, former Chief Justice of India, Honorable Mr. Justice Deepak Verma, Honorable Mr. Justice K.S.P. Radhakrishnan, Honorable Mr. Justice A.K. Sikri, Honorable Mr. Justice Deepak Verma, Senior Advocate and Member of the Parliament, KTS Tulsi, Mr. Neeraj Kishan Kaul, Senior Advocate, and Ms. Geeta Luthra, Senior Advocate and Vice President, Indian Council of Arbitration, FICCI, for taking their precious time to interact with the nominees, evaluating their accomplishments, and choosing 36 leaders of them all. Before we move to the Legal Leaders Awards for 2020, we have with us some of the best legal minds from India and overseas speaking to us about the important aspects of business and law, including legal tech, compliances, ease of doing business, privacy and security, trends in white-collar crimes, and much more to give us a roadmap for the decade ahead. I welcome you all to BW Legal World Global Legal Summit and wish you a wonderful day ahead. Now we move to our keynote sessions, and it would be my privilege to call on Honorable Mr. Justice Deepak Mishra, former Chief Justice of India, with over 19 years of experience as an advocate and 22 years of experience as a judge. Honorable Justice Deepak Mishra has selflessly served the bar and the bench over the course of his distinguished legal career. His verdict in the Nirbhaya case drove the genesis of a stringent anti-rape law in India and many other landmark judgments that have upheld the concepts of individuality, liberty and dignity of an individual, right to privacy, equality of rights, freedom of expression, and so much more. I would like to welcome former Chief Justice of India, Mr. Deepak Mishra, to BW Legal World's Global Legal Summit. Sir, thank you for joining us today, and we look forward to your insights on arbitration and mediation, the two pillars for effective dispute resolution, economic stability, and collective harmony.
Esteemed members of the jury, Dr. Anurag Batra, learned panelists, ladies and gentlemen. At the very outset, I must say that the business world has accepted many varieties of the legal profession, which has been able to introduce the concept of specialization in many an arena. This recognition requires a modern mindset. It pleases me the most, as well as I get immense satisfaction. I am speaking about these two pillars because both have economic and social impact. When there is growth of economy, it requires expertise, skill, and guidance. All these come from various spheres and indubitably from the sphere of the legal leaders, the professionals. Whenever there is amity, amiability, and peace in the society, it is because there is economic growth and economic activity. And that apart, there is a sustenance and stability of law and order. Not for nothing, James Forstall has told us, and I quote, "The only way in which a durable peace can be created is by worldwide restoration of economic activity and commerce," unquote. This gentleman, this thinker, this philosopher has been able to conjoin the idea of peace and harmony with economic activities. All three are extremely important for our civilization and humanity. As we see in the modern world, there is tremendous growth of expansion. Do not take into consideration the pandemic. I'm speaking about the pre-pandemic era and also when we jump into the normalcy again. The concept of digital environment is one of the factors that plays as a catalyst for economic growth. It is because it has a global reach and it has infinite capacity, tremendous connectivity, and complex potentiality. It has the ability to innovate. There is a phraseology that the human mind is able to digitally express itself. When the digital expression takes place in a very rational and authentic manner, there is an economic growth. Now, let me focus on arbitration. When India had its rendezvous with the globalization, there was expectation in many spheres that there would be definite changes in the laws of arbitration because we needed an effective dispute resolution system. And the laws changed, and India started to become a propeller of commercial arbitration. When the new era came in, the tendency amongst the litigants started to curb. Earlier, when the Indian arbitration used to take place, there used to be a tendency to take adjournments, rush to the court, get stay orders. But now there is a development of the mindset by which the legal practitioners are really entering into opposite arbitration and with a different kind of mindset because they are really keen on getting the final result. In the modern world, time is money and everyone tries to save money. Apart from that, there has to be a change, I would like to say, a further change in the mindset. The efficacies of arbitration have to be told to the litigants. They must understand they are the disputants and they choose a forum, and therefore they must participate without reservation and innovation. I must tell you at this juncture of time, adjournment is a disease, and all attempts and endeavors to be made to abandon and ostracize this disease. And this can be done by the adjudicators, by their strictness, and by the lawyers, by their self-cultivation and cultured discipline. And I'm sure if there is no prayer for adjournment, unless it's extremely necessary, the arbitration can further be quickened in India. We need a stable and vibrant ecosystem for arbitral institutions. Whenever an institutional arbitration takes up, we require to have a credible, efficient, able, and transparent method of arbitration. It's a great challenge. That apart, the leadership of the institution should be proactive and it must get the support staff who are qualified and are in a position to work hard and assist so that we have a work culture in arbitration. This is apart from the technological infrastructure and physical infrastructure. Sometimes we lay much stress on these infrastructures, but we must have the ability infrastructure in place. When I say ability infrastructure, I give stress on the quality oriented research and assistance. We must develop arbitration literature, which comes from discussion, deliberation, seminar, workshop, and in-depth learning. This literature has to be spread, and there the institutions, the centers, and other organizations have a formative role. We have to see that the young minds grow in that sphere and the literature really springs up. We must understand that the arbitration is a universal institution. It is not an individualistic perception. Georgi Jakubowski speaks that it's a product of universal mind. When we are living in a universe and competing, we have to really pave on the path of competition. This competition has to be healthy, but not a kind of enviable or jealous competition. When we really compete with a proper mindset, having a feeling for healthy competition, I'm absolutely certain we will attain the enviable position. All of us talk that India will become a hub for international commercial arbitration. But I must tell all of you, we have miles to go to achieve that. It's because we have to really have appropriate laws in that regard, the respect for international arbitration compositions, and must develop ourselves. We must show it in our action. You see, there was a gentleman named Dr. Steve Moravali, and he says, absolute emphatically, and I quote, "The universe doesn't give you what you ask for with thoughts. It gives you what you demand with your actions." It clearly means act and act so that you can really make India a hub of commercial arbitration. Having talked about arbitration, let me proceed to the arena of mediation. Mediation, apart from its conceptual meaning, its etymological essentiality, it engulfs the basic idea of sincere solution of a lease. When a litigant comes to a court and is suggested about some kind of alternative method, be it arbitration, unless a contract is there, or mediation, he will ordinarily ask 4 questions. What will be the gain? Because he is really concerned about the result of his case. What will be the result? What will be the efficacy? Will it be cost effective? These questions are absolutely normal. The United States of America had a Chief Justice, Warren Burger, and he had said, with a touch of humanity, people with legal problems, like people with pain, want relief, and they want it as quickly and as inexpensively as possible. He compares a litigation to a physical or mental pain. Look at the empathy. Similarly, in the process of mediation, we must have this kind of empathy. When I talk about mediation and in the sphere of economic development or economic activity, economic settlement, I keep in mind 2 concepts, psychology and pragmatism. Whenever there is a settlement through mediation, business improves. There is a growth of economy. And remember, the controversy is not put to rest in present time. The controversy is put to rest forever because there is no execution. People accept it and they obey it. And therefore, it establishes intergenerational peace and happiness. Having said that, let me now tell you something. What is really required on the part of a mediator to be an effective mediator and to understand mediation as a tool for arriving at sincere solution of a property dispute or a money dispute or a domestic dispute or a commercial dispute. There are 2 components. One is mediation. One has to understand that it's a legal science. And second, it's an artful craftsmanship. In the Department of Legal Science, I would like to put 1, diagnosis, 2nd, prognosis, 3rd, potentiality of contagiousness, and 4th, constitutional and symptomatic remedies. When I say constitutional, I do not mean the Constitution of India. I mean the constitutional basis of the problem. Now, traveling to the concept of artful craftsmanship, I would like to put in or divide the same to 4 facets, namely psychological base. A man, a litigant, may have the egotism, and that is connected with the psychological base. Psychographic balance, it has some nexus with geography, a territorial mindset at times. Reduction of litigation pathology. And last one, a broader therapeutic counseling to break the positional stand. And let me tell you, ladies and gentlemen, when settlement takes place in commercial matters, by understanding the concepts I have mentioned, there is economic growth as well as social healing. And social healing is a categorical imperative for our progress. Now let us understand another aspect. It is my concluding aspect I emphasize upon. Unless the litigants are absolutely egocentric and they have the attitude of a Duryodhan who says that I shall not leave an inch of land without war, then the matter would be difficult. But barring those categories of people, all others have a hidden desire in them that someone elderly, someone unbiased, someone courteous, someone understanding would come and discuss with us and may be in a position to solve our problem. This is the psychological seed which is there in his heart. A true mediator can bring in this psychological seed to the forefront, and by which the settlements can take place. And when the arbitration and mediation come to the forefront in this country, I am absolutely indubitable there will be economic stability, social peace, and human progress. With this hope and optimism, I conclude and thank the organizers and all other participants. I am sure the discussions during the day shall be absolutely successful. Thank you. Thank you very much.
Thank you so much, Justice Deepak Mishra, for enlightening us today. And what a great way to start our wonderful discussion today. Thank you once again, sir. So ladies and gentlemen, with this, let's move on to our next speaker for today. Well, we've got with us our next guest of the day, Senior Advocate, Mr. Anup Bose. Well, we're going to be hearing from him on the do's and don'ts for young legal professionals. And for all the ones who are viewing us live, we'd love you to spread the word using our hashtag BWGLS on social media. So with this, I'd request Mr. Anup Bose to join us live. As you can see him, over to you, Mr. Bose. Thank you for joining us. So ladies and gentlemen, we've got Mr. Anup Bose right here. Thank you, sir. I'd now request you to please unmute yourself and join us on the main stage and screen. Over to you.
Good morning, everyone. I'm speaking to you from the ever-pulsating city of joy, Kolkata, which has produced no less than 5 Nobel laureates and is today proudly awaiting the whirlwind visit of our Prime Minister Narendra Modi to set in motion the Parakram Divas, or Bravery Day, to commemorate the 125th birth anniversary year of our monumental national leader, Netaji Subhash Chandra Bose. Netaji was not far removed from the world of law. He was in fact intimately connected with it. His father, Janakinath Bose, was a lawyer of immense distinction, and his elder brother and mentor, Sarat Chandra Bose, was an outstanding barrister who was at the forefront of India's freedom struggle. Every young law aspirant knows that practicing law is a noble profession. The legendary Indian jurist and judge Venkatarama Krishnaswamy Iyer, who single-handedly assumed the responsibility of funding Swami Vivekananda's historic trip to Chicago to participate in the World Parliament of Religions in September 1893, in his classic treatise, Professional Conduct and Advocacy, lauded the legal profession as the most brilliant and attractive of peaceful professions, with responsibilities both inside and outside it, which no person carrying on any other profession has to shoulder. He further pontificated that an advocate has to deal with the greatest possible variety of human relations and has his mettle constantly tried from every direction. For the same reason, an advocate earns great social distinction which ought not to be misused at any cost. The avowed purpose of law is to preserve and nurture the moral sanctity that binds the society. Senator Robert F. Kennedy, the effervescent brother of President John F. Kennedy, a former United States Attorney General, captured the essence of this sentiment. Lawyers have their duties as citizens, but they also have special duties as lawyers. Their obligations go far deeper than earning a living. They have a continuing responsibility to uphold the fundamental principles of justice from which the law cannot depart. The Supreme Court of India, in a landmark judgment delivered on 17 January 1995, in the case of Indian Council of Legal Aid and Advice versus Bar Council of India, enunciated that since the duty of a lawyer is to assist the court in the administration of justice, the practice of law has a public utility flavor, and therefore he must strictly and scrupulously abide by the code of conduct, behoving the noble profession, and must not indulge in any activity which may tend to lower the image of the profession in society. In 1829, Justice Joseph Story, the titanic American lawyer and jurist, stated, "The law is a jealous mistress and requires a long and constant courtship. It is not to be won by trifling favors, but by lavish homage." The first 5 years of the professional career of a lawyer are most critical and invariably determine his success at the bar. If after his admission to the bar, the young lawyer squanders his precious time paying more attention to the varied pleasures of society, the irresistible lure of alcohol, tobacco, and drugs, not to mention the opposite sex, and the alluring amusements of the intellect and mobile telephony and other modern-day distractions than he does to the study of law and interests of his clients, he can never hope to be successful at the bar. John Scott, first Earl of Eldon, the erudite English barrister and Lord Chancellor of Great Britain, once remarked that in order to become a great lawyer, a man must live like a hermit and work like a horse. This dictum may be too severe for a young lawyer to follow in practice in modern times, but hard work is undoubtedly of paramount importance. Abraham Lincoln, the towering 16th President of the United States, who is universally hailed as the father of modern democracy, astutely revealed in a historic reply to a letter he received seeking his advice on the best mode of obtaining a thorough knowledge of the law. The mode is simple, though laborious and tedious. It is only to get the books and read and study them carefully. Work, work, work is the main thing. William Wirt, the prodigious American lawyer, writer, and statesman, who was the longest serving United States Attorney General, once advised a young aspiring lawyer, "Take it for granted that there is no excellence without great labor. No mere aspirations for eminence, however ardent, will do the business. Wishing and sighing and imagining and dreaming of greatness will never make you great. If you would get to the mountain's top on which the temple of fame stands, it will not do to stand still, looking, admiring, and wishing you were there. You must gird up your loins and go to work with all the indomitable energy of Hannibal scaling the Alps. Laborious study and diligent observation of the world are both indispensable to the attainment of eminence. My most illustrious senior and guru, Ashok Kumar Sen, the undisputed leader of the Indian bar for over 50 years, and the Union Law Minister in the cabinets of Pandit Jawaharlal Nehru, Lal Bahadur Shastri, and Rajiv Gandhi, whom I affectionately called Ashok Mamu, was never tired of reminding me on a very serious note, never tell anyone that you attended the chambers of Ashok Sen. Tell everyone you were trained in the stables of Ashok Sen, where you were whipped to perfection. And in a lighter vein, he said, the lighter the lunch, the better is the performance in court. This rule does not apply to a legal giant like Fali Nariman, blessed with a gourmet Parsi wife. At the same time, the young lawyer must assiduously inculcate the quality of diligence. Lincoln rightly remarked, the leading rule for a lawyer, as for the man of every other calling, is diligence. Leave nothing for tomorrow which can be done today. Lincoln also laid considerable emphasis on the cultivation of the art of extemporaneous speaking. He observed, extemporaneous speaking should be practiced and cultivated. It is the lawyer's avenue to the public. And I would venture to add that such extemporaneous speaking must be characterized by vigor, cogency, and lucidity. If the young lawyer is desirous of becoming a shining star of the bar and the glorious toast of the profession, he must have an exalted standard of ideal excellence. Benjamin Franklin, the phenomenon American polymath, writer, philosopher, politician, scientist, statesman, and diplomat, and one of the founding fathers of the United States, once remarked jocularly, God works wonders now and then. Behold, a lawyer and an honest man. Young lawyers are often baffled by the hackneyed question, can a lawyer be honest? No man of sense who has read the biographies of Mahatma Gandhi, Sardar Vallabhbhai Patel, Bhimrao Ramji Ambedkar, Lincoln, Chief Justice John Marshall, Sir William Blackstone, Lord Thomas Erskine, Lord Alfred Thompson Denning, and other legal luminaries will ever venture to ask such a frivolous question. In this context, Lincoln aptly observed, there is a vague popular belief that lawyers are necessarily dishonest. I say vague because when we consider to what extent confidence and honors are reposed in and conferred upon lawyers by the people, it appears improbable that their impression of dishonesty is very distinct and vivid. Yet the impression is common, almost universal. Let no young man choosing the law for a calling for a moment yield to the popular belief, resolve to be honest at all events. Further, Lincoln frankly confessed, no client ever had money enough to bribe my conscience or to stop its utterance against wrong and oppression. My conscience is my own, my creator's, not man's. I shall never sink the rights of mankind to the malice, wrong, or avarice of another's wishes, though those wishes come to me in the relation of client and attorney. The young lawyer must never lose faith. Anna Eleanor Roosevelt, the charismatic American politician, diplomat, and longest-serving First Lady who promoted the cause of India's freedom struggle and chronicled her 1952 trip to India in a bestseller, India and the Awakening East, succinctly remarked, if you lose money, you lose much. If you lose friends, you lose more. If you lose faith, you lose all. He must not become unnerved by the numerous hurdles which strike him as almost unconquerable. By perseverance, he will succeed. He must adopt the motto of the inimitable Irish statesman, author, orator, and philosopher Edmund Burke never despair as his guide. He must remember the lofty distinctions which are inexorably conferred upon successful legal practitioners and relentlessly endeavor to succeed. Before the resolute, hurdles rapidly vanish. Lincoln rightly observed, if you are resolutely determined to make a lawyer of yourself, the thing is more than half done already. And further, always bear in mind that your own resolution to succeed is more important than any other thing. John Dunning, 1st Baron Ashburton, the eminent English lawyer and politician, once remarked, "Our profession is generally ridiculed as dry and uninteresting, but a mind anxious for the discovery of truth and information will be amply gratified for the toil in investigating the origin and progress of a jurisprudence which has the good of the people for its basis and the accumulated wisdom of ages for its improvement." Lincoln said, "Law is nothing else but the best reason of wise men applied for ages to the transactions and business of mankind." But profound knowledge and sound rectitude will not always ensure success. Much attention must be paid by the young lawyers to manners in his interactions with his clients and fellow lawyers. William of Wykeham, the celebrated Bishop of Winchester and the Chancellor of England, asserted way back in the 14th century, "Manners maketh man." John Wrathby, the renowned English lawyer, pertinently observed, "Manner is that invisible quality which insensibly pervades with the happiest effect the works of pure genius. It allures where it awes the mind. It speaks a language that no power but itself can express, and is that Attic fire that enlivens every object to which it communicates its influence. In the advocate, it is more immediately discernible than in any other character. Consequently, the want of it will more easily be detected. It is an indescribable combination of ease and dignity. It mixes with and elevates the character without seeming to form any dominant part of it. It is of a dignified nature and is the result only of a penetrating judgment, a refined and enlarged sentiment, a superior virtue, and an extensive commerce with mankind. In each and every situation, whether in court or otherwise, the young lawyer must never forget that he is first and foremost a gentleman, and that he belongs to a most honorable profession, the dignity of which he must conserve with all strength at his command. He must make sure that no words escape his lips which you would dread to repeat in the presence of the most refined company. By being thus guarded in conversation, he will acquire a graceful style, unblemished by intemperate or coarse expressions, which will be of immeasurable advantage to him in the practice of law, especially in the conduct of cases in court, the argument of cases, and the examination of witnesses. At the same time, the young lawyer must realize the utmost importance of self-control and composure. He must not, under any circumstances, permit anyone to be the master of his temper but himself. He must strive to emulate the manner of the ablest legal practitioners who unfailingly retain their presence of mind and sense of decorum. David Paul Brown, the reputed American lawyer, aptly remarked, "By all means, in all circumstances, maintain your composure." If asked what is the most desirable attainment of a lawyer, we should say composure. If briefs do not come instantly, the young lawyer must be gratified to patiently wait until Fortuna, the fickle goddess, smiles upon him. It may be prudent for him to wait enduringly for cases for some time, for then, when he eventually appears in court, if he has made judicious use of his time, he will exculpate himself persuasively. On the other hand, if a case is entrusted to him too early after his admission and he loses it, the injury done to him would be immense. A young lawyer cannot afford to make unnecessary mistakes at the genesis of his career, but failure to obtain cases as soon as he may desire must not ruffle his feathers and must cause him to become discourteous to those with whom he becomes in contact. He must be deferential to all He must guard his tongue well and must especially remember never to speak perniciously of anyone. And he should especially be careful not to speak disparagingly of any of his professional colleagues in the presence of their clients or even otherwise, no matter what he thinks of their capacity or competence. And the young lawyer should, when opportunity comes his way, seek and obtain the advice of lawyers older and more experienced than himself as to the studies he should undertake. The complexities of practice he does not comprehend, and in fact, anything he is not affirmative about. He must never shirk from defending the cause of the poor and underprivileged. Justice Sonia Maria Sotomayor, the first Hispanic and Latino judge of the United States Supreme Court, emphatically stated that lawyers have a professional and moral duty to represent the unrepresented in our society, to ensure that justice exists for all, both legal and economic justice. And last but not the least, the character, credentials, and antecedents of a client should never deter a young lawyer to accept a brief. Here, I am irresistibly drawn to the most pertinent observation made by the Supreme Court of India in his judgment dated 6th December 2010 in the case of A.S. Muhammad Rafi versus State of Tamil Nadu. Every person, however wicked, depraved, vile, degenerate, perverted, loathsome, execrable, vicious, or repulsive he may be regarded by society, has a right to be defended in a court of law, and correspondingly, it is the duty of the lawyer to defend him. I feel confident that young legal professionals will by now appreciate my conception of the do's and don'ts that they should formulate for themselves, and that they will adulate the legal profession and consciously learn what is expected of them as fresh limbs of the law. In conclusion, I am highly emboldened to advocate to them the timeless message of Lincoln. When I have a particular case in hand, I have that motive and feel an interest in the case. Feel an interest in ferreting out the questions to the bottom. Love to dig up the question by the roots and hold it up and dry it before the fires of the mind. Thank you very much.
Thank you so much, Mr. Bose, for joining us and giving us your valuable sharing today. Well, ladies and gentlemen, what an exciting day this is turning out to be. We're right now at this wonderful event organized by BW Legal World. And coming up next, ladies and gentlemen, we're going to be moving on to our next legal luminary for the day. And once again, a big, big thank you to Mr. Bose for joining us today and taking out his valuable time. Well, ladies and gentlemen, with this, I'd like to now call upon for the next keynote session, Honorable Mr. Justice K.S.P. Radhakrishnan, former Judge, Supreme Court of India, will be addressing to you and sharing his experiences today. Thank you so much, Justice K.S.P. Radhakrishnan, for joining us and giving us your valuable time today. I'd now like you to join us on the stage and screen. Over to you. You're on mute. You're on mute, sir. Requesting you to unmute, please.
Am I audible now?
Yes, perfect. Thank you. Over to you.
Yes, good morning, all of you. Let me first congratulate the business world for instituting these awards. The Business World Legal Leaders Award 2000. And I'm also proud. Am I audible to all of you?
Yes, you are. Yes, you are.
I'm also so proud to be part of the jury who selected the winners of this award. And let me first congratulate the business world for organizing such a function and recognizing the skill and knowledge of the legal fraternity by suitably acknowledging them by the institution of various awards, which runs more than 35 awards. Giving away awards is a great form of motivation, especially for young lawyers, because that by giving the awards, they are recognizing their talents in their respective field of law. And the very essence of giving an award is to recognize their expertise and the outstanding achievement they have made in the various fields of law. That will give them more opportunity, that will give them more motivation to work hard and to excel every year in their respective field of law. Another essence of giving him the award, which I should congratulate the business world, it generates competitiveness, because those who are maybe second in the rank or those who could not excel themselves for the award due to various reasons, may not be attributed to them, various reasons. There's an element of competitiveness. Next year, definitely they will excel themselves. They will work hard in their respective field of law so that they can achieve these type of awards every year. So these are the very essence of the giving the award. It is not just giving just to give an award every year. It has got a motive, it has got a purpose to achieve. I'm sure this will motivate the young minds in their respective fields of law. Now we have about, you must be knowing that we have about 23 national law schools in this country and more than 1,371 law colleges in India. So a large number of students are passing out of this law college. In fact, I understand in the year 2011, the Bar Council of India has decided or recommended to the government to impose a moratorium for 3 years so that no new law college be opened in the country. Because they do not know, because those who are passing up to the law college, especially then young law students, after passing out, they do not know which field they must choose. Now you are very well aware. Now there is about 60 to 70,000 law graduates. They are joining in the profession every year. They have to be accommodated somewhere. They may go, if they have got a godfather, if their father, uncle, somebody in the profession, they can just walk into that law firm. If it's a very established law firm, there's no difficulty. But there are freshers who have nobody to support. And I am happy to note that many of the law firms in this country definitely look for talent. And if a young mind shows in their law college or outside, excel in a particular field, we have law firms in the country, they absorb them, even if they are not godfathers or theirs. In my experience, I find many of the students who have come out from the various national law schools and other schools have get openings in various law firms in the country. So they are giving a great service to the legal fraternity by giving them appointment in their law firms, and ultimately they may be made partners also. That is a great opportunity for law students. All the same, don't think that this is the only opportunity for those students who pass out of the law, from the law college. There are a lot of other opportunities also, not as a practicing lawyer. Of course, everybody focused on practicing lawyer because that was the mindset when we started practice. The only avenue was go to our office, then go to the court. There's no other. That's the only way a lawyer is looked up on. Now it is not so. There's a lot of areas on which we can concentrate. In the legal firm, of course, the legal firm, many lawyers never appear in the court. Those who have the inclination, those who have the motivation, of course, they may appear in the court. And all lawyers may not be a success in a court of law. We know one of the great speakers, I'm not naming him, he was a big parliamentarian, he was a lawyer he was practicing as a lawyer. He was a great speaker, but he was a poor advocate. And I was wondering, we used to discuss always with my friends, see, why this man? He spoke so with all his ability in a political platform. But when you come to court, it's a different ballgame. So if you put some questions to him, he won't be able to answer. From my experience, I say I'm not casting any aspersion for the last 25 years as a judge, and after that also. So whenever a important, controversial, or sensitive issues comes, the law and technology, because we are in the Supreme Court, a lot of issues come with which we do not know, because we are not studied at the law college, or as a lawyer, we do not have been dealt with those subjects, because these are new emerging fields, new fields of law, which many of the lawyers may not be knowing due to various reasons. So whenever a very important law which has got some technical base. When you put answers to some senior lawyers in the High Court or even the Supreme Court, they fumble. Either they may seek an adjournment, get it adjourned for studying the subject. Well and good, I'm not finding fault with it. Or sometimes they may look at either side to their juniors. That is a role that juniors has to play. Because many of the law students who come out of the college, they have got a lot of area for specialization. Even after coming out of the law college, when you get into a good legal firm, you get a lot of opportunities. You get a lot of opportunities studying technology and law. So when controversial issues come, for example, recently one matter came to the Supreme Court, that is a blockchain technology. I did not know what is blockchain technology because I started reading some materials to understand what it is. Now, when that case comes, naturally the judge did not know because the judge has not studied that subject. It's a new emerging field, nobody knows it. But suppose a young lawyer who has concentrated on that particular field is available to the court and it is known to be well versed in the particular branch of law, necessarily the entire court or even the lawyers sitting there will look upon him. So I used to advise all the young lawyers, don't think of clients. Clients will come and clients will go. Clients may not come. That is a different matter. As a professional, as a lawyer, first you must study your subject. But many a times we find lawyers study only when the client comes. That shall not be the attitude. If the client comes with a brief, he discusses with the client, then he studies the subject. They will ask the client to come after 1 week or 2 weeks. By the time you go through the file, by the time you may look at the law, and then you advise the lawyer. That cannot be the approach now. Probably that was the approach in the olden times. But now I would advocate to all the young minds, all the young lawyers, to concentrate on a subject of which you have some interest. How you will find out the subject of interest? Probably your peers may help you. Your law professors will help you to find out the subject on which you have some interest. You study the subject well, because now law and technology is so intertwined, because you cannot separate both. That's a law now. You take any law, it is so connected with the technology. So you study the subject well. If you study the subject, even if there's no client, your knowledge will spread your knowledge among your friends, among your seniors, and among the legal fraternity. Slowly, clients will come to you because you know you're a master of the subject, unlike a general practitioner. So that is one of the aspects I would like to highlight to the young lawyers. Now there's an article. It's actually a blog of the American Bar Association, somewhere in around 2000. They asked what are the new emerging practice areas in the foreseeable future. So they said, what are the new practice areas that solo, small, and medium firms should prepare for the next 5 to 10 years? So young lawyers should look forward. What is going to be the new emerging fields of law which they have to handle in another couple of years, 5 to 10 years? So law firms need to start building up an expertise around visibility and variability of data collected by small technology. You know, in America, you find, say, every household or every office, slowly they're building up. Every office and household is now controlled by technology, Alexa, or some other technology, because even for when opening a door, we can just give a command, it will be opened. So everything has been technology based. So that it involves a technology of voice activated technology. So what is voice activated technology? You must study that. So that is one of the emerging fields that is going to come in the near future. Lawyers will have to repeat it and then one more thing I like to highlight. That is, that is often a doubt has been used. I used to put it to me many law freshers. Sir, how will you excel? But we don't have any clients. One law firm told me that I got 8 clients. Well, good. That's good enough. Start with 5 clients. Start with 10 clients. Not difficulty. That's how you excel. But don't think that you will get 100 clients all in a sudden. So that's what they say. One of the greatest Dutch painter is well said, as he has said. See, success will not come overnight. Great things are not done by impulse, but by a series of small things brought together. That is said by Vincent van Gogh, one of the greatest Dutch painter. That means, see, you start practice with the five clients. This is for the young minds, young lawyers. That is good enough. But do justice to these 5 clients. Then overnight, within 1 or 2 years, you will have 10 clients, then you'll have 20 clients, you'll have 30 clients, it will go on. So start and make a small step. That's why they say great things are not done by impulse. That means 100, we are not going to get 100 clients overnight. But by a series of small things brought together, you will achieve success. So that is one of the secrets, I would say, that I would like to share with the young lawyers. Now, unlike when we had our in law college, basic thing only, we study property law, we have studied contract law, we are inclined in, we have studied criminal law, that's all. There is not much subject. Some specialized in the last year for taxation or for administrative law and an ordinary dispute resolution also. Now, when I was going through the, when the jury was judging the performance of the various law firms as well as the lawyers, we find a lot of new emerging fields, and for which award has been constituted also, award has been awarded also. For example, investment law. There are few firms who concentrate on investment law. So young lawyers who must concentrate that particular field, what it is. Then restructuring and insolvency law. That is also a good field for young lawyers. Then real estate law, after the new legislation on real estate, you can consider real estate law. Then policy law, because policy is being changed every now and then by the government due to various reasons, and due to that they need policy makers. They should be properly advised. Then merger and acquisition. Then intellectual property, of course, it is there in the field for a number of years now. Then insurance law. Then environmental law. Environmental law is a very, very emerging field. And then ADR, of course, many of them know that. And competition law, capital market, the tax, technology, media law, and so on, energy law, sports law, and fields are plenty. Don't think that there are no place for the young lawyers. So fields are a large number of fields. Only thing you must specialize in a particular field. You can be, that doesn't mean that you shall not attend any other type of cases. Other type of cases also you can always attend. But at the same time, you must concentrate in a particular field so that slowly you become an expert of that field. So the base should be, of course, many of the legal firms in this country, and they take large number of lawyers, young lawyers. So suppose you excel in a particular field, naturally the senior most partner of that field necessarily will bang on you because you have studied that subject. So that's why you develop your knowledge in a particular subject. So don't be disheartened. And don't think that the only avenue for a law student to come into college is to go a legal firm or practice as a lawyer. There are a lot of other fields also. You can be a solicitor, or you can be an advisor, you can be a consultant, or you can be a law professor. That is the need of the hour. Because yesterday also we had I inaugurated one function of the Price College, the law college, Price College. So I was thinking this is the right time. You must update the knowledge of professors, law professors, and law teachers. Because just in the United States, suppose they have got any controversial issue or any constitutional issue, the first bank on the professors, not the lawyers. So the professors are exposed to the new vistas of knowledge. They know probably better than theoretically, and of course their practical knowledge may not be that much as a lawyer is concerned. But for advising, theoretically, their knowledge is boundless. So they always advise they are the constitutional experts. First, they bang on them. So just like in India also, I think it's high time you must update the knowledge of our law teachers and law professors, so that only they are properly equipped, then only they can properly teach their faculty, their students. Then that will update the student. They will generate interest in students in particular various fields of law. And this is some of the aspects I would like to advise young lawyers. And I don't think that in any court in this country always recognize juniors. don't be afraid when you are pitted against senior most lawyer in the country. Don't be against, because the judge always look at the how to. We have to just do justice to both the parties. The mere fact that junior is representing that will not going to affect your case. Of course, you must properly study, you must properly present, and you must know the facts, you must know the law also. So don't be afraid. Probably you may be better equipped than a senior lawyer, because you are the new generation lawyer. You have studied law in the law college. You are equipped in a particular subject. So on that aspect, probably you will have a better knowledge of the subject. Of course, face value differs. Experience also, we have to recognize experience of lawyers, the manner in which they present the case, that you must slowly you will educate yourself. So don't be disheartened. You have a lot of opportunity. And I must also really congratulate the business world for instituting these type of awards. That is a great motivation for the young minds, great motivation for young lawyers who are working in the law firms and individual lawyers also. Next time, I'm sure we will get more, we will have more recognition of better talents next year. So they must, element of competitiveness is already there. Next time, also new law firms will join in this in this program, and let us see when next time we judge, we will have better talents. So I must congratulate all the award winners, whether it is declared or not, I'm not sure, but we have judged and we have given our inputs, and ultimately they will be awarded the awards. So I must congratulate all the persons who have received the awards from Business World. I must also once again congratulate the Business World for instituting these awards. So thank you very much for your time. Thank you.
Thank you so much, Justice K.S.V. Radhakrishnan, and thank you for joining us today. Well, we'd also like to thank you, sir, for your valuable learnings from the treasure trove of your experiences today. Well, ladies and gentlemen, hope you all are spreading the word using our hashtag BWGLS. And moving on to the next dialogue for the day, we are going to be joined by Mr. K.D.S. Tulsi, Senior Advocate, MP, Rajya Sabha, Chhattisgarh. Well, he will enlighten us with a few words on the systematic digitization in the aftermath of COVID-19. Thank you so much, Mr. K.D.S. Tulsi, for joining us and giving us your valuable time. We'd now request you to please unmute yourself and put your video on. Thank you for joining us.
Well, thank you very much. I'm very grateful to the business world for inviting me to speak. And also,
Mr. Tulsi, if you could just have your video on, the video is not on right now.
The host isn't allowing it.
I think the problem is with the host is not allowing.
Okay. Sure. Just give us a moment to resolve that, Mr. Tulsi, because we'd love to have you on the screen. Yes, now we can see it. Thank you. Over to you.
Right. Thank you very much for inviting me, and very grateful for this opportunity. This is it is said that every problem is an opportunity. In the present case, it was that the problem of the world was an opportunity for the whole mankind. That was the kind of impact on pandemic, and the whole world seemed to have gone topsy-turvy. But how did the humans, deal with it and survive, not only survived, excelled in several fields? I'll be dealing with, apart from our lifestyles, I'll be dealing with the impact that it has had on judiciary, the impact on the healthcare sector, and the impact on real estate. This is how I'm dividing the issues that I'm dealing with. Suddenly, all of a sudden, one day we woke up and we realized that the books were too slow. They were not giving us the instant information. What has happened? What has gone wrong? And suddenly we discovered that books are quiet. So what did we do? Internet all of a sudden became much faster. Everybody was going for it, and it became much louder. So the two instant impacts were reversed by mankind. John Donne, a poet, says that no man is an island. Every man is a piece of a continent, a part of the main, until one day we are all locked down. That's what happened. And socially distant. Suddenly, we were all islands. All continents connected through the World Wide Web. One has never felt closer to people. All you need to do is to click a button and you can reach your friend. But at this hour, you can make a friend. But at the same time, one is more distanced from the world, the only access being through a computer screen. The relationships are changing. The manner in which we socialize is changing. The change is visible here and now. There is huge increase in streaming and lockdown to work from home. Two big changes, which are going to have impact for decades to come, or centuries to come, which was also captured by data demand. The data demand rose as compared to the commercial areas. Millions of people went online for the internet and more. Total internet hits have surged between 50% to 70% according to the statistics of March 2020. Lockdown boosted data demand. India's data consumption over the top streaming services surged to 947% between March to July of 2020. According to Frankfurt-based internet exchange, the data consumption and OTT streaming and video on demand rose by 249% between March and April as against February of 2020. How did it hit the lawyers or judiciary? As a lawyer, it turned our world upside down. It took away our black gowns. It took away the arguments in open court. And also the time that we spent traveling to and fro from the courts. Suddenly we became very lonely. But then there was a way out. The International Court of Justice allowed proceedings to continue through video conferencing. It was said that it was balancing the right of health of judges and also those involved in the court proceedings with the fundamental role of the judiciary in securing access to justice, legal protection of human rights, and the rule of law. Pandemic led to closure of courts. Only urgent matters could be entertained, a final argument in criminal appeal, or delivering a reserved judgment in such appeals would hardly qualify as emergency. What does this mean for a person in jail? He or she can continue in jail as the case is not urgent. And this and many more dilemmas continue to engulf, except that in this case, the courts intervened and ensured that the courts were not overcrowded and those who were under trials were ordered to be released on their personal bond. From struggling to find space to stand within the courts, we were struggling to click on links and arguing our cause for justice from behind a computer screen and also on a seminar like this on law and justice. Though through new VC apps, Cisco, WebEx, and Zoom, etc., we discovered new world. From filing documents physically to now sending an email to the courtmaster with all the files. What happened to education? Children had a reason not to go to school, but they missed friends, and suddenly schools reduced itself to classes and homework and examination. The tiny respite of tiffin time, of course, was missed. Globally, over 1.2 billion children were out of classrooms. Distinctive rise in e-learning, where teaching work took place remotely on digital platforms. In Denmark, children up to the age of 11 were returning to nurseries and school after initially closing down on 12th March. But in South Korea, students were responding to roll calls from teachers online. India e-tech company Byju, a Bangalore-based educational technology and online tutoring firm, has seen a 200% increase in the number of new students. One hand, unplanned. On the other hand, rapid move on to online learning with no training, insufficient bandwidth, little preparation, with the result that the poor use of experience that is unproductive to sustain growth and unconducive. On the other hand, integration of technology into an experience of education will provoke conventional classroom to move beyond the emphasis on rote learning to a more realistic, practical, and all-round learning experience. Coronavirus visa uncertainly tuned against foreign Chinese students. Pandemic affected racial prejudice. What happened to the hospitals and health sector? COVID-19, rapid admissions into hospitals, number of patients in ICU rises, supplies are low, ICU are near full capacity, not full capacity. St. James Hospital in London, one of the best in the world, saw patients lying in the corridor on the floor. Some are conscious, some unconscious, some dead. The world was on the brink of catastrophic moral failure in the distribution of vaccines. Once the WHO, 29 deaths in Norway after getting vaccinated. India, 580 adverse reaction and 2 deaths based on day 3 of vaccination. Matt Hancock, Health Secretary of United Kingdom, says that someone is admitted to a hospital every 30 seconds for coronavirus. Global medical staff shortage. Indian doctors went on strike in protest against long, undulated working hours and inadequacies of the India's health infrastructure. Iraq faced doctors shortage too, because about 20,000 doctors fled Iraq in the recent years over threats and targeted killings. South Korea, doctors turned furious and decided to go on strike. US healthcare workers demanded strike action to address understaffing and low pay as the pandemic deepened. What did it do to real estate? According to Knight Frank, India, second quarter of 2020 was perhaps the worst hit due to COVID-19. Office realty saw a substantial decline of 27% to 17.3% in 2020 with NCR and Pune witnessing the sharp fall of 86% and 87% respectively. Office leasing dropped by 37% in the year on a year-on-year basis to 17.2%. According to NAROC, home sales across top 7 cities decreased by 49%. Sales in 2020 were down to 81%. Surges by Regus post-corona financially scarred companies resorted to seeking smaller and flexible office spaces to save on costs. Besides eliminating the substantial real estate costs as rent, electricity, and facility management. Work from home was aiding companies to cut down transportation costs of the employees. This allowed the employees to find houses farther away from the office location. Collier's international report, office vacancy rates have risen and rents in Silicon Valley have sagged. In India, NBFCs still facing liquidity crunch. The government says possibility of creating more schemes like 25,000 crore, a special window for affordable and mid-income housing to ensure expeditious completion of all stalled and stressed projects. The government should consider extending the credit-linked subsidy scheme for middle-class and middle-income groups, under which the upfront interest subsidy of 2.7 lakh is provided to first-time home buyers beyond March 31, 2021. Thank you.
Thank you so much, Mr. K.D.S. Tulsi, for joining us and giving us your valuable time today. We definitely learned a lot on the systematic digitization in the aftermath of COVID-19. Thank you once again.
Thank you.
So ladies and gentlemen, taking the conference forward, I am delighted to welcome our next speaker for the day. We've got joining us is Ms. Geeta Luthra, the Senior Advocate, Vice President, Indian Council of Arbitration, SICI, and she'll be speaking on a very important issue that we need to address when reportedly a woman is sexually harassed every 12 minutes in the country. Well, let's learn from her on sexual harassment and what we need to know about it. Thank you so much, Ms. Geeta Luthra, for joining us and giving us your valuable time today. With this, I'd now like to invite you to join us on the stage and screen. Over to you, Ms. Luthra. Ms. Luthra, if I could request you to please unmute yourself and put your video button on. So, ladies and gentlemen, it is all happening at the BW Legal World Presents this wonderful summit and awards today, and we're going to be shortly joined by Ms. Geeta Luthra, who's going to be talking on a very integral topic for today. And ladies and gentlemen, also I would like to once again remind everyone on our hashtag BWGLS. Thank you so much, Ms. Luthra, for joining us and giving us your valuable time and being a part of this incredible summit today. I'd now request you to please unmute yourself. What a wonderful day, and you're looking brilliant. Thank you, ma'am, for joining us. Over to you.
Thank you. Thank you for having me. I've been having the pleasure to hear a number of the speakers before me, including Justice Radhakrishnan and Mr. Tulsi. And it's a beautiful learning experience to listen to friends and to listen to other colleagues, to listen to seniors, and to imbibe even a small percent of what they would be saying. Even if we imbibe 10, 20%, that's a lot.
Absolutely.
I want to start this by first thanking the BW team and the beautiful manner in which everyone has conducted the entire program. as well as the jury meet, as well as the awards. Extremely transparent and well done. And I think they thought of every possible category. I can only praise them and say that this is the encouragement and also the recognition that we as lawyers can say that is something which goads us to do better and better. And that's why I feel that an award of the nature of the BW Awards is a recognition of one's capability, and competence, and also an encouragement to young people who are setting out, who have done small startups, who are putting their feet and starting their profession. I can only appreciate what has been started by BW Awards. I was thinking of talking a bit about sexual harassment and slightly about the privacy judgment, if there is time. And what I wanted to say was that, let me start with a quote. You can tell, Jawaharlal Nehru, you can tell the condition of a nation by looking at the status of its women. While a murder destroys the physical frame of the victim, sexual harassment degrades and defiles the soul of a helpless woman. Let's look at what law there has been and what redressal mechanism there has been in India and in the world for sexual harassment at the workplace. And I want to correlate this, even though it is not totally connected, with the role of media in being very circumspect, in being very careful in the context of all reporting of all judicial proceedings or proceedings even outside the court, and refer perhaps to the Mumbai judgment, which is a recent judgment of the Mumbai High Court, where the court has come down strongly on saying that reporting by media, even if it is investigative, the duty that devolves on the media is to inform the investigative agency and not to run a parallel trial. So first, about sexual harassment at the workplace. Although there were always criminal laws with regard to redressal of sexual harassment, and therefore those criminal laws took into account sexual harassment at the workplace. But the more important aspect was, did we have sufficient laws, and did we need a special law in order to emphasize sexual harassment at the workplace? Now, the CEDAW Convention, in fact, which was an international convention in China, was what emphasized the elimination of discrimination against women. Pursuant to that, in India, and there were many cases even before that, which were in the general domain and which had been filed under misconduct rules or other rules. The Supreme Court came with a Vishaka judgment in 1996, which was reported in 1997. Now, this judgment basically said that every workplace should have a committee, which is an internal complaints committee, where there could be complaints of sexual harassment. There should be availability of a manner in which a complaint could be filed. That sexual harassment committee should be a committee already existing in space, so that if a complaint was filed, the same could be referred to a pre-existing standing committee where the complaint could go for redressal. So sexual harassment then, in view of the Supreme Court recognizing international law and recognizing the CEDAW Convention, said, let's bring this as part of the law of India, and a Supreme Court judgment to this effect by Justice J.S. Verma and by Justice Kirpal actually recognized the requirement of giving importance to sexual harassment at the workplace. After that, over many years, this Parliament brought in a bill in 2012, which became an enactment in 2013. Now, this enactment has far-reaching consequences. It is not only in the organized sector, it is in the unorganized sector. It again re-emphasizes what Supreme Court said in 1996, that there should be an internal complaints committee in every college, in every institution, in every school. And particularly, you noted in schools, colleges, and such institutions that there was danger of sexual harassment. Now, the most important aspect is the workplace should not be hostile. The workplace should be a free environment. At the same time, we have to give importance to due process. What the law recognizes under the Sexual Harassment Act is that within 3 months of the last incident, a complaint should be filed. That complaint has to be decided within 90 days. Now, very interesting, there have been cases that I have done where the principal of the institute himself formed a committee and, in a sense, had his junior colleagues decide with regard to a complaint of sexual harassment by a student. This was in Delhi. And as a result, because the case got so much, was taken up by the then Chief Minister, Mrs. Sheila Dikshit, given due importance, National Commission for Women formed a committee and gave its report. Now, the National Commission of Women's Committee could not be the statutory committee, but there is now a provision that there can be a local complaints committee and that the committee should be senior or superior to the employer or the senior most person in case the complaint is against him. What's important is due process, that a complaint should be within a period, a reasonable period. It should be with limitation, that while adjudicating the complaint, the person who has been an aggrieved person should not have to be answerable to the superior against whom she has filed a complaint. So she can move for transfer, or she can ask for that person to be transferred. There will be cases that you would know where someone has been asked to go on leave while the complaint is being adjudicated. But adjudication is a must. No one should be condemned unheard. There cannot be naming and shaming of people. There cannot be something which is said which is beyond limitation. And that's where the role of the media comes. The role of the media is that they have to be very careful that they do not go beyond the realm of what is due process and what is fair and what is just. In this regard, there is a Professor Ogletree, Harvard law professor, and there have been many persons who have spoken of it, who say that there is what may be a low value speech and a high value speech. And then in the context of O.J. Simpson, which became a media trial and a trial within a trial, he says that you have to be careful that the First Amendment does not get embarrassed. And that is putting it in very mild language. Lord Denning in the context, and I think Lord Diplock of the House of Lords, comment on this aspect where media starts reporting and goes beyond its realm in a case which is sub judice, have said that you may feel and say that judges are impervious to newspaper reporting, but then you are not remembering the frailty of the human mind. In the same context, the Delhi High Court in Nirbhay's case also said, when there was a film called India's Daughter, that we cannot permit such a film to be telecast while the matter is sub judice. Same context, the Supreme Court, by judgment of none other than Justice Lodha, Justice Nariman, and Justice Kurian Joseph in Piyush CL versus State of Maharashtra, have said that we cannot be reporting beyond pure reporting, lest once a matter is sub judice, lest a court be prejudiced. And we have to be careful that this newspaper or this publication does not affect the minds of people. After all, we have to recognize that judges are also human beings. And therefore, if you continuously read something, then it should not be that a person is named or shamed and something goes beyond the realm of reasonable and due process, which is the right of liberty, the right of due process, the principles of natural justice for any trial. Now, coming back to the issue of sexual harassment at the workplace. It is the courts have looked at sexual harassment at the workplace and the various provisions of the enactment and have interpreted it extremely widely to take workplace as being anything in connection with your work, even if you are not within the actual parameters of the place. And today, with work at home, work from home, you cannot be saying workplace means only the physical place. So workplace means if you're going on an office visit, you're going to an office site, all this becomes part of workplace. Now, importantly, while the definition, including organized, unorganized sector, including protection of women who make complaints, including various aspects, the fact is we also have to be careful of what may be incorrect or false complaints. I have seen in my own experience complaints being filed when an employee is working inefficiently and is given a show cause. She may file a complaint. Now, the statistics in this are that there may be 6% of men or 5% of men who may be actually harassed in the workplace. But the vast majority, particularly in the context of India, would be women who are harassed in the workplace. For example, there is a US judgment which says there were sexually colored posters put up in the shipyard where the aggrieved was an employee. Is that sexual harassment in the workplace? Of course it is. Making sexually colored remarks is a thing. So it has to be verbal, it may be physical, but it has to be. So there is one judgment which says a solitary incident cannot form a ground of a complaint because it may be an incident. There is another case where an employer made imputations where again in the context of teaching and lectures, one senior person made a complaint against or made a statement against one of the teachers, and she made a further complaint, was Anil something, and made a complaint saying that he was making sexually colored statements. And the court said, no, this statement, if somebody is castigating a junior employee, even if she's female, if it is not gender sensitive, if it is not attacking a person as a gender and is a gender neutral statement, just because the person is a woman, she cannot say that it is offensive to her and it would not constitute sexual harassment in the workplace. So the question that we have to address is that there should be an extremely safe environment for women. There should be availability for women to be able to seek redressal. That redressal should be swift and should be quick. It is dehors a criminal case that the person may file. It is dehors any other action that she may take. But that environment, the workplace has to, with more and more women coming in the workplace, it has to be secured and assured that women can work their best. And for them to work their best, the atmosphere should not be hostile, should not be something which is so inimical to them that they cannot function. Now, in this context, we have to look at the fact that today there are many platforms which are online platforms, and there is sexual harassment even in online platforms, which has become a real danger. The other aspect we have to look at is the fact of social media, the role of social media, and the fact that social media availability of Facebook, Twitter, Instagram can result in sexual harassment. Now, it can be sexual harassment in the school, it can be by your colleagues, it can be sexual harassment by the seniors, it can be sexual harassment by those who are in a superior position than you, who are in a controlling position. But the fact is that this may be through social media, it may be through normal media, it may be verbal, it may be physical. All of them, fortunately, in today's date and time, have a means of redressal. Concomitant with this is Puthuswami's judgment, which I believe would, where a person has a right to their private space. And because a person has a right to a private space, that right of privacy also needs to be protected, not only for women, but also for men. So let's look at the way forward where we as responsible people, as responsible citizens, say, make whatever we say has to be with a sense of a duty of care and caution. Thank you so much.
Thank you so much, Ms. Luthra, and thank you so much for giving us your valuable time and letting us know about our rights and empowering us with the knowledge of the same. Thank you so much. Ladies and gentlemen, hope you all are spreading the word using the hashtag BWGLS. And well, the insights are truly getting better and better with each keynote. Where else will you find such visionary speakers on one common platform? Well, ladies and gentlemen, with this, I would now like to present before you a renowned senior advocate, Mr. Neeraj Kishan Kaul, Senior Advocate, Supreme Court of India, for his dialogue on tribunalization of justice encroachment by the executive. Thank you so much, Mr. Neeraj Kaul, for joining us and giving us your valuable time today. And we're really looking forward to your session. Ladies and gentlemen, it is now time to bring him on the stage and screen. Over to you.
I must thank the team of BW Summit, who've organized such a splendid summit where, you know, as member of the jury, one had the opportunity to see what a wide pool of talent you have got together, not just established law firms, but young first-generation lawyers, startups, first-time generation startups, and what remarkable work they're all doing, from space law, aeronautical law, to, of course, the established fields of law that we were all aware of. Very heartening and very reassuring to see that the legal profession is in very safe hands of very diligent young generation taking it forward. Now, coming to my my topic of discussion for today, which is tribunalization of justice and encroachment by the executive. Let me begin by saying that quoting Justice Jaisamma Babu in a 2004 judgment in Gandhi R versus Union of India, where he said he was apprehensive that the growing tribunalization of justice in the country will ultimately lead to tribunalization of justice. And Article 50 of the Constitution of India, which deals with the separation of judiciary from executive, categorically states that the state shall take steps to separate the judiciary from the executive in public services of the state. Now, despite this categorical provision provided in the Constitution, there have been repeated attempts by the executive in this country to encroach upon areas which were solely earmarked for the judiciary. And the 14th report of the Law Commission, which did recommend setting up of the tribunals, even that was conscious and stated that it was, and they said that though tribunals were needed, they were only meant to supplement, not supplant the judicial system. The traditional courts had to exist. Now, really, the justifications given from bringing in the tribunals were, one, the heavy clogging and cases in the courts. Secondly, with specialized socio-economic legislations coming, they needed experts to be brought on board, and those are broadly the justifications given. But really, what changed and tilted the balance, or what started weighing with the executive, was that during the 70s, there was an attempt felt that maybe courts were acquiring a certain degree of power which they ought not to exercise. And the balancing of power between the judiciary and the parliament was something which was conceived by the and perceived by the contemporary governments of the time to be tipping in favor of the judiciary. And thus started this whole talk of more tribunals, and the Swaran Singh committee coming in, talking about the exclusion of all courts with respect to tribunals, except for the jurisdiction of the Supreme Court under Article 136 of the Constitution. And this then led to this led to the 42nd Amendment to the Constitution in 1976, which brought in 323A and 323B. Now, these were provisions which really dealt with the conditions of service of union and states and the employees. That was really the starting point. And they came up for consideration. And of course, the justification was arrears of cases in courts, etc., etc. And they came up for consideration in Sampath Kumar versus Union of India, where the Supreme Court upheld these alternative institutional mechanisms. And personally, I thought it was a great opportunity lost, but thankfully after that came the testing of the 42nd Amendment in 1993 in the case of Sakinala Harinath, the state of Andhra Pradesh, which ultimately reached the Supreme Court. And the 7 judges of the Supreme Court and L. Chandra Kumar were asked to decide many important questions, including 2. The first one being whether the provisions of 323A and 323B, allowing for ouster of the entire jurisdiction of the all courts except the Supreme Court, ran counter to the High Court's and the Supreme Court's inviolable powers of judicial review under Article 226 and 32. And secondly, whether the tribunals being effective substitutes to the High Court's jurisdiction possess sufficient competence to invalidate statutory provisions. Now, the Apex Court really in these matters said that as far as 226 and 32 are concerned, these are basic structures, part of the basic structure of the Constitution. And thus there was no question of these powers being curtailed. And it concluded and said that the powers were not only part of the basic structure, the only leeway that we could give was that the tribunals could be there to supplement, not supplant the courts. So thus the courts, though, upheld the basic structure, said you can't oust the jurisdiction of the courts, but paved the way for transition of tribunals coming up as alternative judicial mechanisms. Though in Chandra Kumar, I must point out, and I quote, the court very categorically said, and I quote, the tribunals are competent to hear matters where the vires of statutory provisions are questioned. However, in discharging this duty, they cannot act as substitutes for the High Court and Supreme Court, which have under our constitutional setup been specifically entrusted with such an obligation. Their function in this respect is only to supplementary, and all such decisions of the tribunal will be subject to scrutiny before the division bench of the respective high courts. Now, L. Chandra Kumar, though upheld it as the basic structure, yet, as I said, had paved the way for tribunalization, which had started earlier from Sampath Kumar's time. Now, the attempts did not remain there. Then, in various judgments, what started as initially ouster of judicial review, now increasingly, the nature and the terms of appointment of members were such that their independence could be compromised on the very nature and terms of their appointment. And that's where, and that's what I'll repeatedly come through as the common thread of this brief talk of mine, that in various forms, the executive from time to time has attempted to bring in the executive, bring in the bureaucrats, and encroach upon judicial functions. So how would you appoint officers who were not part of the judiciary? Would there be an independent process? Came up for consideration. And the Constitution Bench of the Supreme Court in R. Gandhi laid down in great details while dealing with the Companies Act, the requirements of a chairperson of the NCLT, who should be a technical member. There need not be a technical member every time. What will be their terms of appointment, remuneration? The emphasis being the terms of office, service conditions should be as independent as possible. Otherwise, where is the independence of adjudication if the executive is to fill these tribunals with their own people, hugely compromising on the independence of judicial functions. So R. Gandhi was a major step. Then came another Supreme Court judgment in Madras Bar Association versus Union of India, where the Supreme Court dealt with the National Tax Tribunal case. And again, there categorically held that members of the tribunal should be appointed in the same manner and should be entitled to the same security of tenure as judges of the court sought to be substituted. And the court affirmed the position of law laid down in Chandrakumar and R. Gandhi that appointment of technical members is restricted to cases where technical expertise is essential for adjudication and is impermissible in any other case. But despite all this, one would have thought that the executive would not now make any further attempts. But then, with great respect, the executive is incorrigible at times, and further attempts came to be made. And after all these judgments, ultimately, then came the Roger Matthew judgments, etc., again emphasizing how the executive refuses again and again to follow the diktat of the courts, and in some circuitous way or the other, attempts to take on functions never meant for that. And here I want to quote Justice Rumapal, who in a scathing review, and also the decisions of the Supreme Court and the High Court, said that in a Kalidas-like action of cutting the branch of the constitutional tree on which the judiciary is sitting, courts had permitted tribunalization of justice in this country. And she went on to say, and I quote, "Why or indeed how, having regard to the principles of separation of powers, can the power of adjudication be shared with me or transferred to be subjected to the control of the executive, which is what tribunalization has come to mean in this country." And she also said that if delay of arrears of cases and specialized knowledge have been usually cited as the reason, if the work of judiciary is being hampered because of litigation explosion, the Constitution envisages appointment of more judges. You can bring in technical members for evidence, but why create tribunals as post-retirement jobs for bureaucrats under the rules of socio-economic legislations and backlogs, and bring in and take away a jurisdiction meant for the courts? If you want, there's an explosion, have more judges, have more courts, call the technical members as experts therein. And the history of tribunals in this country have shown backlogs of an extreme nature. So the best answer was to create more courts, more judges. And look at the expert evidence. And very interestingly, she observed that suppose a tax matter comes up and former Secretary of Finance is sitting in the Supreme Court, what level of independence will you expect from a court in that case? Now, those are the nature of crucial issues which come up. A constitution which envisaged a complete separation as far as functions are concerned has actually in the process over the years, by repeated onslaughts, gradually diluted the separation of powers that was envisaged under our constitution. And I end by, and I know there's restricted time, I'll end by just quoting from two quotes which are very apt for this subject. And one is by Alexander Hamilton in his famous Federalist paper, and where he said, "There is no liberty if the power of judging be not separated from the legislative and executive powers." And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. That was the ethos, that was the philosophy behind the Constitution. And every justification today being given for tribunalization, be that be socio-economic legislation, the experts required, explosion of dockets, clogging of courts, can be sorted within the legal frameworks of the courts. More courts, more judges, experts being called for evidence when required, but handing over functions entirely meant for the judiciary to the executive, or tribunals controlled by the executive, or where the executive has a major role in the appointment, is something which I think we seriously need to look at. And that is not something which the framers of the Constitution ever envisaged. Thank you very much for inviting me for this summit.
Thank you so much. Thank you so much, Mr. Neeraj Kishan Kaul, Senior Advocate, Supreme Court of India, for your dialogue on tribunalization of justice encroachment by the executive. Well, ladies and gentlemen, now we have a message from our Chairman and Editor-in-Chief, BW Legal World, BW Business World, and Exchange for Media Group, Dr. Anurag Batra. Over to you, Dr. Batra.
Hi, good morning. It's a special morning, Saturday, 23rd Jan 2021. I welcome you on behalf of BW Legal World, which is the legal community for BW Business World. We're about the business of legal. We're about the intersection of legal and business. This year is the second edition of the BW Legal World Global Legal Leaders Summit. We have an eminent line of speakers, jurists who have really been part of landmark and iconic judgments, who are leaders of the Indian judicial system, are speaking today. When you hear them, you'll be wise. You'll know that they are still very updated with what's happening, and with their background and perspective, they're able to give us knowledge, insights, and wisdom, which all of us can use to be better professionals. In the evening is the second edition of the BW Legal World Awards, Global Legal Leaders Summit and Awards. So the jury, led by former Chief Justice of India, Justice Deepak Mishra, and an eminent panel which comprised, Justice Sikri, Justice Radhakrishnan, so on and so forth. I can take every jury member's name, and you'll see them on the jury AV shortly, who spent 2 sittings to be able to come up to the winners. We have 36 winners tonight, and you.
Wow, what a brilliant day it is ahead planned for all of us. Well, ladies and gentlemen, now it is time to move on to the first panel discussion of the day. And what a great day this is turning out to be. So, well, ladies and gentlemen, now it is time to move on to our first panel discussion. And as you can see that we're going to be joined on the expert panel by our key panelists. The discussion is going to be on the rise of legal tech, leveraging power of AI to grow 10x. And we're going to be joined by our panelists. First up, Mr. Rajiv Chopra, MD Legal at Accenture India, Mr. Divakar Agarwal, Partner, Dubai Practices, Stephenson, Harwood, Mr. Himanshu Gupta, Founder, Lawyer, Ms. Puneet Bhasin, Founder, CyberGeo Legal Consulting, and the session chair of this panel discussion is going to be Mr. Kapil Chaudhary, Corporate Counsel, Autodesk, Tech Attorney, and a legal tech speaker. Thank you to all our eminent panelists for giving us your valuable time and being a part of this wonderful global legal Summit and Legal Leader Awards today. Thank you once again for joining us. I'd now like to pass on the live baton to our session chair to take it forward. Thank you.
Thank you, Bhavna. Thank you. Appreciate, and I think what a warm welcome. Really appreciate it. And the morning panels have been excellent. So looking forward to another great panel today. So first up, a quick introduction. My name is Kapil Chaudhary. I'll be your session chair for the day. It's a very eminent panel. I'm truly honored to have with me, if I can call them legal stalwarts, it'll be a misstatement, but truly amazing bunch of legal colleagues and seniors. The topic for the panel is extremely interesting, and if I can probably just let you know that all of the panelists are immensely capable and qualified to speak on this intricate subject. So we'll probably just delve quickly in, but for me to just quickly introduce the panel, the panel's topic is the rise of legal tech, leveraging power of AI to grow 10x. I thought I'll probably begin by just sharing with you a few key data points which I have with me here. I'm probably not being allowed to share my screen, but nevertheless, you'll probably see these slides as part of your presentation deck. So essentially, just setting the stage on legal tech, what's happening is, if you see, let's say the fintech sector, banks and financial institutions, from 1997 to where we are today, we've gone from internet banking, sign-on applications to what we call face detection technologies. So, let's say when you're using a Citibank or any of the banking's mobile applications, now they let you sign in simply via a face detection login. Whereas what's happened is, if you look at the legal sector, we've been kind of slow on the uptake. If you remember, we have the famous track changes feature, barring an upgrade into the Microsoft and the Windows versions, we still have pretty much the same track changes feature. So, we are kind of getting there. Also, a few data points for the audience, which are worth, which I came across, which was shared by a bunch of legal tech companies, is that last year over $18 billion was spent on legal tech products, and by 2025, this is expected to reach about $30 billion. The spend on legal technology and automation products. Last 18 months, with the pandemic, has really shown a very important imperative for all of us to quickly adopt technologies, because there has been more and more emphasis on doing more with less and coming across as adding real value to business. So the pandemic has kind of forced us all to adopt and adapt quickly. With that, I'll probably pause and quickly invite my first panelist, Mr. Rajiv Chopra. Rajiv is a dear colleague, a dear friend, as well as he leads the very eminent legal team at Accenture as MD Legal. So Rajiv, a very warm welcome to the panel. I really appreciate you being here, Rajiv. Rajiv, if I can quickly jump in, and from your perspective as one of the preeminent general counsels in India and this part of the world, Rajiv, can I first ask you? We're already seeing several disruptions in this new age of legal tech and artificial intelligence in the field of law. From your bird's eye view, what are the major challenges that you've seen corporates and especially in-house attorneys, which some of these challenges which we are continuing to face with the advent of AI, and also, with the virtual environment kind of becoming the norm, what are some of the barriers to adoption that you've seen coming our way? Over to you, Rajiv.
Okay, thank you, Kapil. Good to meet you after quite a while, actually. But thank you for inviting me to speak on this topic, and also appreciate that I have such a great panel. I look forward to hear views of others as well. So first up, I know, Kapil, you said that the spend on legal tech was in the range of 18 to 20 billion. my limited research on Google tells me that it was about 1.2 billion. So whatever number is true, as a comparison to the total legal market, which again, as per my search, is 800 billion, is a fraction of a percent, right? So, that itself tells you that, of course, there's a long way to go. But, again, it depends on whether these numbers are a true reflection of any reality. But the difference, nevertheless, is profound, right? 800 billion legal services market, or, fraction of that is spent on legal tech, right? Now, one thing we must keep in mind is that the field of law is very tradition bound and perhaps slow to adapt to technologies and tools, right? But however, that's changing. Who would have thought that even our courts will go online because of COVID, right? So to me, that itself was a pretty transformational thing that we saw in legal tech that happened, right? But then just wanted to note a few dynamics, and I'll come to answer all your questions, Kapil. The technological transformation expected to take place over the next 5 to 10 years is now being compressed because of Corona, right? And you will see proof of that as all the results of all the IT companies. You will see they've gained, a lot in revenue terms. So that means all IT companies are doing well, which is a reflection of the fact that the companies are investing a lot in IT, right? And this is just not about getting faster and cheaper, but it's also about maintaining productivity and minimizing business disruption, right? So it's not just a question of fast delivery. It is going to be transformational, right? The degree of maturity is moving from foundational to innovative. Now, you all know that we've kind of started investing in tools which are productivity enhancements, and journey has been ongoing. But again, to a large extent, the investments have been in foundational technology. So I think there is some degree of innovation and transformation that we still have to see in our industry. Then we'll have, obviously this also means new type of talent in legal field, right? So as we transform, as we digitize, there'll be techno lawyers tomorrow. God knows what kind of jobs will be out there for lawyers, tomorrow, right? It could be, lawyers could be data scientists, but it'll be interesting space to watch. And we all know that with remote working, more flexible working arrangements has only increased the use of technology, right? I also know that there are about, and this number depends on which website you visit, but there are definitely 700 legal startups, in legal tech startups rather, who've entered the market and belong to different domains: e-discovery, online legal services, lawyer search, research, whatnot, right? But one thing we must sort of pause and think about is that the top key legal priorities for technology are still very basic, right? So you'll see that contract management is still top of the agenda, followed by e-signature, document automation and management tools, various collaboration tools, legal research, knowledge management, record management, and so forth. But very less priority on still the analytics side of it, right? So I think the transformation is yet to happen completely. Now, coming to what as Accenture we've kind of done with adoption of technology, and then I'll come back to answer a specific question. Our threefold focus is always on how we can innovate for our people and our clients. How can automation help us to do more for less, like I suppose anybody else, and how can data lead to smarter decision making and risk management. Now, I'll just quote a couple of examples of how we've kind of leveraged technology for our legal team, which is largely anchored on robotic process automation and some bit of AI. So first is that we've leveraged some startups and we have developed an end-to-end solution for automatic lease contract abstraction for clients with the help of a partner called Voltage. And using the AI-based technology, data points, clauses are auto-abstracted with 90% accuracy and with about 80% template coverage. So this kind of solution can lead to about 40% saving in resource cost, 40% odd improvement in accuracy, and about 90% saving in time. We have experimented with bot very successfully. Our whole code of business ethics is based on a bot model where, which provides our people with an anonymous way to access information and resources that they need, helps them make good decisions every day, and helps us act with integrity. It takes out the it kind of takes out the technical realm and puts it into a human experience realm, right? So it's kind of interesting, and it is kind of, we've seen that there is a vast improvement because an employee is dealing with a bot, and therefore they're not afraid to ask questions which they might otherwise feel are silly, and that's helping us to sort of act with more integrity and progress our integrity and ethics agenda. And now my team, for instance, is also now using bots for our regular mundane tasks, right? And that's helping a lot, right? So there are many areas that we have completely sort of now bot enabled and saves us time, right? Of course, then at the elementary level, all of us use some sort of compliance tool, etc., right? Which helps us track and monitors our compliance requirements. And then I guess all of us are also invested in risk mitigation tools, be anti-money laundering or tools that are necessary because of the anti-corruption laws, right? So how do you track and monitor gift and entertainment, and how do you track business intermediaries, etc., right? So that's kind of the kind of spectrum of tech use in a nutshell that Accenture does, and there is a lot more. The investments are happening as we speak. So the contract extractions and ease of doing contracting is the next big thing on our agenda, which is being rolled out as we speak. Now, coming back to the barriers, right, Kapil. Now, one thing we have to remember is that there is a finite budget, right? And we have to speaking for a multinational company. Everyone has their own priority. So we have a priority at the local level, or we have a larger global priority. So it kind of depends on what priority is outweighing the other, and therefore, of course, you might want to adapt to various things, but there is a limitation out there, right? And of course, important thing is, unless it adds value, it is of no use, right? It's not just because it's cool to use, it doesn't mean anything, right? So you have to understand the business need and how the technology will help further that requirement. Obviously, you have to identify gaps and opportunities. So unless there is a gap, unless that there is an opportunity to fill that gap, I guess just technology for the sake of technology doesn't make sense, right? And of course, you have to have a feasibility and impact analysis done so that everyone is invested in bringing technology, right? Now, one anecdote I'd like to share is that and this is going to be my last point before I pause. Kapil, is that the evaluation process is also pretty long. I remember that we wanted to implement a very foundational compliance tool, and we had to scout the market. We saw various products which were available, and each product came with some glitch or the other. They were all fantastic products, by the way, but your information security has some problem with this tool because of this reason, and somebody else a problem with that for that reason. So by the time we evaluated the market, we were down 1.5 years of this exercise, and then finally we said, okay, chuck it. We're a tech company. We can build our own tool. So we sort of build our tool. So let's keep in mind that, while there is a lot of technology opportunity available, but how do you sort of seamlessly integrate that into your company systems is another choke point, which I think, depending on, from company to company, I guess we're all sort of grappling with. Kapil, I'll pause. I know maybe I should have, but hope I've answered your question.
Sure. Thank you, Rajiv. Fantastic. And in fact, that's a great segue for me to bring in Diwakar. So just a quick introduction for the audience and for our panelists. So Diwakar is a pretty well-known face in this part of the world. He's a corporate and commercial partner with the law firm of Stevenson Harwood, and he's got extensive experience in handling complex M&A, private equity, and venture capital transactions across Middle East, North Africa, and India. So truly a global lawyer, and very privileged to have you, Diwakar. So Diwakar, if I can quickly jump on to you and ask you, you sitting in your perch in Dubai, obviously getting a view of the entire Middle East, Africa market, as well as coming from a firm of the stature of Stevenson Harwood. Could you tell us and talk to our panel on and the audience on what has been your experience in terms of legal innovation? What is the kind of legal AI tech you are seeing available generally, and then kind of also round off and maybe crystal ball gaze and tell us what is the future holding out as we look forward to this year, and maybe also share some of the efficiencies or gains or ROIs you've seen firms such as yours capturing the true value of legal tech and automation. Over to you, Diwakar. Thank you.
Thank you very much, Kapil, for a very kind introduction. Lovely to be here, and thank you for the organizers as well. So I think Rajiv made a very good point that AI and technology is, it's ultimately a function of innovation. We as lawyers have benefited from innovation probably later in the day compared to the other industries, etc. But we have. And innovation is something which you need to look at not just from very fancy things, but even making something efficient on day-to-day tasks, has a benefit and contributes immensely. Just want to kind of keep that in mind. So it's a very wide kind of spectrum. I guess that's the main point. So in terms of our firm and lots of other firms as well, I mean, we actually have a very senior position called the head of innovation within the firm. There are other firms who've got that position as well, and we've had that position for the past at least 4 or 5 years. Now, that's saying something that, obviously this is an area which is being looked at very closely by firms. And of course, and it's a win-win in many respects because it's useful for the firm because it adds efficiency, it adds accuracy, it saves costs and time. It's very good for the clients because the clients want exactly the same thing. They want the efficiency. There's always cost pressures and budget pressures for clients. Now,
वो क्या प्रॉब्लम था?
नहीं एक्चुअली आपका जो मशीन है ना,
हाँ,
बहुत टाइम से उसको शट डाउन नहीं किया।
Oh, I thought we get some audio. Okay. Oh, back to
Apologies.
No, that's fine.
I think Mr. Advani, thank you. Over to you, Kapil.
So what we therefore have is a situation, so we have got this position, and we've been looking at innovation in terms of, and I'll talk about, in terms of the software and the levels of software, etc., which we've invested in, which we're using, as well as we've actually got, every year we pull together a team of associates, like an innovation pool who kind of, contribute into ideas, etc., which can work. And so it's not just a top-down kind of thing that, okay, this is software, please use it now. No, it's almost, people and practitioners across the firm, across the network who are contributing to say, okay, this is what might work, come up with ideas, etc. But that is what actually makes innovation really scalable and frankly usable. Because, we all know if something is top-down, it has one effect. But if it's kind of more kind of widespread, then I think that effect is actually multifold and exponential. So I think in terms of what we've seen is, there is the basic, I won't talk about, the basic functions of, time and billing, etc. That's, I think, there, and that's fairly, especially now, remote working, etc. I think that's almost a given in most environments just now. But on technology being used specifically, at the basic level, you have the kind of, I would say, slightly mechanical functions such as document automation. which is, you have programs like Contract Express and Hot Docs, which we use. And you also have systems like expert systems, which effectively it's like basic programming. So it gives you if-then algorithm. So you can take pretty much any situation where there is some clarity as to what is the outcome in certain situations, and you can draw up something like that, and put questions and you can get an answer. So it's just like a efficient way of analyzing certain fact situations, which is actually very helpful for areas which are relatively binary in nature, if you see what I mean. So, some compliance things, is this applicable? Do you fall into this? Yes, no. This is the situation. If it's yes, this is the situation, like a flow chart. So that is something which is actually very useful, because once you do that, you can save a lot of time. The clients can save a lot of time. You can actually put that on your website. You can kind of give some sort of, you can get some initial answers, or so you can get some initial pictures of certain situations. So those are very, very helpful. Now, and I think document automation also is extremely helpful, especially for documents which are heavy precedent oriented, relatively straightforward, and relatively, I would say, standardized in nature. So that is simpler contracts, which when you talk about volume, these are excellent ways to generate them, rather than having a bunch of lawyers kind of typing in parties' names and so on and so forth across 100 documents. You can make it much simpler by getting data, plugging it in, and then have that replicated. So parties' names which have to appear, let's say, in 4 places, can be done with pretty much the touch of a button. So those kind of things are definitely adding value, and we've seen the benefit of that. That can be rolled out in pretty much all our offices. So wherever areas we see where we see relatively standardized documents, I think clients will also love that, because we are actually able to be more competitive and still be profitable as a firm. The other aspect is, now we come towards the area of which is really the core of it, which is the true AI, artificial intelligence. What does it actually mean, and how does it actually work? I want to, being an M&A lawyer and a transaction lawyer, I want to maybe focus on a couple of examples, which is basically Luminance and Kira, which has been around for a few years now, but effectively it's being used as analysis tools and contract review tools. And I've kind of had a pretty detailed discussion with our team about this in terms of how it's been working and so on and so forth. And it's interesting, because what it does is it's able to read and analyze contracts, okay, and identify certain issues which you're looking for, based on the instructions which you feed in and based on the data which you feed in. Now, how it gets very interesting is basically you have a situation of let's take an example. You're doing a large due diligence exercise, and there are a bunch of standard form contracts. Let's say 100, 200, 300. What would they have normally done? Somebody would have to kind of go through them, or have a team of people kind of going through them, looking for certain, let's say, change of control clause, which is a classic example, or so on and so forth. And once you have that, now where the software will help you is based on the inputs which you gave. So so these software come on they're already pre-programmed to a particular extent. So they're already intelligent in that sense. Now, what makes it interesting is the more you use it, okay, the more intelligent it becomes. And when I say that, that's done through a training mode. It's not that, you can, it is ultimately, you have to bear in mind, ultimately it's garbage in, garbage out. It's still a machine. So what the inputs which you're given is, for example, you've seen that certain kind of contracts and certain kind of transactions are, these are the kind of variations, and this is what you see normally for change of control or any particular clause you're looking for. And then you put it in training mode and you train that. Okay. So with more and more that software being used, let's say within your organization, basically each and every person using it in training mode, of course, will be contributing to the efficiency of that software. I must emphasize it already comes pre-built at a very advanced level. So Luminance pretty much is very efficient because it's geared towards M&A transactions. Kira is more versatile and is able to use it for other things. So the point really being that you can actually increase your efficiency, but there's always a balance there, because it always comes with risk, because I as a lawyer am signing off, and the client is looking at the firm as, the firm is basically taking liability and signing off on something. Now, can you rely entirely on a machine or a press of a button to say that, okay, I've scanned, whatever 100 contracts, I've got a report and that's it, that's the end of my job? Well, it's a question, and I think the answer is we're not yet at that stage. I don't think we will ever really get to that stage, to be honest. But what our practical experience has been is that it certainly helps identifying certain documents, which you can then review. It makes things easier and more efficient. So to take a very practical example, you have to look at the, let's say, top 10 contracts. You would still go, you can run everything through this thing, but you will still go through those top 10 contracts on your own, manually, to make sure you get the comfort, etc., especially in the early days of deploying the software, because you don't have them. But where it can help is you can still get, so let's say your scope of work is, you have to look at the top 10 contracts, but there are, let's say, 90 other contracts, so less smaller value. And this is a real value add. What you can do is you can run those 90 without spending too much time, and something comes up, you can always pop it and point that out. And that's a value add, because while you're not supposed to do it, you're not really doing that and spending time on it, you can still add value to the client in that respect. So those are kind of key things. And I think our experience personally has been that sometimes, let's put it this way, you are relying on a bunch of, what would you have normally done? You're relying on a bunch of individuals who kind of review this, come up with certain things. There have been occasions, and I must say this, is that sometimes when using the software, they have actually caught up points which we would not have thought of while doing the manual review. So we've actually seen a real kind of value add coming in on that. So I think overall, if I were to kind of look at it, is that these are definitely, it's important how you use these tools. Okay, these tools are there. You have to bear in mind that they're not the driver. I don't think, I think lawyers will struggle to make them drivers, because that's actually against the interest if you look at it. But the reality is, these tools are helping us being more efficient and more competitive and more value add to clients. And that could be, and that's always good. The important thing is how you use them and how smartly you use them. And that's something which is kind of evolving as we speak, because every firm has its own experience about it. But I think many aspects, what I've mentioned here has been the experience of many global firms and Indian firms who have also started using these systems. It's there, it's useful. Let's put it this way: it's not a one-size-fits-all kind of situation, but there are certain areas where it can add tremendous efficiency and tremendous value. So you have to figure out and choose and correctly in terms of how you want to go about that. So I think that's probably one important aspect. The other aspect is, I think it's also used for e-disclosures. Now, I'm not a litigator, but I know for a fact the litigation team love it. So they've been using this a lot. It's very helpful for various things. To be honest, I don't know the exact details how it works, but it works. For identifying certain documents and so on and so forth, for looking certain things. It can be very, very helpful and less time consuming and very efficient. Now, in terms of future, they are, I was looking at a couple of articles and videos, is that, pretty much on a weekly basis, new AI tools are being developed. And when I say AI, on a generic basis, so you have tools, for example, I was seeing something very interesting. You actually say something, pretty much type out like a Google search, and or a certain trend, give me a trend for this, it'll generate, using Wikipedia and internet sources, it'll generate a kind of, you give the first 2-3 entries of your trend, it'll generate, the other, the balance 10, 15, 30 entries along the same trend, for example, based on, of course, available data. What I'm saying is, it's getting more and more interesting, and it is only a matter of time that the similar things or those kind of technologies will start finding their way and percolating into the legal industry. As I think Rajiv rightly said, is that the speed and the acceleration which we are seeing in the use of adoption of technology is unprecedented. I often say the lawyers were the last people to give up their Blackberries, or take Blackberries for that matter. But the reality is that's kind of changing now quite a bit. And we'll be in a position where, but ultimately, the value add really of the lawyer should ultimately it is our brain power, if you like, which is the value add. But I think with more and more technology and with more and more things, it's going to get more and more interesting. But the important thing, and therefore that's the important bit. that you need to maintain the balance so that you are able to use the technology rather than being ruled by the technology. I mean, I remember in my very early days with a very senior partner in Bombay in one of the large solicitor firms, he said, always it's good to use a precedent, but never become a slave to the precedent. So I think the same thing pretty much holds good here as well. So, just because something is there doesn't really mean it. You still have to kind of apply your mind and be intelligent in terms of how you use this technology.
Fantastic, Diwakar. Thank you so much. Very valuable views. So I know that we have 2 more speakers left, and we have about 12 minutes to round up. I'll quickly bring in Himanshu Gupta. Himanshu is a legal tech entrepreneur and a founder of several legal tech startups. It'll be great, Himanshu, to get your perspective on when we were discussing this panel. You did mention about platform companies, Swiggy, Zomato, Ola, Uber of the world. From somebody who's come in and actually ventured out into legal tech and given you a background, could you talk to the panel on what are some of the new emerging legal business models you've seen in this feature in this field, and where is India in that journey? Can we, for instance, tomorrow create a legal tech equivalent to an Uber, which we can call an Uber for legal tech, or an Amazon as a platform for legal tech? Over to you, Himanshu.
Hi, good afternoon, everybody. Thank you, Kapil. We've been talking about on a lot of aspects of use of legal tech into the industry. Well, I'm the only one who's not a lawyer in this panel, but certainly want to represent the legal tech startups in the country. You rightly said the Zomatos and Swiggies, they have simplified the essential need of having food to the users as they have focused only on providing the best service on the food and delivery. So likewise, I feel that AI and tech in the legal should help in awareness to the masses and provide the choice of legal remedies to the users. Let the legal professional focus on delivering the services rather than trying to work out the ways to get more clients or waste time on administrative tasks. So I feel that in high volume areas like contract management, e-discovery, legal tech is already standardizing and automating what were once the labor intensive tasks performed by lawyers at law firms. I think Diwakar and Rajiv have spoken a lot about how these legal tech or innovations is transforming and helping them in improving the productivity. However, there is another aspect to it. There was a recently published report which showed that lawyers are spending about 2.3 hours on billable tasks, which accounts for less than 30% of the 8-hour workday. Rest of the time they are spending on administrative tasks and attempting to retain clients. In such scenario, I think the advent of technology in practice management for lawyers seems less of a choice and it's more of a necessity. If we talk about more complex legal tech advancements relating to blockchain and AI, which is definitely going to disrupt the legal industry, the smart contracts, property and financial transactions, intellectual property registry, I feel that all of these are going to be powered by blockchain in the future. And the benefits of blockchain, I mean, I don't need to advocate about it. Everybody knew that this is the new buzzword in the industry, and is not just focused towards the using it as a currency. AI is also being adapted to create solutions which are hybrid of technology with traditional face-to-face lawyer-client connect. All this would vastly increase the efficiency of lawyers through predictive electronic discovery, intelligent legal research, and automated document preparations. I feel that if we have to get we have to focus and help in the advancing the rule of law, is where the legal tech has to focus on. Is how do we find lawyers? With the population of internet users, I mean, all thanks to platforms like Airtel, Jio, and whatnot, the population of internet users is crossing 4 billion mark, or rather more than that. It is showing almost 7% year-on-year growth. This means that the consumer demand through internet is driving big changes in the new way we find lawyers. In the past, as we all know, the business and individuals found lawyers through only personal connections or word of mouth. But I feel that personal referrals can be as inefficient in law as in any other industry, as your network might not know the right type of lawyer for you. So this is, I think, is where the online platforms can help connect lawyers to clients, and these are definitely adding value. And in addition to enhancing the ease of availing suitable services of lawyers, Kapil, where you mentioned creating an Uber for lawyers, ensuring that there is no breach of law, ease of availing suitable services of lawyers, these platforms also ensures greater transparency in terms of price and quality. Because see, the biggest, I would say, stigma attached to the legal industry is primarily related to honesty and transparency, especially pricing also. With the advent of these platforms and use of these platforms, the consumers are equally, they are equally as beneficial to lawyers as they are for consumers. As now independent lawyers have greater chance and platform to build brand as big as the largest law firms. It will also help, Kapil, I think, in easing of the burden on the metro cities, because as you know, people get into this legal industry and then they leave their hometowns and start moving towards Delhi, Mumbai, Bangalore in search of livelihood. But if we have these kinds of platforms, which this will help us in structuring and equally distributing the services and helping lawyers to use technologies and provide legal remedies. I think COVID-19 has definitely helped us all to think and innovate.
Right, absolutely. Absolutely, Himanshu, fantastic. So I think those were very valuable thoughts. I think I'll bring in next our very eminent panelist, last but not the least, Advocate Puneet Bhasin. Puneet is a well-known figure in India. She's been several times awarded as the best cyber lawyer in India, and she consults several Rajya Sabha committees as well. And she's also set up something called Cyber Jur Academy. She's been teaching and speaking a lot about privacy, data protection, and cyber law. So, Puneet, thank you for joining us. Maybe, as somebody who's ventured out in the field of cyber law and, kind of digitized your practice, could you also talk to us about, how do you see some of the mindsets changing and some of the risks that you've seen in digitizing legal practices? Over to you, Puneet.
Good afternoon. Really glad to be addressing the audience. One of the major things that I have noticed about digital technology is that I don't feel like from a legal fraternity standpoint, there's a huge change in mindsets. I'd say the youngsters or the younger people who are entering legal practice are the ones who are open to using more technology. If I still look around at, if you see especially litigation practice, it's primarily dominant by people who have at least a 10-year plus experience. You're not looking at youngsters in that space. So the amount of technology adoption by that entire category of major chunk of litigant practitioner is not that high. So one of the key reasons again being because of years of training which has happened in physical methodologies of maintaining your calendars, etc. And maximum what people use is Google Calendar. Then with respect to research is primarily where they end up using, let's say, technology. So there are different platforms wherein for research, they are open to using technology. So if I would say even with respect to me, I'm still old-fashioned in my way. So maximum will be a Google Calendar. If somebody will say, am I going and making everything work on tech platforms for my firm? Then I don't think so. I am really working in that direction. More because of usage. The way I have been practicing for years is what I'm continuing with right now. But if I would say, let's say 20, 30, 40 years down the line, there is going to be a change. The reason being you have younger people coming in who are actually more exposed to this technology and are comparatively open to working on these platforms. So if I say about advocates who are above 60, above 50, above 40, now I don't really see any of them moving towards the direction so fast. So because of COVID, definitely they've started with online hearings. They've got onto Zoom. Like Zoom and Skype have been there for years. But we never really saw people entering into conference meetings using that. So it's only during this COVID period that, it has to some extent brought in technology into the legal fraternity is what I feel. And with respect to the risks that are posed, the risks are absolutely very high. So unless a law firm has very robust cybersecurity management, incident response management, you're handling very sensitive data of clients. So today, let's say, even if I'm looking at my firm handling at least 300, 400 clients' data, I need to first of all have a very high level of cybersecurity because that's a high amount of sensitive data that I'm handling. So the moment I'm looking at digitizing, I'm also opening my doors to all this data getting leaked, which will render me liable on a lot of levels. So the point is still, we do not have a team which is going to be able to be capable of managing the risks. Opening your doors also has its risks in that scenario. Yeah, considering the paucity of time as what Kapil had mentioned, I would just leave it here. So if anybody has any questions, they can definitely ask.
Fantastic. Thank you so much, Puneet. That was very helpful. So, luckily, we have another 10 minutes. We can round off by 1 p.m. and 8 minutes hard stop. Maybe what I could request is exactly 2 minutes per panelist, and this could be a quick round, quick fire. So one of the points I really liked from the panel, and we can actually have a full day of discussions on this very interesting topic, something that we are all very, very passionate about. I heard Rajiv speak about techno lawyers. I also heard him speak about bots being implemented, so that's fantastic. Divakar mentioned a point on speaking to somebody called the head of legal innovation. Now, that kind of got me thinking. This is also opening up a lot of opportunities for Indian lawyers. So for instance, somebody like me, who's a 20-year-old lawyer, wants to venture out into legal tech. And why not, right? It could be seen as the next progression for one's career. Now, maybe if the panelists can take a couple of minutes each and maybe just dwell upon this and say, within your legal team, within your law firms, do you really see once lawyers start reskilling, upskilling themselves, do you see legal tech as a career option for young Indian, bright Indian lawyers and law graduates from top law schools and universities? I mean, we are producing probably one of among the best lawyers in any part of the world that we can. So do you actually see legal tech and careers in business, in actually the business of law versus a pure practice of law? Do you see those careers emerging in India in this year, the year of transformation as we call it? And if yes, what is your advice for the audience who might be looking at us and this panel as somebody who wants to venture out into legal tech? Your quick word of advice, crystal ball gazing. So we'll probably go in the same order. Rajiv, over to you.
Okay, so Kapil, this is not a 2-minute answer. This is not. But anyway, so couple of things, right? One, I think if you have to work in-house today, I know Puneet spoke about our more traditional colleagues who we still, litigation practice, maybe differential stages of evolution in terms of technology adoption. But as an in-house lawyer, I don't think you have a place in a company unless you are tech savvy. It's as simple as that. It's already out there, right? So if me or my colleagues don't know how to use various modes of technology that we put already in place, you are going to be an outsider. You don't belong there, right? So that's number one. Number two, let's bear in mind, Kapil, that already there are a lot of people, at least in evolved and mature legal in-house teams. There is a group of, by whatever name you call them, but they are looking at, like Divakar said, it's not just one person. There's a group of people looking at law tech and how in-house departments are going to leverage that. Now, today it's a mix of lawyers and non-lawyers, but going forward, I do see that team comprising of people who have knowledge of tech as well as are some sort of lawyers, right? So that's already beginning to happen, right? And Kapil, number three, the point I'm trying to tell the audience will be that there's already a lot, if you're an Indian lawyer and you don't want to go to the mainstream of law, there are a lot of opportunities because a lot of work is offshore to India already in terms of, Clifford Chance has an outsourcing unit in India. Accenture has, believe it or not, we have 400 plus lawyers in India who are doing work for onshore lawyers, right? And likewise, there is the legal landscape of the legal profession is not just anymore litigation or a law firm. It's already evolved. It's just a matter of taking more maturity. That's all I could say in 2 minutes.
Excellent. Thank you, Rajiv. Over to you, Diwakar.
I think what I'll say is a tech attorney requires both. It requires understanding of tech. It requires understanding of law. If I can just pick one theme from what I was saying is AI and technology is being developed at a very rapid pace across, which is, on a generic basis. Now, how to percolate that and get the benefit of that into the legal sector can only be done by somebody who knows the law and who knows the legal practice. So you need that background as a lawyer. But to actually do that, you also need to understand the technology. So it's a bit of a hybrid function. I see no doubt that this is an immense growth area. Schools are being taught, children are being taught coding in school. So, and let's say, so somebody's already learned coding. I mean, I remember in the 80s, I actually did BASIC for a long time, but I still remember it. I may not be a coder, but, and that's I'm talking about the 80s. But what I'm saying is, even now, people are learning coding. People are very tech savvy, and that's just going to percolate. So I think there's an absolute explosion that is going to happen. India can definitely play a role in that. It already is, and I can quite, I see a bright future on that path.
Fantastic. Thank you, Diwakar. Over to you, Himanshu. Just quick closing thoughts.
Okay. So while we have been talking about educating legal professionals about legal tech, I mean, Rajiv rightly mentioned there is no place for a legal professional who is not tech savvy. So the young generation, by virtue of their education, now they are very well versed with using different tech solutions, whether they are legal or non-legal, doesn't matter. I feel that we need to enable the consumers and bring the legal closer to them. I must say that the greatest beneficiaries of the legal tech are the consumers, as they can and they will be able to afford greater visibility and access to a wide range of legal services and providers. So the legal tech era, I feel, is increasing the competition. It is providing quality metrics and also reducing costs, enhancing transparency, and is aligning the consumer with the provider. So I feel that if we have to invest in legal tech, while we are doing a lot by bringing in solutions of improving the productivity of legal professionals, we should also focus and support legal tech solutions which are trying to bring the consumers closer to the legal industry. So that's my points.
Great. Thank you, Himanshu. Appreciate that. Over to you, Puneet, for any closing thoughts.
Well, if you would say there would be career opportunities, and there's definitely for those who don't wish to practice in mainstream law, let's say litigation or corporate, then legal tech definitely is a good avenue. So wherein they're looking primarily to develop tech products and marketing of tech products which can be used for different legal functions in organizations. So if you would see from that perspective, if somebody is not looking at a mainstream legal career, then yes, this is a good option that they can take up. With respect to growth, definitely there will be a growth, but I'm not quite certain growth as much as maybe litigation or in a corporate law practice. But yes, if you're founding a company which really takes off with legal tech products, that would be an opportunity. With respect to what even one of the co-panelists mentioned, legal process outsourcing. Yes, there would be great opportunities where, India is one of the prime regions where a lot of KPO and LPO work happens. So there, yes, there can be an opportunity. But primarily just, if you would say, legal tech products and working in that space, that.
I'm sorry, I think Puneet got dropped off. She was having a few network issues. That's probably a point for us to round this up. I really want to thank the wonderful panel. I know we had a very short time, 45 minutes to an hour, but you've been a remarkable panel. So a very big round of thanks to Rajiv, Divakar, Himanshu, and Puneet. Let's keep the conversation going. I appreciate the opportunity Business World Legal has given us, and hopefully you'll see India emerging as we've been the hub for a large number of industries in the IT space. I am very hopeful that India will emerge as a very strong hub, just as we are emerging a hub for fintech, for ODR, for mediation. India will emerge as a very strong hub for legal tech, legal automation, and adoption of AI technologies. With that, I want to thank the panelists again, thank the organizers again, and look forward to continuing the conversation. Back to you, Bhavna.
And thank you, Kapil, for
Thank you.
Thank you, Divakar. Thank you, Himanshu. Thank you, Rajiv. And thank you so much, Puneet, for joining us. Kapil, what an incredible moderation of this panel it was, because every panelist did get their due time. They did get their chance to voice what they had in their mind. And this definitely calls for a virtual applause from my side. Thank you once again for joining us.
Thank you. Thank you, everyone. Thank you, Bhavna. Thank you, team.
Our pleasure. Thank you.
God bless. So, ladies and gentlemen, what an incredible panel discussion that was, being our first panel discussion, and what a wonderful collaboration. AI is surely going to create newer possibilities for all of us. And moving on the next panel discussion, which is going to be on another very relevant and an interesting topic. It is on what do global businesses need to know about data security and privacy. Well, let's hear it from our experts, wherein we're going to be having first up Mr. Pawan Duggal, Advocate, Supreme Court of India, leading cyber law expert of India. We're also going to be joined by Mr. Apar Gupta, co-founder and executive director, Internet Freedom Foundation. We have with us Dr. Karnika Seth, cyber lawyer, author, policymaker, and educator, founding partner, Seth Associates Law Firm, India. Also, the session chair of this entire panel, ladies and gentlemen, is going to be Mr. Sudhir Mishra, founder and managing partner, Trust Legal. Well, with this, I'd now request our eminent panelists to please put their videos on and join us on the main stage and screen. And I'd now like to pass on the live baton to our session chair, Mr. Sudhir Mishra, to take it forward with his eminent panel. Over to you, and welcome once again.
Thank you, Bhavna, and good morning, everybody. Thank you, Business World, for giving us this opportunity to do this panel, and welcome Mr. Duggal. We have been meeting each other for last 2 decades in various platforms. Welcome, Karnika. It's a pleasure to be here with you. And I think Apar was also here, but is Apar here?
Mr. Mishra, he's just going to be joining us in some time. He's not yet logged in, but he'll be joining us.
Wonderful. And Mr. Divakar Agrawal also is in this panel. No, we are only 3 of us.
Yes.
Okay, great. Thank you. Thanks a lot. So this is a very interesting panel. And whenever we get this opportunity to get experts like Mr. Duggal or Ms. Seth, we have this extra advantage of bringing out the actual facet of law, more on the practical side, because I would say these are the people who foresee things, and these are the people who have gone miles ahead before the whole world was thinking about cyber or the digital or all these things. They were very futuristic about it. And it's a pleasure to listen to them, to understand from them, especially because of the pandemic and the kind of situation we are in, and the kind of new challenges which have happened, be it all kind of threats, cyber threats, and other stuff which is happening. And there is so much of litigation around it. There's so much of involvement of ordinary courts now on a day-to-day basis. And 2 years back, I would say, we were not as accustomed as Mr. Duggal to even understand the basics. We were quite reluctant, also happy in our own practice. Now, all of us have to deal with some kind of stuff on legal side with regard to whether it's data, whether it's security, whether it's the whole online mechanism. So we have a very illustrious panel, Dr. Pawan Duggal, across the country. Whenever I have heard him, I still remember. I don't know whether he'll remember. Good morning, Apar. Welcome to get you here.
Thank you so much.
Wonderful to have you here.
Thank you.
And so we have Apar Gupta also joining us. So this can be one of the best occasion for three such experts who have single-mindedly worked in this field and whose expertise is something which the country knows. So Mr. Duggal, I heard you in Cochin in 2009 in IPBA conference. When most of the Supreme Court judges, some of them have retired now from the Supreme Court, were there, and they all were listening to you on rapt attention. And that time when you were talking about data, online, digital, it was all sounding Greek to us because that was very, very prehistorical days. What we are seeing today, we all have accustomed. I'll just tell you one thing before I introduce the panel, that as a law firm, when we are working at almost 72 places today, the reason is because of this online mechanism, it was faster to integrate with like-minded lawyers wherever you want to. The kind of technology they are using and the kind of problems they are facing is something which is uniform across jurisdictions. You talk to other lawyers in other countries, they have the same kind of problem. So Dr. Duggal is here. Dr. Kanika Seth is somebody who has on online safety and digital empowerment. She has done path-breaking work, has been recognized repeatedly, and has again single-mindedly focused on this area. So she will talk a lot about those issues. And Apar, of course, was part of the privacy laws and the Aadhaar thing. Everybody knows about it. So Pawan, I'll start with you because you will initiate this entire thing. It has become mainstream now, this whole worry about data security, privacy. And more than that, it is very samaik, as they say in Hindi. It's very contemporary. Like if you ask an ordinary person, even he knows that WhatsApp has been now challenged in the court, that mera WhatsApp surakshit nahi hai. Or if I'm doing something on WhatsApp, it is going to be read. How do you see this coming year, the 2021, that we will have less cyber attacks, we'll have less threat calls, we'll have less threat mails. And how do one protect? Because we are from children to a 75-year-old person, we all are only glued to our screens, whether they are small or they are big. Yeah, you mute. Huh? Pawan sir, you are mute.
Thank you.
Yeah.
Can you hear me now?
Yeah. Yeah.
Thank you for giving me this opportunity and for your kind words. Actually, if you're looking for something which is going to be scarce or less, then we are going to be mistaken. It will be a case or an age of bountiful. Bountiful in every sense of the word. In sense of cyber attacks, in sense of cyber crimes, in sense of cyber security breaches. And one of the key factors in this bountiful age of 2021 is COVID-19. In fact, 365 days back, nobody thought the world would change on its head upside down, but it has. And during COVID-19, I was keenly watching some key trends in cyberspace. And I was realizing how these key trends are beginning to have an impact upon the way cyberspace will evolve. So I wrote this book called New Cyber World Order Post-COVID-19, where I've actually said that by the time the world is victorious against COVID-19, it will be a new cyberspace that will be waiting for us. This will be the new cyberspace where cyber crime will be a default option. We need to appreciate that thanks to the coming of COVID-19, we have already begun to start seeing the golden age of cybercrime. Never before in the history of the internet in the last 50 years have we seen cybercrime growing at such remarkable pace and coming up with so distinctive manifestations, avatars that are now beginning to amaze us. So in this exercise, I've expected that by the time we are victorious against COVID-19, we've only begun the journey. The vaccines are only the starting point. It does not mean that COVID-19 goes away. In this new cyber world order, cybersecurity breaches will be the new normal. States have already begun to start becoming very powerful. And when I look at the variety of COVID-19 legislations across the world passed last year, they are all in one way or the other enhancing state power, both in terms of the power over data and also the power to go ahead and impact prejudicially or otherwise the enjoyment of digital liberties. We're also likely to see a massive onslaught on digital liberties, and therefore I expect more and more people to move on to the dark net, both for legitimate and for illegitimate purposes. So for this kind of an ecosystem, I believe that 2021 has to be a year of bountiful cybercrime. Cybercrimes will keep on enhancing. They will keep on building on the gains that they have made in 2020, whether it's phishing, whether it's identity theft, or whether it's fraud. I was on the darknet recently and I saw that now they have begun, some websites have actually begun advertising a new kind of service. They've actually begun advertising the hiring or leasing of networks which have been compromised at the back end, which belong to the law enforcement agencies of some countries. So if you use that and push comes to shove, you're going to be identified. At best, the attribution is going to land up at the concerned network of the law enforcement agency, and you're going to be relatively safe. So when cybercrime as a service has begun evolving as a maturity model on the internet of the dark economy, we have to be now mentally prepared for this. On top of it, even on the superficial net, I'm beginning to see so much of onslaught of cybersecurity breaches globally. Australia last year had a very bitter experience in this regard, and massive attacks were targeted Australia, so much so that Australia publicly acknowledged that this is actually the handicraft of some state actor without naming the same, but saying that the same was violating its cyber sovereignty. In India, I see the attacks imminent. Now, nothing gets reported, but basis the work that I do, I can tell you there are so many attacks that have already happened. People are just not willing to talk. Yes, and a Singapore agency has warned India of a big imminent cyber attack. The Indian Computer Emergency Response Team, being the nodal agency on cybersecurity, has warned of India of a big cyber attack based on phishing. The RBI has asked the banks to be in a state of readiness because they are expecting a big attack on the network. So I think in a scenario like this, cyber crimes will no longer reduce. They will increase in their propensity, in their frequency, in their impact, and more significantly, in terms of ultimately impacting not just individuals, but even the sovereignty, security, and integrity of nations as a whole. Cybersecurity breaches will be the new normal, and therefore we have to be now readied for a new ecosystem where the data economy is our life and blood, where data is the building block. But it's this very data that's getting potentially attacked, targeted by state and non-state actors.
Thanks a lot for those introductory words, Pawan. Very reassuring that we'll have an end to all of this, but I think it's only act of God we are safe in India. That is what I can understand from your point, the very prominent word to use. Kanika, may I ask you that if data is the new oil and you understand data and I can see the kind of valuation which has happened of these companies from a commercial law point, if you see that even if most of the companies are struggling, the companies which are basically digital across the world, their valuation has skyrocketed in last 8 to 10 months. Most of the stock exchanges, the Indian stock exchange is showing, I think the major impact is of those companies which have a digital interface. So when you see the data as the new oil, what are the foreseeable changes you see in the trends coming up in 2021?
Well, at the outset, I must say that I'm very pleased to be on the panel here today. Thank you, Sodhi, for this opportunity. And as you rightly put, data is the new oil, and I also endorse the same view. And if you see the kind of trends which will emerge from this data economy which is being generated, it's going to see a sea change in how the businesses, global businesses, view the value of the internet, evaluate the brand worth of their company in terms of data, and entire commercial models will be changing basis on the regulatory mode, which is also changing in the country, and basis the budgetary allocations for their cybersecurity agendas, both technical and legal. So let me throw some light on this issue since the topic we have been assigned is what do global businesses need to know about data security and privacy. I'll break this into 3 buckets for you. First of all, I want to say that, if we look at the global scenario, USD 112 billion is the kind of cybersecurity investments in terms of business, that globally we see in this sector as a whole across the world. And slightest of breach, data security breach in any global corporation leads to almost 134 million users loss of data of users. I'm talking about the slightest of breach, and there have been major breaches across the world. Whether you see the Adobe breach, or you see, there was another adult friend site, which was a very known scam as well. And then there was a hacking of Canva. There's so many instances we can pull from the news reports we've seen in the last few years. And I myself have dealt with a few cases where I have seen the kind of data losses which have occurred. In one of the instances, since this is important forum for sharing this, for businesses to understand what it means, just not giving you theoretical figures here.
Yeah.
One of the businesses in the US, there was a client who was making, building an IP, which is intellectual property, in a real estate auction site. And when this website was made, it was given the project to another US company who had a back office in India. And after the handing over of this whole, IP, the work, it was through a platform called Jira. The entire IP was hacked into by the Indian back office later on. So these kind of data breaches, even with service providers or even with contracts that you're giving, for your own work, is at stake. And we had to procure the local commissioner's orders from the district court in Gurgaon to actually get this, those data in the servers and the computer systems confiscated by the, local commissioner, and then put in the court, deposited in the court. So these are the real life instances and the real repercussions of what, businesses don't sometimes understand the risks involved when they're even engaging in a harmless deal with a, service provider to make a website for them. So it's something very, very interesting. One must keep in mind. Now, moving on from there, I just also want to say that, when we talk about data, let me come to data. Data is not just data as we understand the nomenclature itself. It could include a lot of wings. If you see IP protected data, you could see trademark, you could have non-personal data, you could have sensitive data like a health record or an Aadhaar. Then there could be encrypted data, it could be unencrypted data. There could be so many different kinds of data, intangible data, even tangible data at times. When it's on a device, you can actually say this is tangible, right? So where is it stored is another question. So for global businesses today, on cloud, or is it on device, or is it on a handphone, or is it on servers? Is it third-party servers? Is it cloud servers? Is it a dedicated server? Then hybrid servers and PDP, whether with the PDP bill coming in, there will be mirror image data also kept in, say, delocalized position or a localized position. How do you really reconcile these questions which are coming? It will have an overhaul of both the technical and legal frameworks which exist in the cybersecurity domain. That's how I perceive, data. And therefore, policy changes will be necessary, both IT policy, social media policy, the usage of data policy, the storage of data policy, IPR handling, surveillance policy for productivity. Yesterday I was at the BBC, we're talking about employee data privacy. It's a huge, huge domain itself, because we are talking about surveillance through software, like keyloggers, like tracing softwares. So is that not an invasion of privacy? And to what extent can we actually declare that we are going to be surveilling for productivity reasons and do the same? Is it not a violation of privacy, considering the Justice Puttaswamy case, the verdict?
Absolutely.
These are the new questions, both in the legal and technical domain, which global businesses need to answer.
Yeah.
Apart from that, VPN, DLPs, data loss prevention software is being used. Though trainings are going to be imparted, yet the protection has to be end-to-end. Network security, ISOs to be complied with, GDPR compliances wherever applicable. So email security, there's so many endpoints to it. And there is currently the latest in terms of technology infrastructure is the zero tolerance. You would be aware of the same, that the zero tolerance architecture is being endorsed all across to protect them from insider threats as well as from hackers. And in the dark web specifically, we see a lot of corporate espionage happening. So, cooperation is being sought from service providers like social media who will have to give this data to the law enforcement authorities? So the questions of electronic evidence too.
Okay.
I just want to end this introductory part.
It's an introductory part because then I'll come to specific thing, because for all of us, this is so much of information and so much of understanding is required. So Apar, I'll ask you something which you have been focused on, like Arjun, which is the privacy laws and basically both Aadhaar and the privacy litigation which you spearheaded in Supreme Court. I want to ask you, again, it was a very futuristic jurisdiction you were looking at when we were so much critical about the whole Aadhaar thing, about our privacy. Now everything is dependent on that, whether it's the vaccine, whether it's the banking, whether it's our, I can see that we are actually moving towards a entire digital landscape for all citizens, our accountability, some kind of a voter identification, citizen identification, they all are going to be linked with Aadhaar. Do we really, you have seen the action in the courts, and do you really feel that as a country, all sections of the society, whether it's the politicians, whether it's the judiciary or ordinary person, actually care about the privacy?
So thank you so much for having me, Mishra. It's a pleasure to be here with Mr. Duggal as well as Dr. Seth, and benefited by their remarks. In terms of responding to your question, first I would like to clarify my role in that litigation was as a junior lawyer assisting senior advocates in 2 petitions which were drafted. They also included larger questions about the process through which the Aadhaar Act was passed as a money bill. So we're not only at the intersection of technology and fundamental rights, which is what I work on now, primarily through the Internet Freedom Foundation, but also on questions which are much more larger to the public law and constitutional design of that entire program. Given that the remarks here also structured towards lawyers who are working in firms and private practices, in addition to Aadhaar, after I quickly answer this, I'd like to make some introductory remarks in addition. So just in terms of Aadhaar and the litigation with respect to it, there were 2 rounds of litigation. The first was the first Puttaswamy case, which answered a larger question on where does the right to privacy emerge from the fundamental rights chapter, where 9 judges of the Supreme Court in August 2017 quite clearly indicated it arises from all the fundamental rights. There were different opinions given by them. In fact, in 2 of the opinions, the Personal Data Protection Bill, which was an ongoing exercise even at that point in time, is also noticed, in which, for instance, in Justice Chandrachud's ratio, which comes towards the end of the judgment, he indicates that the right to privacy has several components, which includes informational privacy, which means that privacy can also be a right which attaches to individual autonomy in terms of manner of dress, what you can wear, what you can eat, what you can watch, and also attaches to several other core aspects of human identity. For instance, matrimonial liberty to marry people, make life decisions, gender, sexuality, etc. Okay. Informational privacy is distinct, but has been noticed by both Justice Chandrachud, Justice Kaul, by Justice Nariman as well. And that shouldn't violate the fundamental right, but they are also in the nature of being a positive obligation on the government to come out with a data protection bill and to create certain legal standards, which firstly have a legal basis. Secondly, that purpose is clearly defined towards a constitutional purpose. It can't be something very absurd, right? It has to follow what is the requirement for governance and is articulated within the Constitution. Third is proportional. So the law that you're making and the measures that you're making link to that purpose. And finally, has enough safeguards. So it's a legislative framework. So the second round of litigation on Aadhaar was evaluating the constitutionality of the Aadhaar Act on these legal standards, and the majority opinion authored by Justice Sikri was in favor of upholding the Aadhaar Act, however striking down certain provisions of it and also striking down certain linkages. In striking down the Aadhaar Act in certain places, it also prohibited from it being used towards use by private service providers. However, subsequently through an ordinance and then through an amendment act, it has been reinserted. This takes care of Aadhaar. Now, coming to a larger question, which is a much more opinion-based question, do people care about privacy? I think people may not care about privacy, but it is a conversation right now. As we have seen, it is also beyond the legal sphere. Our own relatives are talking about a privacy policy change on WhatsApp and how it impacts them. It's going beyond policy professionals and lawyers. So in terms of a user expectation, and why is that occurring? Because the users now are more educated, they're spending more time with smartphones, and smartphone penetration is also increasing in India. As per the latest TRAI reports, they are close to 600 million active collections in India. So we are almost reaching the point of broadband, or at least internet connectivity density, in which for the first time, there is more than one connection for 100 people in India. So we are at that tipping point. And when you have this tipping point, what usually happens is that through waves of usage, people become more educated. Just like they know how and when to recharge their Tata Sky and which channels to pick in their Tata Sky package, people will also know which choices they need to make on their smartphones in order to preserve their privacy, at least through technical measures and choices that they make. And here the Personal Data Protection Bill, which we can cover in subsequent remarks, and I'll benefit from the opinions of Mr. Duggal and Dr. Seth on this, are very vital to it as a greenfield legislation, similar to how the Competition Act created an entire wing of practice for lawyers, but also brought a new degree of regulatory compliance serving a social need. Similarly, data protection is one area where law firms are looking at very, very actively, as well as businesses have already started incorporating GDPR safeguards. I'll stop here. Thank you so much.
Thanks a lot. Apar, very good introductory remarks. Thanks a lot. Pawan, I'll ask you something because you will dissect it for us. I have seen in our ordinary work, when we work for clients, there are, and you have been talking about it in some of the conferences, that, and I'm very particular about this, the whole government structure, when they talk so much about digital empowerment and we are digital economy, we are going to be a digital governance. And Apar is saying that now it's a part of the ordinary person's chat that we do care about our privacy. But as a lawyer who goes to different kind of states, and do you really think that there are few states which are examples for this countries, whether it's a filing an online police complaint is concerned, keeping them secured properly? With a lot of states have tried doing it, the cyber sales. Are these cyber sales really work in few states, or is it's all something in infancy? And if there are some good examples, because this is something which a viewer question has come to me, that are there states where really cyber cells work, and what all care they take about the data, about the privacy, and how smooth it is for somebody to file a case or do something? Do we have few examples on that?
I think we have various examples. We have cybercrime cells across the country. They're all doing the good work. But when I look at the proportion of cybercrime versus what their actions are, I find that we still are at a very infancy stage of development as a nation. Yes, of late, the Telangana cyber cell has been doing remarkably well because they've come down but 50 odd FIRs on this online digital instant loan app scams, which has now led to numerous suicides in Telangana and otherwise. We've also found some good work being done in Bangalore and Bombay. But by and large, these are pockets of excellence that I'm beginning to find. At a national level, I find that there's a massive gap in terms of capacity building. Yes, the government of India has now launched the cybercrime portal at the Ministry of Home Affairs, being cybercrime.gov.in. While it's a great first step in the right direction, it does not necessarily serve the current purpose because it's only a funnel for collecting cybercrime complaints. Ultimately, given the fact that policing is a state subject, invariably these complaints would then be marked to the relevant state police, who would then have the discretion whether to register FIRs or not. So consequently, the FIR registration process is very, very slow, is few and far in between. The cybercrime convictions in the country are at a very appalling rate of less than 1%. I was the counsel for India's first cybercrime conviction in 2003, when I was representing the complainant. And when we got that conviction, we thought that doors are going to open up. Yes, some convictions did take thereafter, but a fundamental flaw took place by virtue of the amendments to the IT Act, by the Information Technology Amendment Act of 2008. These amendments fundamentally changed the nature of legal treatment of cybercrimes. Barring a few cybercrimes, almost all of the cybercrimes were transformed into bailable offenses. And we began to start seeing a distinctive, marked approach in client behavior. Prior to 2008, client would come to us and tell us, look, I've done this, can you help me? Post 2008, a sense of complacency came across. The cyber criminals would first go and destroy the relevant incriminating electronic evidence because it's bailable, because they subscribe to the Indian Jugaad School of Management. And then they would come to lawyers and say, look, this is already done, let's now begin. So I think we've seen this famine of cybercrime convictions after 2009, and that doesn't augur well for the nation as a large. So as a normal citizen, when I'm looking at some effective remedy from cybercrime cells, I'm disappointed because, first of all, getting an FIR is such a tall order, registered. And even if the FIR tends to get registered, most of the time, the electronic incriminating evidence is located outside the territorial boundaries of India, which getting them back it's a big challenge, given the fact that India is not yet a signatory to the Convention on Cybercrime of Council of Europe or the Budapest Convention. Also, by and large, the MLAT route has been a failed exercise from the word go. So we've seen that we are not, as a nation, very successful in getting information from outside India. On top of it, given a very soft glove approach that the Indian cyber law has adopted towards intermediaries, this has further confounded and complicated the entire problem. Most of these intermediaries have very quietly assumed the role of mute spectators while mayhem happens on their network. This is thanks to the observation of the Supreme Court in Shreya Singhal versus Union of India, which not just upheld the constitutional validity of the exemption from legal liability under Section 79 of the IT Act, but more significantly, asked these service providers not to do anything till such time they got a court order or an order from a governmental agency. So it's a cumulative effect of all these factors which have resulted in a very peculiar situation. Now, with so much of cybercrime happening and with now IoT cybercrime massively on the increase, with Jamtara not being just one Jamtara, but cottage Jamtaras generating across the country, I think we need to do far more than just doing the lip service. And also, when one goes and teaches at the National Police Academy or the National Judicial Academy, one finds that barring some few brilliant officers, by and large, there's a need for far more capacity building amongst the law enforcement agencies at large in India.
Yeah. Very well said, sir. And most importantly, when you take the other aspect of administration, when you call it district administration or the other wings of governance, they are using the whole digital empowerment in a very different manner. That's what the government makes us believe. And whether it's dispersal of loan or monitoring the panchayats or other stuff, a lot of good work has happened. But policing and filing of complaints, I think there is a resistance, which you so nicely put it. I will ask you, Ms. Seth, something very, very particular. You are talking about the global businesses now. They are the new East India Company. And I will say that, whether somebody will like it or not like it. Because if it was not the case, Australia would not have said yesterday that we will have to, like Google said, we'll block Googling in Australia. Now, that's a kind of threat you can give to such a large country. Now, where do we stand as a nation? We are such a large population, such a large consumer, bearing the China example where we banned the TikTok. And we said we'll create our own TikTok in a few months or something. We have not been able to create. That's a different story. But tell me, globally, all these giants, the biggest India companies of business, do they really care about such a large market like India? And what do they do so special for India? What they do for other jurisdictions?
I think the alarm bells have already started ringing with the WhatsApp controversy around the corner. We've seen this happen, and it's is apt example to give to start this answer. For you, basically, I understand that there are a huge population that they're catering to, and they probably be even commercially using data for. In fact, businesses all across, whether it is Google or any other media, they often collect a lot of information about people and data, and they let them sign a terms of use, a privacy policy. Now the question is, when every global corporation is probably doing that, then where is the thin line? Where does it transgress? And can our laws have teeth? Basically, the point is that they will have to understand and respect the privacy of Indian citizens. It is time we stand for ourselves and our nation, and to protect and safeguard our people. And that's why I've voiced my concern, and I said government must step in, and that's thankfully what happened. So I'm glad that government has taken a stand on this, and this is just an example, but there will be now revolutionary changes in law. Having closely worked with the government, and I understand this sector for quite some time now, and over 2 decades, a lot has changed and will be in the next few years. Rapid changes with the PDP coming in. It will be basically a lesson for all of us to understand that privacy of people is, after all, a fundamental right, as rightly put by the held by the Supreme Court also. And every corporation which is using data of people cannot make people as their data. So it's not, we are not the products after all, and we shouldn't be. And therefore it is time that the Indian regulatory framework tightens up its nose and does something to protect its citizens of India. That's what I feel should be the take on this.
Very good. Thank you. Apar, I'll ask you something which actually bothers me. You are much younger than me, at least in this panel. Of course, Pawan is much younger to me. I feel that because he has always been like this. Tell me one thing. It bothers me how much pressure is on us to always be online, be connected with your internet. You talk about Internet Foundation. Like, I can see in my office all the lawyers, if they are in a meeting also, invariably people have this compulsive thing. It's like if you know the Chinese opium war, we were addicted to the opium. It's the same kind of thing. Like, you have at least 7 or 8 important social media sites. And I know people who follow at least 3-4 religiously. And then we have all these OTT platforms saying mobile only content, mobile only options. When do you get time to be productive? And how will you be productive when there's so much of pressure just to be glued to this handset? So where do you see this whole trend going as a youngster? Where do you see this whole internet, digital, being actually a tool rather than being the main medium?
So thankfully, I've just taken good care of myself. I'm actually 36 now, so I don't consider myself young. Till 35, I used to still consider myself young. And somebody younger to me actually explained me what all of this is in just 2 words. They call it doom scrolling, because you keep scrolling and you don't doom scrolling. So they call it the doom scroll, where you lose a track of time. And you're right, it goes back to the fundamental economics of time spent on digital platforms, where more personal data is gathered on the basis of your gestures. And this personal data is then used towards serving advertisers and third parties. Secondly, it's also used towards devising better content, better in the sense being more engaging towards that specific person, and which is why your individual content feed on any social network is personalized as per your taste and preferences, even when you may not know what your own taste and preferences are, because there's this fantastic book which says that data-based insight actually shows that everybody lies. We have an image about ourselves, but our psychological motivations, which are submerged, are sometimes very different. So technology has reached a point where there's pixel tracking, where even when you highlight something on a page, just because of emphasis or force or habit, or you press your thumb a little too hardly on the screen, or you play around with the image which is there inserted, the smartphone can capture that user interaction, and then on the basis of that, they know that there is a stimulation for which you are reacting. So there's also a very good book called The Shallows, how that impacts a long-term mental mental models, starting with memory, and then going towards much more serious conditions towards addiction. Now, what's underlying this entire model are two things: the economics, which do need to change. They are changing, okay? Also because of regulatory scrutiny, especially in terms of its interface with younger children and adolescents. It's happening in the United Kingdom, where it's going a bit distinctly from liability frameworks to duty of care frameworks. That's also how the larger digital communications are now being viewed, not only as a platform-based behavior, but also as a publisher-side behavior. And these things and these boundaries, which were set in law and defined for conventional models of media distribution through radio as well as television, are changing, and the law is reflecting to change that. These active policy discussions are happening in India as well. So I would like to say eventually that to a large degree, when we blame people for doing these kind of things, we also need to understand that there are huge incentives and ecologies which are set. There are biases which are being exploited, and the human mind and our own level of self-control is eroded when you're placed in that environment, and certain incentives are placed where certain things feel good, even though they may be only short-term benefits in terms of a dopamine kick, in terms of the number of retweets you get, likes you get, shares you get. But however, what happens at the end is you end up losing about 3 to 4 hours of your time, and your eyes end up being dry because you're waiting for the next person to retweet or like something which you're doing.
Yes,
Sudhir, may I just interject? I have a comment. I appreciate what Apar also said, and that reminds me of this movie, Social Dilemma and The Circle, which we have seen. It's quite popular with what has happened in the today's generation. But my concern is larger right now with corporations. We are talking about global corporations. It's even larger because in the times of AI that we are using IoT devices and smart gadgets. Tomorrow we should not be scared that if we're using a smart device, a refrigerator or an AC or something, or a lighting equipment which is smart built, maybe built in a country where we are, or from some place where a snooping could occur. So that is the kind of breach of privacy invasion, the extent that we are all facing. And that's a big question mark and a dilemma at this point, because you can declare what you're collecting as a social media platform. Maybe they can declare what they're collecting, what is encrypted and which will not be intercepted or saved on a server. I can understand that, and balancing and harmonizing competing interests can be made. But what about this? I mean, this is something which is like unexpected surveillance and invasion of privacy.
Yes.
And that is also an area which is worth introspecting at this point.
Wonderful. Thank you, Karnika. Pawan, I'll give you the last word. And this question is actually very deeper. I think it's very premature. But like cigarettes, which were 25 years back, were supposed to be very cool. There were no movie halls, there were no disclaimers, there were no problems. Suddenly, this has started when we travel internationally in international conferences. I think a lot of time is being devoted now in IBAs and New York Bar conferences, that how people are getting out of this whole mobile fascination, and how you hardly get a mobile number to start with. You get a landline number. Most of the law firms we work with, you work or others work. So in India, it's on the contrary. At the first opportunity, we are supposed to give our mobile number. And then if we don't, as Apar very rightly said, if you don't give a response, then they say, oh, you haven't replied. You have read, but you have not replied. So that chain takes actually, but I would know very proudly some of my people around me who said that I devote 8 or 10 hours of time on mobile and computer and everything put together. As a person who has seen this coming 20 years, you have been focused on this area. Are we getting into a good direction, or we should start worrying now? It's mute, huh? Mute, sir. Yeah.
I think it's a journey in progress. We have potentially not yet reached a level of internet usage maturity that we ought to use to reach as a nation. So consequently, it's all about the glitzy, the devices and the screens that are currently engaging our attention. Very quickly as a nation, our eyesights are getting impacted. Very quickly as a nation, we have begun to start getting more unproductive. So consequently, we'll have to make a very conscious choice to understand that internet is not the be-all and end-all of life. Unfortunately, in India, we've already been seeing the great Indian vomiting revolution, where Indians are vomiting all kinds of information about their personal, professional, social lives without having any consideration to kind of the ramifications it could have for their future. No wonder people are now not getting jobs because the employers are now Googling them, the potential candidates, and even looking at social media handles and the social media searches. I think as we go forward and as maturity comes across, we will have to start apportioning a limited period of time in a 24-hour basis to this entire internet bandwagon. Yes, internet is a vehicle, but as we go forward, it will be one of the many streams that we will be using. So in case if we would want to have a more holistic, balanced approach, then to be on a 24/7 basis on the internet, on social media, on call is a mindset we'll have to quickly say goodbye to. But then it is going to take some time, given the fact that a lot of Indians are still first-time users who are jumping onto the internet bandwagon. And given the fact that they are right now in the period of, shall I say, teenage experimentation of internet hormones, I think it will take some time, but more and more people will increasingly find much more benefit in trying to have a balanced approach between the real world and the virtual world. Ultimately, it's not just work-life balance, it'll be actual world versus virtual world balance that will have to be maintained as we go forward.
Thanks a lot. Thank you, Apar. Thank you, Karnika.
Thank
you, Pawan. What a panel we had. I think we finished it on time. And it was wonderful discussing. I wanted it to be a little different than the usual stuff so that we get a larger message across. Thank you. Thanks a lot for this.
Thank you.
Over to you,
Dr. Seth. Thank you, Mr.
Thank you.
Take care. Bye-bye.
Thank you.
Thank you. Bhavna? Yeah, all yours. Yeah.
Thank you so much. Thank you so much, Sudhir, for joining us. And Karnika, Pawan, thank you so much for giving us your valuable insights today and being a part of this incredible panel discussion. Thank you once again for your valuable time.
Thank you. Thank you. Thanks a lot. Bye.
Thank you.
In the world of business, when you think business, you think BW Business World, spanning across platforms.
Coming up, as right now we had an amazing discussion which was on what do global businesses need to know about data security and privacy. And let me tell you, what an insightful and an engaging discussion that was, ladies and gentlemen. And I'd really like to once again thank our panelists for sharing their expert views on the topic that has something for everyone as a takeaway. And ladies and gentlemen, now we're going to be slowly moving on to our next panel discussion, which is going to be coming up. As we're going to be having our next panel, which is going to be starting at around 2:05, and we're going to be now queuing in for AV to be played. Thank you once again for being a part of this incredible day. I'd now request the AV to be played. Thank you so much.
In the world of business, when you think business, you think BW Business World, spanning across platforms from print to the fast-growing digital space, from custom events to insightful industry books. BW Business World continues to capture a critical market space. Enjoying over 1.2 million engaged reader base, we have replicated this success in digital, with a 6-fold growth in the past 1 year. So who is the BW audience? Our magazine readers are the cream of the crop business professionals spread across industries and niche communities. BW Digital engages with a much larger audience, hailing majorly from India and US. We also reach diverse markets including UK and Saudi Arabia. The BW Print universe comprises of BW Business World, BW Smart Cities, BW Hotelier, BW Applause, BW Education, and BW People, each profiling industry leaders and niche sectoral stories. BW Digital Communities target niche segments like startups, CIOs, smart cities, defense, amongst a range of other fields, with a following of millions of unique digital users. BW Business World is an industry leader in curating a plethora of IPRs. With multiple industry stakeholders under one roof, BW IPR events generate superlative content. BW Engage offers bespoke brand solutions across functions with inputs from the award-winning BW editorial team. We design and execute a 360-degree marketing model, resulting in top-of-mind recall and a large BW Engage client patronage. Why engage with us? We have an award-winning editorial team. We forecast new scoops and future trends before any of our competitors. We provide 360-degree brand solutions, and our clients are always happy with the ROI. This is just a glimpse of our client endorsements. To subscribe to our print patronage, visit subscribe.businessworld.in. Follow us on Facebook and Twitter. You can also connect with us on WhatsApp on businessworld.in/WhatsApp. BW Business World presents a rich legacy of curated events that enable conversations on policy issues in India.
Because of the state of our cities, we have no option but to build smart and resilient cities.
Digital India is more for the poor, underprivileged and the deprived.
Covering a range of topics, BW Business World events look to create a strong narrative around smart cities, digital India, healthcare, Swachh Bharat, human resource issues, education, banking and finance, among others.
The world is fast changing. Best practices are available now on the net.
विकास डेवलपमेंट पूरी राजनीति में ये फोकस बन गया है.
BW Business World events provide a speaking platform to the voices that matter.
स्मार्ट से ताल्लुक यह है कि हम जो बेसिक एमिनिटीज हैं उसको हम चुस्त दुरुस्त करें.
You don't have to be a technologist. You need to understand how technology influences the world.
Mahatma Gandhi was a great man. He was the leader of the freedom struggle.
We believe that e-governance and IoT will play a very, very important role.
BW Business World is an excellent exhibition platform that helps you showcase your services to the right audience. To be a part of our legacy, write into us at partner@businessworld.in.
Well, ladies and gentlemen, what a great AV that was. Thank you so much once again for joining us. And let's move on to our next panel discussion. Well, ladies and gentlemen, right now joining us on our next panel, which is going to be on ease of doing business in India. And this is going to be our third panel discussion. So how does India break into the World Bank's top 50 nations on the ease of doing business index? And let's find out what lies ahead from our expert panelists. First up, ladies and gentlemen, we're going to be joined by Ms. Seema Jingan, the partner and co-founder at Lex Counsel Law Offices. We're going to be joined by Mr. Suhail Nathani, managing partner, economic law practices. We're also going to be joined by Mr. Ajit Mishra, partner, international and India, Harrison Clark Rickerby. We're also going to be joined by Mr. Badri Narayanan, executive partner, Lakshmi Kumaran, and Sridharan as well. The session chair, ladies and gentlemen, of this panel discussion is going to be Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Legal World, BW Business World, and Exchange for Media. Well, with this, I'd now request our eminent panelists to join us on the stage and screen. And thank you once again for giving us your valuable time. Do unmute yourself and welcome once again. With this, I'd now like to pass on the live baton to our session chair, Dr. Anurag Batra, for taking it forward. Over to you, Dr. Batra.
Thank you so much, Bhavna. Good afternoon. A very happy new year to all of you. This is the second edition of the Global Legal Leaders Summit. Last year, we did it in a hotel virtually at the Imperial on the 12th December. This year, we are doing it on Jan. We've had a good day of dedication. And there's an echo from someone's phone because, I'd suggest that if you're speaking and you put your phone in a active mode, otherwise you'll have to mute it. the topic we are discussing is very, very relevant. At the end of the day, if we have to realize the dream of being a 5 trillion economy, we need to improve the way we do business here, the ease of doing business. Again, there are two ways an economy grows. One is through investments and others through demand. Both are in some way linked. So we have an eminent panel who understands how investments can be accelerated. They advise their clients in their positions. They're able to interface with both the policymakers and the investors to understand what is needed to be able to create India as a destination for more capital. So let me, you already introduced the panel. We have Mr. Mishra joining from UK, and really he understands being based in UK and helping European and British companies to come into India. First of all, while we have improved so much, I'd like to understand from the panel what are things that still need to be done better. Let me start first with Mr. Ajit Mishra, and then I'll go around the house. Mr. Mishra, your opening comments on what has improved, but what still needs to be done to attract more investments.
Well, thank you so much, Anurag, and other panel members. Good morning and good afternoon to you. Good morning from London. Good afternoon to you. Well, see, first of all, I will say Indian government has done really well in terms of making it easier for investment to come into Indian market. The potential which India has, I don't know it has been properly utilized yet or not. Still, that's why we are talking about how we can be 5 trillion economy. But I think potential for India is slightly more than that. Big boys, so like we see Tesla is coming to India, and that's a big news. I think things are much more easier for them. But when we talk about SMEs, and personally, right now I'm working for a few clients who are setting up in India. Everybody is quite enthusiastic. But I think Indian government should do slightly more in terms of supporting SMEs. SMEs, something as simple as I will say, the remittance of money from here to India, to their subsidiary. This regulatory filings, that's a big issue. Okay, initially setup takes too much time. Once it's done, it's much more easier and seamless. But initial hurdles still they are there. So making it regulatory aspect, especially for SMEs, if Indian government takes that agenda slightly more on the priority, that might be very helpful.
Okay, you know, one of the things that I often hear, I was talking to a group of very big investors that have a big stake in India's entrepreneurial ecosystem, and their bone of contention on RBI's speed of response, and sometimes the articulation of why something has been permitted and why something hasn't been permitted. I think that was a specific area where I got comments in a discussion 4 days back. Let me bring in Mr. Badri Narayanan. Mr. Badri Narayanan, you know, policy certainty is a big issue. You know, if you look at the tax regime in the last few years, it's been to be kind to the regime, it's been erratic. Okay, we asked for retrospect tax. So tell us, what can we do in the way we improve our way of doing business and hence attract more companies?
I think, thank you, Anurag, again. And I think one of the things, as you know, is a big issue for foreign companies coming into India has been tax issues. Okay. And there is our tax system, you put it very politely, is at best erratic. But there are two things which are happening. I think I must say some positive things and I must say some not so positive things. One is the movement towards more and more faceless assessment, I think, is in the right way. Okay. Today, for example, one of the big issues with tax used to be that you used to have multiple authorities come and knock at your door, and used to spend many days trying to look to the same data and probably on the same. I think that's reduced certainly. Faceless assessment gives more opportunity or the people to be able to provide the information in a manner which they don't feel is under threat. Having said that, I think there are two issues which I feel from a tax point of view, which we are still not able to get over, and it creates a lot of negative impact on the global diaspora as also the global investors. One, as you know, is that we keep changing our tax positions, okay? And our policymakers, I feel, sometimes don't have the consistency to keep and stick to that. For example, if you take both income tax and GST, the number of amendments have happened is a lot. The compliance are becoming much more. That's one side of it. The second more concerning area I find is that the tax investigation continues to be very, very hard. Okay? Start the position of being somebody who has done something wrong, and then you kind of move into that area, and the real thought process is that you kind of get into companies which are global companies with best practices, and you treat them like people who have done fairly petty criminal activities of tax evasion, and that's where the real issues I think come. Those are the two issues that come in tax. I also find that in some of the other laws also, we see some of this, where, for example, especially some of the new age laws that are coming in, you find that there is investors want certainty in terms of policy, but then the minute you change the positions, there is a lot of pushback on this area. So I think policy certainty and better management of tax authorities is going to be very crucial or to invest and attract investment into India.
Okay, let me bring in Seema. Seema, again, you work with a multitude of clients that have, looking to come into India or already doing business in India and looking to kind of grow what they have. Tell us what can be done beyond what has been done to make it more attractive, because clearly, let me give you an example. You take pharmaceuticals. Of course, we produce for the world. Look at textiles, we produce for the world. But in the last 1 year, while some of the supply chain has moved to India, a lot of it is moved to Vietnam, it has moved to Bangladesh, which textiles anyway is more competitive than India for whatever reason. And, a lot of money continues to, go to other emerging economies in spite of India having the right, demographics, it having a good banking system, and most importantly, a domestic demand, which clearly creates a market, which then is the base for a very scalable business. So we are losing out to other, in spite of this improvement, we are losing out to other countries and economies. How do you think we can simplify some of the things? Primarily, investors are concerned about, cost of compliances, the time to take approvals, and policy consistency, and primarily in the three areas of capital, labor, and land. Capital being the most, then being labor, and when it comes to manufacturing businesses, land. So give us a sense of what can be done from here on. We can't be happy if we want to be among the top 3 economies in the world. We can't be we can be in the top 50 and be happy. We have to be among the top 5 countries in the world to be able to do business the way it is done globally.
Right. Thank you, Anurag. Anurag, I would like to step back a bit and say and discuss what exactly it really means to do, having an ease of doing business. There are a lot of components of having an ease of doing business. I think the most important component, the first and foremost, is the ability to set up the business in an easy, non-complex, and straightforward manner. The second element is the continuity of the business, which is the operations and the compliances related to the business. The third element is the ability to access capital and funding by that business. The fourth element would obviously be the ability to employ people, to have ease of getting into the property transaction with ability not to be delayed so much, which is right now the case. The predictability of taxation is another very important point. And enforcement of rights and obligations. So when a foreign investor comes to India, or even when an Indian industry or entrepreneur sets up a business in India, the stability in enforcement of rights and obligation is a very, very important aspect. And the last but not the least, the ability and the ease of closure of business. All of these components, when we operate, when we advise our clients, all of these components form a big make the puzzle complete. Now, the government has definitely done a tremendous amount of work since 2015. The ranking itself is showing that we have moved up from 142 ranking to 63. But that's just a reflection of the business being done in two scenarios, which is Mumbai and Delhi. And India is pretty large to be having only in these two entities. The Department of Promotion has also set up a task force, and they do a cohesive policy review every year. And they come up with the compliances and the reports and a planning system, what they can do in this for the last 7 years. They've been looking at it, and their focus has been to look at single window clearances. Their focus has been to remove unnecessary registration and licenses. Their focus has been to do away even with the renewals, every 3-year renewal of the licenses. And the last focus has been also been on implementation of these policies and creating transparency. But these are great initiatives. You cannot take that away from the government. But what is happening right now? I'll give you some instances from our own operations. So let's look at something as basic as setting up a corporation in India, which is the first starting point for any company to come to India. Now, when you are a foreign investor, or even if you're an Indian company, as against previous scenario, you have a unified licensing situation, whether it is a GST registration or your EPFO registration or your VAT or your tax, everything has been consolidated into one filing. But what happens is that you have to file a number of documents. And if it's a foreign investor, you have to get it consularized, you have to get it notarized, and you have to take translations. I understand the requirement of translation. And then you have to also do the certifications through CS and CAs. Now, the whole process in getting the approval and the pre-approval stage, which is the consularization, making them understand why we need 50 types of documents and 50 types of ID, one with address proof and one without it. It is as simple as that baffles them. And then one interesting, and I'll give you an example. When we were setting up a company recently for a German client, all the directors were non-Indian. And there is a requirement in the Companies Act where one of the director has to be a resident Indian going forward once the company is set up, which is 182 days, has to be complied with. But the registrar office was insisting that the current director, which is a German director, has to have a residency certificate, and his input coming to India and outside India has to be certified showing 182 days. Now, when you have a wonderful single window policy, but you do not have efficiently trained officials to implement that policy, we have a problem. Similarly, when it comes to contract enforcement, that's a huge issue when any industry sets up in India. The dispute resolution process, the enforcement of the rights and obligation is a nightmare in India. And more often than not, the requirement is, can we have foreign laws, can we have foreign jurisdiction, but that doesn't work always. For example, recently we were having an enforcement for a commercial court. But the stamp duty, the court fee that you have to pay for adjudicating your matter in a commercial court is 7.5% in state of Uttar Pradesh, which means a client which had a litigation of contract enforcement of 5 CR had to pay approximately 40 lakhs of court fee. That is just I would say unthinkable in terms of any other progressive community, because you're not getting your money here. You are first paying the money to get more money. So there are a lot of challenges with the enforcement as well. Similarly, if you look at the basic operations related to lease registration, I'm saying even before you go to the lease, undertaking the due diligences for the property, state by state, the documentation, the nature of the documentation, the name of documentation is completely different. In Haryana, it would be 20 pieces of documentation, and in Andhra Pradesh, it could be 30. And there is no cohesive, complete list of land records. So there are a lot of...
That when it comes to, let's say, liquor industry, land, that there are certain subjects which are state subjects and certain are center, and, hence
right.
There there is no, those are finer things. But I think before we get there, if we got there fast, then clearly it would accelerate the quantum of investments and the quality of investments that come into India. Mr. Suhail Nathani, your opening comments on how we can maintain the momentum that we've achieved by being in the top 50, but we have a long way to go.
Thank you, Anurag. And yes, we have many practical challenges, but we have come a long way. So let me not share with you war stories of clients. There are plenty of war stories on how clients are suffering in this. But earlier during the lockdown, as early as April this year, well, last year, the government of India, Invest India, put out a new KYC tender. They wanted all the central government laws to be collated in one place so that any investor could come to a single portal and understand what was required under the law. And please recognize, as you correctly pointed out, India is a federation of states. So these are central laws, and then there are state laws, and then there are some subjects that are concurrent. We worked with the Invest India, compiled all the laws, and now there is a beta testing of a website going on as we speak, which will launch fairly soon, which will give anybody doing business in India, whether foreign or Indian, a single point to gather all the information. So one aspect is getting the information. The second situation is that after seeing this, many state governments have volunteered to come on to a similar platform, and several are already doing it. Telangana is doing it, Andhra is doing it. Several state governments are now coming out on the same platform to disseminate this information. And if you see the WTO structure also, many of our agreements there are on sharing information. First thing is sharing the information. Then we'll come back to what you said on capital, labor, and land. India's shadow banking industry, to put it politely, has been the largest example of crony capitalism over the last few decades. The IBC, not working ideally, but has come a long way to resolve that issue. Credit is flowing again in the economy, and that's the most important aspect to get your economy going. In terms of land, that is a state subject. The environmental ministry has sort of taken out its tentacles on project-based approvals, which we had seen in the past. Whether it's a good or bad thing, I'm not commenting on that. We can talk about it. In fact, the National Highway Authority made a statement in court, which the court took exception on, saying that these are foreign agendas to drive the environmental compliances in India. I'm not subscribing to that view, but I'm just saying that land laws are being reformed as we speak. Andhra and Karnataka are issuing notifications every day on conversion from agriculture to non-agriculture to commercial and industrial use. And the key here is that if you do a property transaction, let's say in London or in any other developed country, you don't need to go to the registry office and do a search. Everything is online, and there is a belief that this is reliable. Today, we are seeing that happening in our various states. So land cannot be cleaned up overnight, but it is a process. So if I buy a piece of land today, I have to trace the title back 30 years. But the fact of the matter is that the last 10 years will be much easier to trace than the last 20 years. So that is the situation. Labor. We have 29 labor codes, which have now given way to 4. They are going to kick in on 1st April 2021, assuming the government stays on track. And these labor codes are revolutionary, to say the least. Are they perfect? No. We don't bring in perfect legislation. GST was a very good thought. We know how long a tail it has in terms of implementation. But labor, almost the last bastion, is now going to get reformed in a very, very significant way. So in India, we always had workarounds. So basic wages were low, then Provident Fund was low, and then we would give all these allowances. Now all 4 codes have a common definition of wage. There is a common contribution to the Provident Fund. There were several industries that had their own laws in terms of safety. So there was a BD and Cigar Act, which was a central act. I was surprised when we found that out. And there was a coal mining act, and there was an industrial act, and whatever. All these have come into one modern code on occupier and safety hazard. And it may bring a smile to some of your faces to know that now the inspectors are not called inspectors. So you can have a factory inspector, but the law is now calling him a factory inspector and facilitator. Now, whether this will make a change in the ground, your guess is as good as mine, and we all know where that is heading. But at least the mindset needs to change, that this is not an inspector. This is somebody who's come to try to help you get into compliance. So lots happening, long way to go. Agree with everybody. Thank you.
They say God is in details. Again, we know we need to improve what we need to improve. You gave specific instances. Now, let's look at the sectors which we are naturally suited to attract capital, where companies coming from UK, Europe, America can naturally, whether it's fintech companies, whether it's edutech companies. So let's look at sectors and give examples of one or two policy tweaks or policy interventions that need to be made to make it even more attractive. Let me start with you, Suhail, this time first. Give us some sectoral interventions that need to be made to be able to improve the attractiveness of doing business.
See, Anurag, the way I look at this from our client's perspective is that you want industries that generate wealth and employment. You are not alone in seeking that type of investment. There are several countries who compete for this. So take fintech, for example. Is India the most ideal market for fintech? Let's be honest, we are far too regulated to have that. We may have payment gateways, but we don't recognize Bitcoins. And the financial world is moving far too quickly globally for India to stake a claim in this space globally. You may have pharma, you may have some type of manufacturing, but as you said, Bangladesh and Vietnam have taken the opportunity away from China more than India has taken the opportunity away. So how do we pick these champion sectors? For one, you speak about education. Really, India has the base to build education. And if you see globally, in many universities, there are Indian professors. There's a lot of investment in education. We have a rich tradition of education going back to the Nalanda and whatever else. The fact is that how do you make these work for yourself? I know I serve on some education foundations, and there are two things that I give you examples of which are very good. One, on technical education, the government has made great stride, and tomorrow's education is not a degree education. It is almost a gig economy. If you start and finish in the same profession in the next few decades, I think you're doing something wrong. There will be a
even true for lawyers
everywhere.
Mr. Nadani, even true
lawyers
for
are the ultimate gig economy. Don't forget, counsels come in one matter and they go away, and they may sign on the opposite side the third day. So it's the first and ultimate gig economy. It's true. It's true. You hire a counsel for a particular day for a particular slot, and then he's gone. But I'm just taking that aside, that yes, the education will prepare you. So if you see universities like Cambridge and Harvard and whatever else, now they're giving you the ability to go back anytime during your life and do certain courses for no additional fee. So I may have graduated from a school with a degree in law, but 5 years later, I can go and take 10 hours of lectures in finance, which has nothing to do with my law degree. So these are the kinds of traditional universities changing. The second thing is, in India, unfortunately, education has always been viewed as a social function. And that has created a huge problem. Today, we have private universities, Jindal, Ashoka, several others, which are doing some phenomenal work. But the way it's like pulling teeth. So I serve on the one of Bombay's oldest universities, and through an act of parliament, they gave us a deemed university status, which is huge. We can set our own curriculum, we can do our own exams. Now in a city like Bombay, we have 2 campuses. And they have given us deemed university in one campus, but they won't give it in the other campus. And what is the logic behind that? There is no logic. This is an act of legislature that you brought to give a deemed university status, but we will give 5 institutions, but 3 institutions which sit across the road, we will not give you that over there. Those are things that we really need to get out of.
And we need to keep in mind that legislation and policy intervention need to look at the changing context. A lot of things have changed. Pandemic has changed a lot of things. Education is hybrid or a mixed model. And we can go on to specific industries.
But Anurag, if you view education as a social function, so look at the Supreme Court, look at the fee caps, look at all the judgments on education in the last decade. They have just not allowed education to flourish. Why are you able to pay an American university an absurd amount of fees, as also you can pay in an English university, but in India you can't raise fees, you can't pay your faculty? What is it that is preventing? And people find workarounds, people do all kinds of stuff, which is not conducive to the growth of education in this country.
Okay, now let me go to Seema. Seema, how do we accelerate at, what we are doing at a government level? How do we as professionals, as domain experts, be able to contribute to government's thinking on certain policy things? Of course, as media, we are able to build consciousness, bring issues to their logical conclusion by, taking it to policy makers and government decision makers. But what do you think as legal professionals, as people who are advisors to entrepreneurs and business owners, is the next logical step in improving India's ranking and an actual way of doing business?
So first of all, the government has been engaging with the, lawyers and professionals for a very long time. I'm not sure how much of their inputs are going into the policy. Some of them. For example, if you take the foreign investment promotion policy, government used to regularly interact with the accountants and lawyers and take inputs and formalize the policy. Adding on to what Sohail said, one of the largest lobbying or we have been meeting with the government is with respect to the NGO structure of the education system. I've been very, very active in the education space for the last 15 years. And during that process, we have got multiple international universities, educational institutions, schools, premium educational institutions wanting to come to India. And the one largest thing, one of the biggest impediment in coming to India is being the not-for-profit structures, the trust in the societies and the Section 8 companies that the government insists, because as the education is a service sector, service industry, it's supposed to be in a form of service. The Supreme Court has been reiterating that. The regular inputs that we have been giving to the government over the last 10, 12 years is we have to do away with this trust society. It creates opaqueness. It takes away your tax because these are tax exempt entities. It takes away your tax revenues. And the operators, whether these are international or Indian operators, they find ways to create service arrangements to sort of monetize the money that is coming in education institutions and reap away the government taxations. So one of the major policy initiatives that the government should be looking at is enabling foreign investors to come to India in a transparent, opaque, non-opaque manner, which is to create tax-enabled structures, not opaque structures like societies, trust, and NGOs. The other area that we have seen a lot of activity where industry wants to come is a satellite industries, and I've been very, very active over the last 15 years on the satellite industries, and I've seen multiple international satellite operating entities want to come to India, and the largest impediment is being the monopolistic nature of the way ISRO operates. We have done a lot of discussions and meetings with ISRO to enable canalization of foreign satellites in India, setting up the Indian ISS systems in India. The policy is moving, but very slowly. That is another area where industry wants to come, but is unable to come. The other sectors that I see is defense. Defense is something that many industries want to be in India, but we have a defense licensing system which is very stringent. We have there is a national issues involved there, so I understand the reason why government is slow. I think overall it's not only policy issues basis these sectors, it is also the general perception that we give out to the foreign investor is that generally operating an Indian setup is little cumbersome, it is compliance oriented, and it is difficult to deal with officials in India. I think that is a structure.
And there is a cost of compliance.
Yes.
And there is a cost of compliance, both in terms of number of people, in terms of management time, or whether the CEO's time or the promoter's time, depending on how the organization is structured. So clearly we need to, we've done a survey and we will publish one of the, demands of the industry out of the budget is to simplify compliance, to reduce compliance. I mean, there are sectors where you need to take 45 clearances before you can start a business.
Hospitality is one.
And you open an additional branch. So clearly, that continues to be a major demand of the industry. Let me go to Mr. Mishra and then to Mr. Narayanan. Mr. Mishra, now that the Brexit has happened, UK is UK and Europe is Europe. Tell us, in the way some of the companies from there approach their business in India, does it get changed? How does Brexit impact India? Does it impact India now that it has happened? And tell us the interest of British and European companies in India. Post-COVID, do they see India as even more attractive because, our mortality rate and infection rate is among the lowest. Also, there is an opportunity for vaccine tourism. I mean, I didn't invent the term, but a lot of experts are talking about the fact that India's healthcare system has been able to take care of whatever issues we had there. One of our Indian companies has come up with a vaccine and also manufactured. One of them has taken the partnership with Oxford and manufactured. So clearly, both from a opportunity standpoint, post-COVID performance and vaccine tourism, do you see India doing better in the next few years?
Well, I will say definitely the post-Brexit, post-COVID, during COVID and pre-COVID as well. India has been a very strong partner for Britain. As you might have seen, 26th, Boris Johnson was supposed to be here in India. And we were talking about a trade treaty, which will be 100 billion plus, one of the largest. So, of course, India is second largest investor in this country. And India is a very promising partner. What are the sentiments? Sentiments are quite strong in terms of India. So if you will see, everybody right now, they're singing and dancing about India and their relations. You go to any accounting firm, law firm, or banks, they have got special desks for India. So India has always been, and since I have been in this country since 2008, I'm saying that the interest for India is not coming down. It's just going up. Of course, when investors talk to me about investing into India, their first concern, as we all have addressed, tax, setup, how regulatory framework will be, local directors. There are various issues. But in spite of all that, most of my clients, and generally also, they know India is an opportunity. I'll specifically talk about one sector which I have seen. I'm seeing there's a huge boom right now, and in past, during COVID, I have been working on some of those transactions on various aspects. Gaming industry in India, central legislation is as old as 1835. Now 1835, there was nothing like online gaming. It was more about gaming house and running gaming house. So there's a perception that gaming in India is illegal, which is right. But what about online gaming? When I say gaming, I mean gambling. In India is wrong. But how gaming and gambling, they relate to each other. They are gaming companies which are sitting right now outside India, and they're quite enthusiastic about entering into Indian market, but there's lack of clarity. Indian
So,
government Dream
Ajit,
11 judgment was.
what does need to change specifically when it comes to gaming? Give us specifics. Give us one or two examples of what. For example, gaming is new. Yesterday, I was talking to a large fintech company which is in the blockchain world. Luckily, blockchain cryptocurrency was banned by Supreme Court 2 years back, and last year the ban was lifted. So.
So it's something as simple as fantasy sports, which is a very exciting subject. There is an element of chance over there, but it's primarily skill. You know your team, you know your player, and you choose them, and you form your own team. Now, there has been a very progressive judgment by High Court, and then Supreme Court also gave its blessing. But after that, there is no legislation. So the fintech industry moves much more faster than government regulations. Now, if there are no regulations on that, so the Dream 11 format is good, okay? But that doesn't mean that any fantasy sports company, they won't be scrutinized by judiciary, okay? There might be a litigation, and it will take a long time to find out whether they were gambling or they were gaming. Fantasy sports is a subject which has been legalized in India, but in what format? There is no definition of a fantasy sport. What is that line which should not be crossed? So each company,
hence,
operation.
What do policymakers need to do to simplify?
We need to
and to be while put the checks and balances in place, because our financial system is conservative and it works for us. So what are the specific interventions needed?
Well, I think the recently government has came up with a draft regulation, but draft regulations, they are not law. It's more sort of indication. I think there should be a proper legislation where we define, fantasy sports, as I said, each and every large gambling gaming company, they want to enter into Indian market, but there should be clarity. So there should be a regulation, I would say, in a nutshell. There should be a regulation to regulate that. There should be authority or institution. If there's a dispute, you can address it. So that brings a kind of certainty rather than being in a territory which might be considered a gray area. Most of the investors, they will, in any case, all these gambling companies, gaming companies, they're operating in India right now. Okay, all big names. So why don't we legalize it or come up with a regulation where investors are confident, or those who are playing on that platform, they are confident their money is secured. So a proper regulation.
Okay, let me bring in Mr. Badri Narayanan. Mr. Badri Narayanan, you heard all the other three panelists. Give us some, we are about 7 days away from the budget. Budget is a huge instrument to bring about change, to showcase intent, to showcase vision. What do you think the finance minister can do in the budget to be able to give investors more confidence and improves India's kind of attractiveness to the investors and people who do business with India?
I think great question again, Anurag. And I'm gonna talk a little bit about what my expectation is from the budget. And to be honest, it's not a very high expectation. We all know that the government today doesn't have money because over the last 6 months or so, it has not collected a lot of money. So today, a lot of the thought right now is, are they going to introduce something like a COVID cess? Are they going to introduce some kind of an additional tax measure in order to be able to do that? So you do understand that government has spent a lot of money this year on various things, COVID vaccine, on moratoriums in the banks, and so on and so forth. There has been a slowdown in terms of this thing. My hope was that if you're able to have some kind of a rationalization of rates, some kind of incentives, some of the things that we keep missing out are on giving incentives for setting up units in areas where you want development and so on and so forth. But having said that, we can always be surprised by what the finance minister pulls out of the bag. couple of things I just thought I would comment on, like some of the points that the other panelists have raised. On online gaming, for example, is again an area which I've been involved for the last 4-5 years. So for example, you take one of the issues is of income tax and GST. If you take the amount of money that ultimately goes out of the pocket of the winner can be as high as 50%, 55%. So for example, you have a 28%, 18% to 28% GST, and you can have a 35% TDS being applied on a transaction, and suddenly you find that it is no longer as attractive as it was made out to be because there is a fee. Sometimes I find that some people come and complain the fee that I earned, the service fee that I earn from an online gaming transaction is less than the tax that I have to pay on the transaction itself. So it's just ridiculous, right? So I earn 5%, I have to pay 18% tax. Okay. So that it automatically kind of de-incentivizes people, and it kind of moves the industry below the
And the industry doesn't grow, then in the medium and long term anyway, there is no tax.
Yeah,
There's no,
and you go underground, right, Anurag?
and
So
there's no contribution to the GDP.
when I want to play, we will play whatever happens, right? We'll find a workaround, enough workaround that. Second is, for example, without much, discussion, our states tend to kind of ban these sports without really understanding. For example, Tamil Nadu, Andhra Pradesh, Telangana has banned in some form online gaming. Okay, they're trying to come and convert what used to be a traditional public gaming house, which used to be in the brick and mortar area, to your room. They say if you have a room and you have a computer from where you can connect into an online game, it's really considered to be a gaming house now. So effectively, you converted your own house into a game, and they're coming into your doorstep to kind of regulate you. So variety of issues, if you can improve. Just one other point I thought it was like the new age industries which are coming is where we really need to invest. Okay, like I had a lot of hope in agri-tech, and I do hope that we are able to do that. See, reason is because our rural population is kind of moving out of agriculture and has to move into industries which is going to be able to. Typically, they used to move from the rural sector to urban India. There was nothing in between to transition them. So a lot of people used to go back. There used to be a lot of this thing. So for example, if we can improve food processing industry in India, where it can automatically go from an Indian agriculturalist moving to a food processing industry much easier. Decentralized food processing, if we can improve, there's so much of activity which can be done. If you take, for example, the horticulture, which is outside the usual APMC laws, the kind of development and innovation that have happened is tremendous. So again, an area where I think if we can posture well, and there are a lot of things that we can pick up from other countries, Europe, UK, US, which can really help and improve our agriculture. And that's one area where since 91, where the rest of the economy was reformed, that was an area which is not reformed. And last, I just want to touch on healthcare. Okay, similar to education, we are having a lot of issues in healthcare. So, for example, when I work with hospitals, they have a problem. Okay, again, we have the same notion that they should be charitable, that they must give free beds, they must do all of these things. So you again have a structure which is a problem. So just like Seema and Suhail said in education, we again have these not-for-profit, Section 8 companies, which are the core companies or trust companies. We cannot earn revenue. And then you have other companies having to do service lines and service fees from where they're really earning the money. So the structures in these are not, and again, healthcare is one area where I expect after this COVID, where so much of awareness has happened in India, there can be a huge boost, okay, both for the purpose of Indian healthcare industry as also as an export market. So these are certain areas where I thought there can be a lot of improvement. And I hope some of these are addressed directly or indirectly by the finance minister in the budget.
Thank you so much. We are coming to the closing time. So I'd want a quick comment, short one from each one of you. I'll start with Ajit. And the comment I want from you is, if you have to make one prediction about what will happen in a positive way in the next 12 months as a policy tweak, what would that be? If you had a premonition, or you had in the knowledge of something where you've been able to evangelize a certain practice or a certain tweak, give us one prediction or one area where that over the next 12 months there'll be a policy tweak and it will make the ease of doing business in India better. It will make India as a investment destination better. So Ajit, what would be that prediction?
Well, I will say this whole initiative of ease of doing business in India will move from only from states, I will say Mumbai and Delhi, and now Calcutta is also there. It will move to other states, and basically all these states coming together, they will give a kind of push, and this entire scenario of ease of doing business, that will become a kind of nationwide rather than restricting to too few cities. Yep.
Okay, Seema, your
I think one initiative that the government would be taking going forward is they have enough of policies right now, and stabilization of policies is also being talked about. I think the sensitization of the officials enforcing and implementing the policies, I think that would be the focus of the government, so that the bureaucracy and the babus who are implementing the policy really make it as ease of doing business for the people who are in India.
okay, Mr. Sunil Nathani.
Anurag, two situations. One is what we know will happen. And I'm going to add one wish list, and very briefly. What we know will happen is that e-governance will drive the way forward. As we heard Badri say, faceless assessment for tax, online filings, all that will come up in a big way. And that will reduce the interface with government officials, which is very good. Second, what should happen, the largest litigator in this country is the government. And the government needs to get out of litigation with its population. It creates uncertainty, it creates mistrust, and it only delays the process. So as they have done with Vivad Se Vishwas in tax, government needs to start settling its commercial disputes as well, so that economy flows. Government is the largest litigator in the country. And where they need to have a rule of law.
And they're taking a hard line. They were taking, at least till some time back, they were taking a very hard line thing. You know, this is my way or the highway.
You're saying hard line, obnoxious positions. Yes. And the fact of the matter here is that when a criminal spends more time waiting for a trial than the time he would spend if he was convicted, you know your justice system needs to be reformed, and that's what I hope will happen.
Okay, I think, you're four very senior practitioners, I would say leaders of the legal ecosystem in India, and legal ecosystem is a major advisor to businesses, and business need the right framework and right advisors to grow. By the way, I keep saying, if you look at UK, US, the GC, whatever, the head of legal sits on the board. And if the head of the legal says this direction for an investment is a no, it doesn't happen. I think GCs in India also need to be part of board. Legal advisors, whether it's internal or external, have a lot of weight, I would say, in the board, but they could do with more weight. Okay, so thank you for being great panelists. I'm sure as we enter 2021, our dream of being a 5 trillion economy by 2025 and being a 10 trillion economy by 2030 will only happen if the ease of doing business gets even more rationalized. It is in sync with what happens globally. And more importantly, there are new sectors of the economy which need to be looked afresh. Badri talked about gaming as an example. We talked about healthcare. So clearly there are new sectors that, we cannot look from our past, frameworks. We have to look at them from evolving standpoint, because they're really, really evolving at a breakneck speed. So I'm sure government, through its interface with the industry and, its own understanding of how businesses are attracted, will be able to simplify the framework and strengthen it on all the three cases of capital investments, labor/personal, and most importantly, land when it comes to manufacturing. So thank you for joining BW Legal World in this conversation. We look forward to seeing you in the evening at the BW Global Legal Leaders Awards. It's at 7 p.m. Most of our jury members would join. Of course, this year we've done it virtually. Hopefully, the third edition would be back physically, where we'd see each other face to face. But for today, we will do with the virtual edition, and I look forward to seeing you at 7 o'clock. My and my team's gratitude for joining us today. Thank you. God bless you. Over to you, Bhavna.
Thank
you so much. Thank you. Thank you to all our incredible panelists for joining us today. Thank you once again for your valuable time. So, well, ladies and gentlemen, what an engaging panel discussion that was. And definitely we've got some work to break into the top 50, but definitely the ideas shared by the panelists coupled with the optimism has shown us the right path today. Well, ladies and gentlemen, now after these three amazing panel discussions, as Dr. Batra was rightly talking about award ceremony, which is going to be happening at 7 p.m. IST, I'd now request the team to cue in for AV, wherein we're going to be seeing what the jury meet was all about, what led to these awards, and let's look at that AV to know more. Could we have the AV, please?
When you talk about experience, it has to be stated with certainty. It has been an excellent and beautiful experience. You meet young minds and middle-aged minds, come to know their CV and their achievements. Being a part of the jury, sometimes it becomes difficult to finalize, but our duty is to give the stamp of approval to the winner. In spite of the task being difficult, it's a pleasurable duty. And if I can put it in a different way, to borrow a phrase from a great poet in English language, it's an unbearable pleasure. To explicate, the pleasure is really quite a lot. As has been told, there has been a number of categories we have considered with keenness and due deliberation. Our attempt has been to judge from various angles and in a holistic manner. The persons who have joined this award competition, I must congratulate them for their sense of participation. Anyone might have achieved anything in life in this profession, but what matters is the public recognition. I must congratulate the participants, and I must congratulate without any kind of reservation the business world to organize such an event. Thank you very much.
For the first time, I am making a jury of selection of large number of awards. I was a jury for selecting one or two awardees, but this is a business world has taken so many awards, running into almost 30 awards, more than 30 awards. I think it's good that you are promoting the legal fraternity in all fields, so they will be encouraged to do much more, especially youngsters. Some of the topics you have selected is very good. New emerging lawyer, new lady lawyer. I think you are representing all sectors, from juniors to the senior most. Good that you are doing wonderfully well. And some of the awards I think we have to rethink next time. But by and large, it's absolutely a wonderful experience.
There has always been an intimate connection between the law and business. However, with the exponential growth of economic activities in recent years, that too having cross-border ramifications, legal issues are also becoming complex. In this scenario, role of lawyers is becoming more and more significant. It needs to be duly recognized and appreciated. With the launch of BW Legal Leader Awards, BW is doing a great service to not only the legal community but the business world as well. Though only in its second edition, these awards have already achieved tremendous reputation. I congratulate BW for this pious and pioneer venture.
Well, ladies and gentlemen, what a great jury meet video that was. And I'd like to say that we've got the awards happening at 7 p.m. Indian Standard Time. So we're really excited that you all joined us. And now, after 3 incredible panel discussions, ladies and gentlemen, it is now time to revert to our keynote session. Well, we are very honored that we're going to be joined by Mr. Nishit Desai, founder Nishit Desai Associates, who will be sharing his visionary thoughts on legal practice for future. And ladies and gentlemen, to take the conversation forward, we're also going to be joined by Ms. Ashima Ori, the Managing Editor, BW Legal World, and Senior Editor, BW Business World, who's going to be joining us live in one of the start at the BW amazing event organized. So I'd now request Ashima to take it forward with Mr. Nishit first. Mr. Desai, firstly, a huge welcome. We'd request you to please put your video and audio on. Thank you for joining us. And thank you, Ashima, for giving us your valuable time as well.
Thank you,
Thank you,
Bhavna.
Mr.
Thank you so
Desai.
much.
Over to you, Ashima.
Thank you, Bhavna. Good afternoon, Mr. Desai. Thank you for joining us today for Crystal Gracing into 2021. So the way Nishit Desai and Associates is looked at today is a melting pot of culture, purpose, the firm with the path-breaking knowledge management, a forerunner in innovation and legal services with trailblazing firm policies. So we'd like to know, what is your vision of the legal practice of the future? Over to you, sir.
Thank you very much, Bhavna. Thank you, Ashima, and honorable jury around, and all my dear audience. Thank you very much. I'm delighted to be here, and it's a privilege for me to be speaking to you all. And I consider this as privilege because I can express my thoughts about some of the things that I'm thinking for quite some time, and also some of the things that we are working on. So once again, thanks everybody. I think when you say what is the vision of the future, and as has been said in many ways, that vision is the art of seeing the invisible. So if I trip on something, it's more of a fuzzy logic at many a times, so it may or may not be accurate, may happen, it may not happen, nobody knows. But that would be my pleasure to be sharing with you. As I see, I think there are 2 or 3 things. One, on a slightly mundane or broader level, when I look at the law firms and the role of outside counsel, that itself is undergoing change. You must have observed that most of the compliance is getting automated, and it's already automated in many ways, and it's getting more and more of so. Next comes transactions. Now, today we spend a lot of time in doing transactions, negotiations, and debating the issues and all those kind of things. But even transactions in next 5, 7, 10 years will be automated with the blockchain and Ethereum kind of technologies coming in. So even transaction will go slowly out of the hands, except when there is some highly, judgmental issue the limited role will be there. Of course, still something would be continuing, but at the same time, as I see. But the role of an outside counselor, a lawyer, is going to be, of course, litigation I'm not touching at the moment, but role of a lawyer would move to more strategic and ethical issues. So, where it would be very important to, see where we are going. It's just not about knowing law. It's just not about doing transaction. It's about being strategic about it, about being creative about the whole thing. As you all know, that in the age of what they call information age, right? What has happened is the hierarchy of information age is somewhat like this. At the bottom is data. So in the 60s, 70s, it is all data economy. And then, of course, now also is there, but in a different form. But when you collect data, when you organize data, it becomes information. When you interpret information, so we have an information age. Now, when you interpret information, it becomes knowledge. Okay, so we are entering the knowledge era now. And when you add experience to knowledge, it becomes wisdom. Okay, this is how broadly it's the hierarchy. So from data age to the information age to creative, knowledge age to wisdom. Now, in between, what has happened, that knowledge alone is not enough. You have to be creatively applying to solve the problem. So therefore, we are getting into creative age. So this is how role of a law firm and lawyer is going to emerge. Number one. Number two, that we'll have to now constantly focus on future of law. I think so far we always relied on precedents, we relied on past judgments and past experiences and stuff like that. Now you have to look to the future and see that, how do you address the issues of the future? Every new technology, every new business model, every new social, political, or economic development brings along with it a new strategic, legal, tax, or ethical issue. And just to share the way in which we look at is we do trend assessment and forecasting going forward 3, 5, 10, 15, 20 years from now. Look at what new technologies will be coming. What are the new business models that will be emerging? Because technology alone is never enough. There is always a business model, and that takes it to the market. And then after, of course, you have to look at the social issues and the political, geopolitical, and economic issues. So when you look at those ones, then you are able to get some idea as to what is likely to happen. The future may be uncertain, but it is not unthinkable. So in the approach that we have, we call it anticipate, prepare, and deliver. That means we try to see what are the trends, 100 trends that are emerging, anticipate, shortlist some of them, and then try to visualize today what will be the legal, tax, ethical issues of the future. And it's a visualization exercise because law doesn't exist today. So you have to visualize a lot of tomorrow and be prepared for the situation to arrive. So when the time comes, then you are 60, 80% ready. Then you apply your current environment and fit into that, the new legal, tax, ethical issues. And so that is how we have to now look at. So far, we looked at the past and developed ourselves. Now we have to look to the future, and that is how the new age firms have to go. Second thing that we have seen lately is that even most of the organizations which are highly sophisticated, they are very picky about the law firm using technology to deliver the services in terms of actual implementation. And the security systems, they are now changing, and because the data of the client
and information is so critical that they cannot see that anybody remain in the whole chain a weak link, you know. So just to give you an example, and some of you already know about it. So now we are even getting prescriptions to say that how not only the information will be provided, but how it will be retained and how it will be destroyed or it will be shredded. So even shredding has a special process to that, and evidence has to be kept as to whether information is shredded, and all the technologies that go out, you know, have to be, you know, very well secured. And as we know that more and more organizations are going virtual, there's more work from home, and so the law firms are getting, you know, little question on what kind of checks and balances you have, where people sitting at home while they're working, they are not copying something, they are not printing out something, they are not transmitting information or doing something funny with the whole information. So there is a whole what I would call use of technology just for the safety and security of client information. And we are being asked a lot of questions at times. And so this is the other part. So this is about technology. As far as the social issues are concerned, I think the firm of the future, what is being talked about here, is that the expectation of the society would be, and even the corporations, particularly sophisticated corporations, when two firms are almost equal, they try to look at which has more gender equality, which has more diversity, which is, you know, more socially responsible. And those kind of things are again looked into at the time. So when you shape a law firm of your own, just bear in mind that there are certain obligations and there are some, you know, new principles are coming up, which not only companies or corporations have to follow, but also law firms are expected to follow. Now, so these are some of the thoughts that, as I see and as I understand, that the future law firm, I think it would not be necessarily very large, but so its size may not be so much of an issue, but what is called the scale and the depth of knowledge, depth of understanding, that becomes more relevant when using information. Information is all going to be available free. At one point of time, information was most expensive. Now it's free. But use of information and using them creatively is going to be the next level of, you know, evolution that law firms will have to get into. And I'm sure that some of the very reputed firms here I see, they're all into that phase, but at the same time, it is very important to bear in mind that these are the new nuances that are coming up. I do not know how much time do I have, but I'll be happy to take some questions. I think if anybody has any question, that would be even more interesting. I do not know if that's possible, or you want me to do that, or want me to go on?
Thank you so much, sir. And I'll pose a question on behalf of the people that I know would be wanting to know. Sir, when we speak of legal tech and collaborations with law firms, what are the emerging opportunities for lawyers in this space? Do we see, say, law firms in India opening to marketing anytime, and digital marketing experts coming into this space? How do you see that panning out?
Of course, let us understand the difference between marketing and selling. You know, selling is hardcore wheeler dealer, okay, in general terms, you know. So selling is slightly different from marketing. Marketing is what I would call is a subtle thing and a different thing. Communication is a core of marketing. Now you can communicate in many different ways, you know. And so communicating your expertise, communicating your, you know, thoughts, communicating your ethos, all that. So communication is going to be very, very important. So when you say selling, it's just going and doing hard selling. Okay, I want to work,
please give me a work and all that. That's not the way to go about. I think in legal profession in particular, two things matter. Number one, that you actually you do marketing by content, by demonstrating your knowledge, okay, by demonstrating your skills in many ways, rather than asking for a work, because work should be following. I think that is not so respectable in many ways, right? And so we must understand that, and how and different audience have different way of looking at it. There is no one single audience. I remember at one point of time that if you wanted a business in out of New York, then if you don't wear suit below $5,000 Xenia suit, you're considered okay. Come .com, boom, and Yahoo CEO is inviting all the bankers, and he was wearing jeans and his legs were on the table. And then after bankers, especially in Silicon Valley, started changing all the dress code. So they all went for jeans, and I think some fashionable people like you believe that even toned jeans are better. So actually toned jeans were meant for poor people. Now it has become the recipe for the rich.
Also called the distressed jeans, coming from the distressed side of the society.
I think distress is another area of specialty. I don't practice, but I'm just joking. So I think, please do understand that difference, And for example, even councils at one point of time could not hand over business card, right? Now that has become slowly common because they want to contact. Now in business cards are going out of fashion. Okay, so different constituencies, expectation will be different, so you to know what is the need of the client, how does he perceive. There is something called client segmentation. There's a whole science, or I would rather say, better than I know, is that you understand that what is the client segmentation and try to understand the needs and tell them that this is what it needs to be done. And there's a very nice book, if some of you are interested in reading that, all-time favorite. It's called Discipline of Market Leaders. Okay, Discipline of Market Leaders says, how do you become market leader? Okay, very simple. Two things: choose your audience and narrow your focus. If you do not know whom do you want to serve, you will be lost in trying to do everything. So we have found that very effective. We don't try to do everything under the sun, but choose your customer, narrow your focus is the name of the game. And you can create a lot of value. So again, I'm not being judgmental on one or the other. There are many other ways of doing it, but it is at least one of the ways in which you can do is that figure out what you enjoy the most. When you choose a client, as a professional, what do we want? We want excitement of doing work and doing good work. Sometimes you lose or win, doesn't matter, but you do good work based on your ability. And that sincerity itself is marketing. Okay. And I would think that is something we have to bear in mind. And sometimes it's a game of patience as well, because sometimes you do something today, it takes 1-2 years to materialize. And so anyway, but I think marketing has become more respectable globally. But when I say marketing, you have to differentiate between marketing and selling. Okay, selling is hardcore selling and asking for work and all that. That possibly would still remain in a professional world, I would say unacceptable.
True, sir. And thank you for sharing your recommendation on the book. I think we're really going to grab that and read that. Also, sir, one more question. How do you see law firms now coming together in the year forward? Do we see work from home changing to brick and mortar very soon? Or do firms want to carry work from home concept on a little longer?
In fact, I feel that it will be somewhat hybrid model. As far as we are concerned, we have told people that coming to office is voluntary. Accessibility is mandatory in some ways. As far as holidays are concerned, we said you can take unlimited vacation, you are responsible. So new business models are going to be developed around freedom, responsibility, and accountability.
You cannot drive every small action of a person, sitting next to you and driving that. Those things that the behavioral changes are happening. And I forgot to mention one thing, that the strongest competitive advantage you can develop is what is called organizational behavior. And in fact, I have written a paper on that subject. If some on the website you can find, it's called Management by Trust in an organization, and by organizational behavior as a competitive advantage. Because there are three ways to compete: one, price, okay; one, product, okay; and third one is behavior. So you may not be great on something, your pricing or what you call you may not have very good this, but if you're honest, if you're nice, that itself is also a competitive advantage. So do not forget the honesty, integrity part of the game.
Yes.
And so out of the three, organizational behavior, the behavior of the organization is the strongest competitive factor. Okay, and that will definitely more or less likely to lead you to success. And ultimately, it will bring happiness and satisfaction, which is what the core. We are not in business so much as in profession. I think those ethos will really fructify if you just take care of those culture and purpose and behavior of the organization. I think, in fact, Tom DeLonge, one of the professor of HR at Harvard Business School, he said, people can steal people, but people cannot steal culture. And I think it's the most important differentiation you can make. And I will stop here. I have spoken too much, I believe. And
so thank you so much for pointing us to those very practical key takeaways of how you build a practice of the future with all those organizational behavior and marketing principles that we use elsewhere can be used just as well in law practices. And thank you so much for your thoughts, sir. And it's a pleasure having you here today and speaking to you. Thank you so much.
Thanks, everybody. Thank you.
Thank you, sir. Thank you.
Thank you. Thank you so much, Mr. Desai, for joining us. Ladies and gentlemen, what an incredible discussion that was. We had so many key takeaways, and definitely the legal practice has grown by leaps and bounds. And the future not only is looking promising, but exciting. So kudos to that. Thank you so much, Mr. Desai, for giving us your valuable time once again. Well, ladies and gentlemen, we are now going to be next joined by our speaker. We do have Ashima Ori right now amongst us, the managing editor of BW Legal World and senior editor of BW Business World. Well, Ashima, what a great conversation that was with Mr. Desai.
Thank you so much, Bhavna. And yes, and I think we are now joined by our next keynote speaker
Absolutely.
as well. Good evening, Mr. Nayak, and welcome to BW Legal World Global Legal Summit.
Thank you so much. Thank you so much.
So ladies and gentlemen, as you can see on the screen right now, from one stalwart to the next, let us now have Mr. Amit B. Nayak, founder and managing partner, Nayak and Nayak and Company, for his keynote on pressing the reset button. Well, Mr. Nayak, it's an absolute honor to have you today joining us at the BW Legal World Global Legal Summit and Legal Leader Awards. Thank you once again. And now, ladies and gentlemen, it is time to bring him to your screen. Thank you so much for joining us.
Thank you, Mr. Nayak. And over to you for your thoughts on pressing reset. And I'd just like to leave you with a thought and a question. Again, taking from what Mr. Desai said in a previous session, where do you see legal practice going? And when you say pressing reset, what all things are coming back to how they were?
Well, I think, I'm not a stalwart and no comparison to Nishit Bhai. So I don't think that's a fair comparison. These are all veterans in our profession and we learn from them. I think it's a very interesting discussion that I was hearing with Nishit Bhai. As far as reset is concerned, I would only say this. I think 2020 has allowed the legal fraternity to really relook at things. I remember when we got into the lockdown in March, we were the first to go and get an order, which I call as the first COVID order. When there were institutions and banks trying to enforce something, and we had to interpret a very, very sort of interesting situation where whether COVID was covered under a force majeure clause or not. Having said which, that's for the legalese. But the fact is that we were able to get an order in the pandemic, so it kept us very busy. But I think the one thing that I learned is, from physical hearings to papers, to paperless hearings and digital, I think we definitely set the reset button. To dispense with justice in a time where it was very difficult, I think kudos to the legal fraternity. It's not us in as much as it's the judiciary and the government for allowing us to have a dispensation of justice during this time. So I would think we definitely set the reset button. As a law firm, there were a lot of learnings. Working from home was not easy. Many of us did not have the wherewithal or the equipment to do so. But I think one thing that dawned upon us, and the realization that work got done. We were able to build, recover, and I think most importantly, we were able to contribute to our clients. I think it's always not the economics, but the fact that we all remain busy and were able to work efficiently through the lockdown. So to my mind, and I'll give you an illustration, we as a law firm had a webinar. I was very skeptical of it, and we partnered with Facebook. What was very as an eye-opener for us was the fact that we got 25 million viewership on that webinar. A lot of law firms did very, very successful webinars, and I must compliment each of them. But I think the ability for law firms to go into knowledge management and look at things in terms of contribution during the pandemic was definitely setting the reset button. So I reckon that I think these were great takeaways. And I think, the ability to contribute to clients' work, efficiently deliver orders in court were all things that were great takeaways for us. And I would only say that there was a great development and evolution. I think now we realize that a lot of the in-person meetings that we had, client interactions were completely digital. You were able to even develop clients or even market to clients. I think those were some of the great takeaways which I think we were sort of away from. And I think that was, in my sense, to reset. And I remember in the webinar that Mr. Bachchan spoke and he cited what Mr. Salve said. He said, India needs to set the reset button. But I think the legal fraternity definitely set the reset button. And that's exactly what happened. I think whether it was counsels, whether it was solicitors, whether it was attorneys, whether it was young lawyers, all of us definitely set the reset button. From the first 30 days to the balance couple of months, I think all of us had that great opportunity where we were able to do far and more and do active work. I think most of us were busy. I think Saturdays and Sundays were even more hectic. So as a law firm, we did the first COVID order. We did a very great arbitration, a marathon arbitration for Future versus Amazon. I think these are great takeaways for us. So a lot of work got done and keeps getting done even now. I think the challenge is whether this continues or not, and whether this hybrid continues or not. I think with challenging things in what is happening in Bombay High Court and Delhi High Court, I think the one thing that we've learned is if we are able to physically be away and still manage things, it's great. I think it's a good balance in terms of what work-life balance is. It's a challenge, some amount of discipline, but I think we've conquered that. So I think the flood of webinars, I told you about our webinar itself, and the virtual court justice system. I must compliment the judges of all our high courts, the lower judiciary, the tribunals, and the Supreme Court. I think dispensation of justice, like I said hitherto before, was one of the biggest things. And, getting counsels ready for briefing. I must compliment all my seniors, where we were able to get effective counsel briefings done, where we would wait outside the seniors chamber for hours to get into a conference. But here you knew that the Zoom call was at a time and you actually did a conference. So to my mind, I think this is here to stay. I think we managed our time more efficiently than before. And there's a hybrid model that will continue. But I think the takeaways are that you don't need infrastructure as much. People are your real skill set and your infrastructure, and technology is here to stay. So this is what I would say in terms of saying reset. And I think you've also the evolution of reaching out to your clients. I think the attention span on digital hearing is far better. I've lost my voice during the digital hearings. I think the one thing that has happened out of a lot of Zoom calls. But those are some of the negatives, but I think the positives outweigh the negatives. This is what I would have to say.
Thank you, Mr. Naik, for sharing your thoughts on that. And this is a question I posed earlier on as well, and would love your thoughts on too. What are the kind of emerging sectors in the legal and legal tech collaboration space that you see coming in 2021? Since we're speaking of opportunities, legal tech, talks, and compliances, I'd like to shift focus on the emerging job opportunities or skill sets that you're looking at for people joining the firm, and how are lawyers expected to upskill? What are your thoughts?
Well, I think the generation which is of today is far more conversant with technology than what we were. So I think they need no lessons from anybody. But I think hiring is definitely happening. I think there was a little bit of a lull because people didn't know where the pandemic was up until December. I would say almost towards the end of the year. I think now there is some visibility. So I think if the culture is going to be working from home, I find it challenging because courts are physically working. I think till there is some uniformity on that, it will be challenging. But I think people need to hone their skills. They are at home. I think reading is extremely important. But I think tech is playing such an, and look at this. You are conducting what you are. Imagine if you were to do this physically. And I must compliment your team for doing what you are, because I think it's you had Nishid Bhai, you have me, and they're all stalwarts. Bringing them together in this digital time is fantastic. So I would think these are great times, I would think.
Thank you so much, Mr. Naik. And also another question on, they say that there's no elevator to success. You have to take the stairs. Now, for a young lawyer now, what do you think those stairs look like? How steep is that climb? And your message to all the people in the fraternity?
Well, I would just say this. There is no substitute. The work comes to the worker. We can all be very fashionable and it can be all of technology. But I think lawyering is about hard-coded law. I think I would reckon that all lawyers who get out of law school must, it is a steep ladder. I don't think for the last couple of decades that would ever change. I think it gets even steeper. But I think how resilient you are and how you're able to take it. I think the generations which are of today are far smarter, more tech savvy, and more knowledgeable. So I think my message to them would be only one mantra. Work comes to the worker. Don't think there is any shortcut. The moment you think there is a shortcut, and don't be in a tearing hurry. So I would say, please wait your time and don't be in a tearing hurry. There are no shortcuts to success.
Thank you so much, Mr. Naik, for your lovely thoughts and making time for us today. And it's been lovely having you. Thank you so much once again.
Thank you so much. Thank you. Pleasure.
Thank you, Mr. Naik, and thank you so much, Ashima, for joining us once again. Well, ladies and gentlemen, this is all happening at the wonderful BW Legal World Global Legal Summit and the Legal Awards. Now, for the next round, we've got our discussion coming up with Mr. Rabindra Jhunjhunwala, partner Khaitan & Co., who's going to be adding more value with his dialogue on legal landscape of India in 2021 and beyond. Well, definitely the nuggets of wisdom laced with expertise are getting better and better. And now with this, I'd request Mr. Rabindra Jhunjhunwala to kindly join us on the stage and screen. Over to you, sir.
Thank you for this opportunity to speak at this glorious event. Very happy New Year to all of you. 2020, a year characterized by unforeseen crisis and unprecedented changes, is behind us. We look to 2021 with cautious optimism, as there is still a lot to be done. Today, I will share with you some of my views on the road ahead, the challenges that we are likely to face in various areas of trade and business, and the opportunities that lie before us, thanks to technology. Let us begin with a quick roundup of what we are likely to face in terms of policy and regulations in 2021 across various sectors, beginning with the topic in focus for many economists, India-China relationship. The Indian government took nationalist measures against Chinese interests throughout 2020 as a geopolitical reaction to border tensions. These included mandatory government approvals for all foreign direct investments coming from entities incorporated in countries sharing a land border with India, including China and by extension, Hong Kong, Taiwan, and Macau. Bans on the use and download of over 200 Chinese mobile applications, and restricted Chinese involvement in public procurement, citing national security concerns. As it stands currently, all investments, whether direct or indirect, from entities which have Chinese, Taiwanese, Hong Kong, Macau, or other bordering nation beneficial ownership, irrespective of the percentage or quantum of investment, will require prior government approval. I'm of the view that these restrictions imposed by the government are retaliatory measures to put economic pressure on China and would be withdrawn only when the border tensions between India and China are resolved. According to recent reports, steps are being taken to consider and expedite approvals in cases where acquirers have minority investments from entities situated in these countries. Further, the government recently notified certain changes to the FDI regime, granting relaxations to investments from multilateral banks and funds on complying with the mandatory approval requirements. While the relaxation will only benefit a limited set of investments, this is indeed a positive development. The global economy will surely have its eye on India and China and how they progress in terms of the geopolitical as well as trade issues. The government is surely looking to ensure a higher standard when it comes to ease of doing business and addressing investors' concerns on this front. That is definitely the focus here. The next area that I will touch upon is capital markets in 2021. One of the most significant regulatory developments expected this year is the establishment of a framework for the overseas direct listing of Indian companies. At present, the Indian government has, pursuant to a recent amendment to the Indian Companies Act, included an enabling provision allowing for public companies in India to get listed overseas. However, I should add, further regulatory changes are anticipated to relevant Indian laws to facilitate this overseas listing. This could be through the introduction of a separate regulatory framework, which will provide clarity on finer aspects of the process. Moving on now to another important topic, employment and labor. 2021 is likely to usher in a new labor law regime that would further steps being taken towards consolidating the many central laws into 4 labor codes: a code on wages, a code on security, social security, an industrial relations code, and a code relating to occupational safety, health, and working conditions. For employers, here's how life may change. Engagement of contract labor in an establishment's core activities would be barred, except in certain situations. Employees engaged for sales promotion and interstate migrant workers will have certain additional entitlements. On the cost front, employers may see some impact on their expenses towards social security contributions, gratuity, and severance compensation, as these computations may have to be calculated on at least 50% of the total remuneration paid to an employee. Besides formulation of additional schemes and funds for gig workers, and I'll come to it, and reskilling fund for regular workers. Overall, several matters may have been left to the central and the state governments to prescribe by way of rules and schemes. So this year would therefore be an interesting period to look forward to on this front. Let us now discuss what lies ahead in the area of data privacy and data protection. In 2021, rapid developments are expected in the data privacy and data protection legal regime in the country. India's Personal Data Protection Bill, or the PDP bill, is modeled around the EU GDPR and is expected to be path-breaking development for India. This PDP bill includes aspects relating to rights of individuals, termed as data principles, aspects of cross-border data flow, grievance redressal, setting up of dedicated data protection authority, etc. Another development to watch out for is the health data management policy, a draft of which was released for comments from stakeholders in August last year. This policy aims to create a framework for the secure processing of personal and sensitive personal data of individuals. It is applicable to the entities involved in the National Digital Health Mission and the partners who are part of the National Digital Health Ecosystem. It will be interesting to see how the policy develops given the amount of overlap in subject matter with the PDP bill. Given the overdrive on regulating technology, developments in the sphere of data-reliant technologies such as artificial intelligence, blockchain, Internet of Things or IoT, etc. may also be on the horizon this year. A few important areas we must look out for in 2021. On the media front, a framework for government OTT platforms and another for cloud service providers. On the taxation front, clarity on applicability of the equalization levy on non-residents and further guidance on digital economy taxation. On merger control, a size of transaction-based standard to ensnare digital economy transactions may become a reality. There could be clarity on permanent establishment aspects when it comes to MNCs, which have employees working from home across more than one country. These are just a few of the many major regulatory moves that one must keep a lookout for. Now that we have touched upon what is anticipated in 2021, let us move on to the topic that is at the top of the mind for every single employer in the world right now, the future of work. In the post-COVID world, the reality that the way we all work is undergoing a period of change has been front and center for every employee and employee in the global economy. Moving forward, what does this new way of working mean for companies and the people that make those companies? I would like to share my views on some of the major aspects that we must keep in mind while discussing the future of work. The most obvious one, the reality of virtual offices and remote working. And perhaps this is the most impactful. Companies across the globe are now reevaluating their strategies and policies in an attempt to figure out what is the best way to ride this remote working wave to ensure top-notch efficiency and productivity while reducing the costs of a physical office. Tech giants have already announced longer-term work-from-home options for employees. However, how will this trend translate to Indian businesses? We will have to wait and see how this plays out here. The striking of the elusive balance between ensuring high productivity and standards and reducing costs is bound to take some time. Throughout 2021, as the vaccine rollout has started to gather steam, we may see companies trying to return to pre-COVID way of working in some way, shape, or form. But I expect many will take their learnings from the lockdown, work from home period, and apply it to a new, more flexible way of working. What exactly will this reimagined way of working look like? Well, I'm as excited to see it as you are. The second, which I wanted to cover, was diversity. You see, a diverse workforce is an asset. This is something that many industry leaders take as fact now. However, there is still a lot to be done in terms of equal opportunity, equal pay and representation. Companies across the globe have been working towards this goal for quite a while. And in India too, this is now a major area of focus for top firms. Remote workings bring with it the possibility of hiring more people with special needs into the workforce. With the introduction of new age technologies like artificial intelligence and blockchain, the process of looking for and hiring candidates can be made much more efficient and geared towards diversity and equality. I would like to revisit an International Bar Association report on the future of work, which I had the pleasure of contributing and coordinating with more than 70 countries around the world to discuss the influence of blockchain technology on the future of employment. Blockchain is essentially an encrypted electronic ledger of, amongst others, transactions, agreements, and contracts that are required to be independently recorded and verified. Each block is time-stamped, and all data is confirmed anonymously in a record of events that is spread across several parties and permanently saved. As this ledger is decentralized and does not have a central point of vulnerability, it is secure from external attack. Although Indian regulators such as the Reserve Bank of India still do not approve cryptocurrencies, the recognition of blockchain technology as a way to improve the functioning of various sectors would be seen as a positive step. Even private individuals, private companies, and startups appear to have increased the demand for talented blockchain developers despite regulatory uncertainty. As it is distributed across several computers around the world, blockchain provides access to an up-to-date version of the ledger to everyone on the network and ensures utmost transparency. This gives rise to many uses of blockchain technology in the workplace. Let me cover just a few very quickly. Blockchain-enabled CVs. You see, blockchain tech creates a medium to bring together information from various sources in a single place. I mentioned this earlier, and this technology will thus help to reduce information asymmetries and outdo CVs in the future. Equal pay and equal opportunities at work for various reasons, including maternity absence, higher tendency towards part-time work and working from home. Women are often paid less than men around the world. The transparency offered by the open ledger qualities of blockchain can lead to increased transparency in remuneration for both women and men. Finally, about gig workers and how it can facilitate payment for a cross-border, a cross-section of gig workers. Most workers in the gig economy suffer from wage penalties, lack of income, and job insecurity. Additionally, payment of salaries is difficult as the workers themselves often have to pay the charge for cross-currency payments. Such payment transfers can be completely eliminated and internationalized to any currency through a blockchain-based cryptocurrency transfer, facilitated by instant verification qualities of the technology. I can go on, but since I'm coming to the end of my slotted time, I would finally like to touch upon how India's legal industry landscape is shaping up in the post-COVID world and the biggest challenges our industry faces. The legal services market is a buyer's market in India. It means that we need to serve a very informed, savvy, and demanding set of clients that keep us on our toes. To effectively deliver quality legal services means that we need to have talent, the skills, the infrastructure to meet their demands and needs consistently and efficiently. We are dealing with a new generation of lawyers who have a different take on what they see from the profession. And we have to invest in newer ways of training and mentoring them to be skilled and client-oriented legal professionals. We need to leverage technology and all available platforms and resources to reduce inefficiency and deliver value to clients. Lawyers are now not only expected to know the law, but also to understand the client's business, their commercial and strategic objectives and priorities, their risk appetite, and even what they leave unsaid to ultimately advise on and implement business solutions. This means servicing less clients, but deepening relationships. As far as opening up the legal market to international law firms is concerned, it does not, to my mind, seem to be around the corner as of now. However, in our view, it will be a welcome move, and it would enhance the quality of legal services being offered here in India. Ladies and gentlemen, these were some of the crucial things that we must keep an eye on as we navigate 2021. In conclusion, I would like to say thank you. I would like to add that though 2020 has been a tough year for all of us in many, many different ways, 2021 offers a ray of hope. Even as global industry is cautiously optimistic, I cannot help but look towards the rest of this year with renewed zeal and positivity. The last year taught us the value of empathy, and going forward, empathetic leadership, even in business, will be what propels you and me and us forward. Well, if you want to reach out to me and want to learn about my primary sources for my presentation, or just want to connect with me, please feel free to email me or reach out on LinkedIn. Thank you very much for all your time. Take care and stay very safe.
Thank you. Thank you so much, Mr. Jhunjhunwala, for joining us. And it was an absolute honor to have you with us today. Well, ladies and gentlemen, this is all happening at the BW Legal World Global Legal Summit and the Legal Leader Awards 2020. Well, right now, it is time for us to view in the BW Legacy AV. Well, it's all about the legacy. Let's have a view on your stage and screen. Could we have the AV, please?
Presents a rich legacy of curated events that enable conversations on policy issues in India.
Because of the state of our cities, we have no option but to build smart and resilient cities.
Digital India is more for the poor, underprivileged, and the deprived.
Covering a range of topics, BW Business World events look to create a strong narrative around smart cities, digital India, healthcare, Swachh Bharat, human resource issues, education, banking, and finance, among others.
The world is fast changing. Best practices are available now on the net.
विकास डेवलपमेंट पूरी राजनीति में ये फोकस बन गया है.
BW Business World events provide a speaking platform to the voices that matter.
स्मार्ट से ताल्लुक यह है कि हम जो बेसिक एमिनिटीज हैं उसको हम चुस्त दुरुस्त करें.
You don't have to be a technologist. You need to understand how technology influences the world.
Mahatma Gandhi was a great man. He was the leader of the freedom struggle.
We believe that e-governance and IoT will play a very, very important role.
BW Business World is an excellent exhibition platform that helps you showcase your services to the right audience. To be a part of our legacy, write into us at partner@businessworld.in.
So, ladies and gentlemen, wow, that was great knowing about the BW legacy, but it is even better if we know about the group in total. So, could we have the next AV talking about the BW business world? Could we have that AV, please?
In the world of business, when you think business, you think BW Business World, spanning across platforms from print to the fast-growing digital space, from custom events to insightful industry books. BW Business World continues to capture a critical market space. Enjoying over 1.2 million engaged reader base, we have replicated this success in digital, with a 6-fold growth in the past 1 year. So who is the BW audience? Our magazine readers are the cream of the crop business professionals spread across industries and niche communities. BW Digital engages with a much larger audience, hailing majorly from India and US. We also reach diverse markets including UK and Saudi Arabia. The BW Print universe comprises of BW Business World, BW Smart Cities, BW Hotelier, BW Applause, BW Education, and BW People, each profiling industry leaders and niche sectoral stories. BW Digital communities target niche segments like startups, CIOs, smart cities, defense, amongst a range of other fields, with a following of millions of unique digital users. BW Business World is an industry leader in curating a plethora of IPRs. With multiple industry stakeholders under one roof, BW IPR events generate superlative content. BW Engage offers bespoke brand solutions across functions with inputs from the award-winning BW editorial team. We design and execute a 360-degree marketing model, resulting in top-of-mind recall and a large BW Engage client patronage. Why engage with us? We have an award-winning editorial team. We forecast new scoops and future trends before any of our competitors. We provide 360-degree brand solutions, and our clients are always happy with the ROI. This is just a glimpse of our client endorsements. To subscribe to our print patronage, visit subscribe.businessworld.in. Follow us on Facebook and Twitter. You can also connect with us on WhatsApp on businessworld.in/WhatsApp.
Well, so you know the social media handles wherein you can stay connected with us. Ladies and gentlemen, now it is time to view in the jury AV because it's all going to be happening. The Legal Leader Awards 2020 is going to be happening at 7 p.m. Indian Standard Time. And it is now time to view in the jury meet AV. Could we have the jury AV, please?
When you talk about experience, it has to be stated with certainty. It has been an excellent and beautiful experience. You meet young minds and middle-aged minds, come to know their CV and their achievements. Being a part of the jury, sometimes it becomes difficult to finalize, but our duty is to give the stamp of approval to the winner. In spite of the task being difficult, it's a pleasurable duty. And if I can put it in a different way, to borrow a phrase from a great poet in English language, it's an unbearable pleasure. To explicate, the pleasure is really quite a lot. As has been told, there has been a number of categories we have considered with keenness and due deliberation. Our attempt has been to judge from various angles and in a holistic manner. The persons who have joined this award competition, I must congratulate them for their sense of participation. Anyone might have achieved anything in life in this profession, but what matters is the public recognition. I must congratulate the participants, and I must congratulate without any kind of reservation the business world to organize such an event. Thank you very much.
For the first time, I am making a jury of selection of large number of awards. I was a jury for in selecting one or two awardees, but business world has taken so many awards, turning into almost 30 awards, more than 30 awards. I think it's good that you are promoting the legal fraternity in all fields, so they will be encouraged to do much more, especially youngsters. Some of the topics you have selected is very good. You emerging lawyer, lady lawyer. I think you are representing all sectors, from juniors to the senior most. Good that you are doing wonderfully well. And some of the awards I think we have to rethink next time. But by and large, it's absolutely a wonderful experience.
There has always been an intimate connection between the law and business. However, with the exponential growth of economic activities in recent years, that too having cross-border ramifications, legal issues are also becoming complex. In this scenario, role of lawyers is becoming more and more significant. It needs to be duly recognized and appreciated. With the launch of BW Legal Leader Awards, BW is doing a great service to not only the legal community but the business world as well. Though only in its second edition, these awards have already achieved tremendous reputation. I congratulate BW for this pious and pioneer venture.
So, well, ladies and gentlemen, that was for the jury, AV. And thank you so much to our incredible jury for giving us your valuable time at the jury meet. Ladies and gentlemen, remember that the Legal Leader Awards 2020 is going to be happening at 7 p.m. Indian Standard Time today, and we're eagerly awaiting for the same. Well, now it is time, after such incredible panel discussion keynote sessions, to move on to our next session, which is going to be on the arbitration and enforcement of the awards. Well, ladies and gentlemen, with this, we're going to be joined by Mr. Hiru Advani, the founding and managing partner Advani & Co., who's given up his valuable time and is going to be joining us. Also to welcome alongside with me is going to be Ashima Ori, the managing editor, BW Legal World, and senior editor, BW Business World, who's going to be joining us on the stage and screen to take the conversation ahead with Mr. Advani. So I just request if Mr. Advani could just unmute yourself and please put the video on. Thank you so much, Mr. Advani, for joining us. There, we can see you right there, bright and shiny. Thank you so much, sir, for giving us your time. I hope you can hear us.
I can hear you.
Perfect. Thank you.
But my video doesn't seem to be coming on.
Good evening, Mr. Advani. We can see you perfectly fine.
We can see you. Don't worry. We can.
Okay.
Perfect.
Good
Ashima,
evening.
over to you first. Thank you.
Thank you so much. Good evening, Mr. Advani, and welcome to BW Legal World Global Legal Summit. Earlier today, Mr. Advani.
Good evening, everybody. And thank you, Business World, for inviting me for this rather wonderful occasion. And I'm going to speak briefly on arbitration and enforcement of awards, because as you can see, the whole country, including the law minister and various judges, have emphasized that India presently is somewhat low on the ladder of ease of doing business. And one of the reasons is that we're not able to enforce our contracts in the way we want. The significant events in arbitration have been, of course, first the 1996 Act, which was based on the Yunsin trial model. Then we had the Ajit Shah Law Commission doing valuable work. And then thereafter, Mr. Justice B.N. Krishna, who of course proposed the 2019 amendments. And the bigger question to ask is, have we now reached international standards in arbitration? I think most arbitrators and most counsel would answer definitely not. And let's ask ourselves why. In 2015, we started off a revolution by putting a time limit of 12 months on passing of the award. And nowhere in the world have you had limits on the passing of an arbitration award. Our country was foremost and in running first and foremost a time limit, which was very necessary. There's a complete shock to our system where arbitration would take several years together with no time limits. And suddenly we were asking ourselves, do we now have to finish in 1 year? How is that going to be possible? Is it possible? I think thanks to a lot of our arbitrators, counsel involved in the arbitration, we started coming close to those time limits. We weren't exactly finishing large arbitrations in 1 year, but within reason, we started becoming 2 years, 18 months, 2.5 years. And when we went to the courts to ask for extension of time, most judges asked very sensible question: why do you need the extension? How many witnesses have been examined? What is happening? But what we didn't tackle was, what happens if a judge refuses the extension? Do we start again? Is the arbitration all over? Do we have any other recourse? And I think those are some of the questions that were left unanswered. And I think, unfortunately, a number of our judges did not take a strong enough stand and say enough is enough, arbitration closed. Since that didn't happen, it was all left a little bit in the air. I think the other major recommendation by the Justice Shah Law Commission was, if you lose an award and you want to challenge an award, then you may be required to deposit the entire money in a court of law. That, I think, was again another first, very, very salutary. And fortunately, our Supreme Court took the view that government companies are not exempt from this. However big and powerful they are, they're required to comply with the law. Under Section 18 of the Arbitration Act, all are equal, and they have to comply and deposit the money. I think this has been a very salutary improvement. My one reservation was, why give the judges a discretion? Why not make it simply mandatory that you have to deposit? Once the whole concept of discretion started, then parties were making applications. Can't we deposit 50%? Can't we give a bank guarantee? Can't we do installments? And all those kind of issues started running, making all the process more and more into a backlog. It's unfortunate. I wish they just had simply mandatory. You lost the award, pay the money into court. You're not paying it to the other party. If the other party succeeds in the challenge, then you won't have to pay the money. So what is the risk? And I think that was a small loophole left. And the other recommendation from the Shah Commission was hearings should be held day to day. And I hope there are a number of arbitration practitioners before us here. How often have you held hearings day to day? I think it is very important that we compare it to international arbitrations, where on the very first date, the entire program is set. Pleadings will be filed by so-and-so date, affidavits by so-and-so date, cross-examination on so-and-so date, and final hearing on so-and-so date. I quite see there may be some changes. There may be a number of applications for discovery, interim orders, etc. But all could be catered for if we have that rigid program from start to finish. My arbitration starts today. My following dates are blocked. Whether I have a court matter, whether I have other issues to do, of no consequences, there will be no adjournments unless for some extreme circumstances, and more on personal issues, like there's some illness in the family, somebody cannot, has some major problems. But you will find in international arbitration, very, very seldom adjournments are given and schedules are met. If we try and follow the same discipline, I think we'll go a long way ahead. The second issue is when you do an international arbitration, time limits are fixed for cross-examination. And after consultation of parties, you have 5 witnesses. How long do you think you will need to cross-examine? 4 days, 5 days, 6 days, whatever it is. Why not fix the time limits rather than just carry on and on indefinite cross-examination? I do not know yet if after the 5th day, if cross-examination fixed for the 5th day, it is not yet complete, and the arbitral tribunal says, no, this is a cutoff point. How will our courts react to that? Does that deny you a right of fair hearing, or does that not deny you a right of fair hearing? These are issues that will be considered. They have been considered internationally, and everybody has found them acceptable. Arbitral tribunals have a little bit of flexibility. They say, okay, we'll give you an hour more. Hour more means we will not adjourn the matter. Let's work 1 hour longer today. Let's work 2 hours longer today, but let's complete the job. And I think these issues are absolutely critical, and it has a bearing on the arbitrators. The other issue on arbitrators is there has been an attempt by the law ministry, which has not yet been notified, to pass on the responsibility of appointment of arbitrators to institutions. We have a number of very good institutions in the country, the Nani Palkhiwala Institution, the Maharashtra Chamber of MCI Institution, the Delhi Arbitration, and virtually every high court has its own arbitration center where the responsibility of appointing arbitrators can be passed on to them. Do we really need the court to hear extensive arguments about whether an arbitrator should be appointed or not? In view of 11.6a, where the court is only required to determine whether or not there's an arbitration agreement. Does it exist? Yes. Appoint an arbitrator. Let the arbitrator consider all other issues, whether it's issues arbitrable, whether there's a full and final settlement, whether there are other intricate issues involved, all the roles of the arbitrator, and let the court avoid that. So why do we need a court to do it? Why can't we have an institution examine it and say there's an arbitration clause, go ahead with the arbitration? Do we really need to involve valuable court time? Arbitration under Section 11, if it's an international arbitration, you need to go to the Supreme Court. Isn't the Supreme Court burdened enough with hundreds of SLPs and Article 32 petitions and final hearings, rather than having to spend their time hearing counsel whether or not to appoint an arbitrator? Surely institutions are capable of doing that. We're saying we're appointing the arbitrator, you please go ahead. Any grievances you have about the issues being not arbitrable, raise it before the arbitrator and he will decide. Please try and enforce day-to-day hearings. Make a program in advance so that the entire arbitration is completed within the year or now 18 months, whatever the time frame is fixed by the Arbitral Act. Please make effort to do that and not on the first day say, oh, this is a very complex arbitration. I hope parties will consent to an extension. My advice both to arbitrators and to counsel and say, no, we will not agree to an extension. If it becomes absolutely necessary at the end, we'll see. Or we will not on day one discuss whether or not an extension is necessary. The law is fixed. Let us follow the law and let us not bend the law to follow our own personal circumstances. Critical, always done in international arbitrations. Your program is scheduled for the next year and a half, maybe 2 years, whatever it is, but it's fixed and it's set in stone unless there are some extreme circumstances taken care of it. Having said that about arbitrations, once again, we would suggest arbitrators, please control the cross-examinations. Do not let it go on extensively. Having said that, I've also been guilty of extensive cross-examinations. I'm also a part of the system and therefore even more aware of it. And therefore, whenever I sat as an arbitrator, I was a member of the SEAC court and I'm appointed twice or thrice as an arbitrator. And very often with former Supreme Court judges as party arbitrators, I'm appointed the chairman. And the first discussion I have with them is let's fix the schedule, let's fix the time limits for arbitration. And if counsel exceeds that, let us put our foot down, not drastically, not to give a right of fair hearing, but repeatedly during the process saying, is this really relevant? Do you really need to do that? And that goes. Do arbitrators need to study the proceedings? In my view, the answer is yes. It is very important that the arbitrators know what the issues involved are, take cognizance, understand the problems involved, understand counsel's problems involved, be completely cooperative, but know the issues. Don't go blank. Don't go blank. It's like you go over and you could do an SLP where the judges have read the papers. In 5 minutes, they say nothing doing, dismissed. Right. We don't have the same powers. But surely we have the power to curtail our irrelevant cross-examination and if necessary, irrelevant witnesses unnecessarily. So control the arbitration process and you'll go a long way. On a very, very different note, third-party funding of arbitrations has now become global. It's a global phenomenon, and 10, 15 years ago, why is India still grappling? Is it permissible? Is it not permissible? Should we allow it? Should we have regulation? Should we have self-regulation? If it's a global phenomenon, shouldn't we be looking at that and passing the regulations? Should we be saying, yes, it's allowed or not allowed? What happens to an arbitration in India? The third-party funding is from England. The Spanish party is allowed. So get third-party funding, go before Indian tribunal. An Indian tribunal sitting in India says, listen to what's going on. Is it allowed? Is it not allowed? Should we be doing these kind of guesswork issues? Or should we have a little better framework of regulation permitting it so it can go ahead? Third-party funding is an international phenomenon. It's not going away anywhere. Please recognize it and please deal with it. If you want to rule it out, rule it out. If you want to accept it and embrace it like most countries wholesale. The biggest arbitration centers in the world, London, Paris, Singapore, Hong Kong. I'm not entirely familiar with US, but I would imagine US, it's allowed everywhere. Why are we lagging in? Why are we lagging in a phenomenon that's been going on for 10 years? Okay, having said that, let's say we go through an arbitration very smoothly, all works very well. What about enforcement? I mean, our government was absolutely brilliant in passing the Commercial Courts Act. What does the Commercial Courts Act say? Dispose of the arbitration in 1 year. Which courts are able to dispose it off in 1 year? You have in Bombay, Delhi, Calcutta, Madras, original jurisdiction, it's in the High Court. You have in other smaller places, be it Bangalore, Hyderabad, Pune, which are not small cities anymore. It's a district court. I have yet to see a city civil court or a district court even make an attempt to dispose of the arbitration challenges within 1 year. There's no uniformity. There's no question of the high courts controlling the city courts. There's no question of the high courts. The high court judge doing section 34, at least in the Bombay High Court, usually has 5 other assignments. It is not humanly possible. I understand there's a shortage of judges. There are many other important issues. There are constitutional matters, there are criminal matters, and the chief may be examining that with some seriousness. And you say commercial matters should be disposed of in a 1 year. Are they be disposing for 1 year? Is our act realistic? Should we make it 2 years? Should we make it 18 months? Should arbitration be put in another category? Unfortunately, these are the kind of issues that are not being looked at. As an experienced arbitration lawyer, what would I do? I would tell my client, for God's sake, don't do arbitration in India. If there's any way you can do it overseas, please do it overseas. You do it in Singapore, you do it in London, or you do it somewhere else. The courts are disposing of the matter in 1 year. So you're finally seeing a result at the end of the arbitration. So if you're looking at enforcement, I think from the last 5 years, India has gone leaps and bounds ahead. But the bigger question, is that enough? We need time, we need issues to think of it. We need chief justices of various high courts, not the Supreme Court, or various high courts to consider what should be doing. Is it a solution, or is it just once again a shortage of judges and let everything go into an abyss? I think I've taken my allotted time, and so I'm not going to say any more. I try to touch upon important arbitration aspects to try and get closer to what an international arbitration looks like. We're 50% there. We're not the balanced 50%. We need somebody to kickstart it. We need the law ministry. We need the chief justice. We need the attorney general. We need the advocate generals of the courts. Sometimes to tell the government, you don't have to challenge every award. You will not be blamed if you lose an arbitration, because in every arbitration, there's a winner and a loser. So if the government were to take one step back and say, do we really have to challenge every award that is given against us, whether it's a few lakhs of rupees or several hundred crores of rupees, or international arbitration on retrospective taxation? What is the dishonor in accepting an award? You have an award against you. You tried your best. You've done all the right things, but you fail. You will lose some cases. The government will lose some cases. Does it necessarily have to be a matter of prestige for the government to fight every case? Can't the citizen be right some of the time? A lot of the time? I think these are a few thoughts I've left for you to consider. So I want to thank the business world and thank my audience. And of course, we're all available on the email. If you have any issues or questions, we'd be happy to answer them. Unfortunately, the time is too short to do that right now. Thank you.
Thank you, Mr. Advani. And we'd really like to take an opportunity now, if you have a couple of minutes more on you, if you could just call upon our managing editor to join us right now, if that's okay with you.
Yes, certainly.
Perfect. So ladies and gentlemen, now I'm going to be calling upon Ashima Ori, Managing Editor, BW Legal World, to join us on the stage and screen and have a conversation with Mr. Advani. Over to you, Ashmi.
Thank you so much, Bhavna, and good evening once again, Mr. Advani, and thank you so much for sharing that talk with us. Just wanted to cue in what happened earlier on today. We had a panel on ease of doing business in India and breaking into the top 50 nations on the World Bank Index. And as we all know, that India broke into the top 63 at least as of 2020. And according to Economics Times report, sustained business reforms helped us make a jump of 14 places, and which was quite promising indeed. However, it also, the report also talks about how it takes 1,445 days for a company to resolve a commercial dispute, which is 3 times the average of any OECD high-income economy. Now, how can this be changed, and how can arbitration come into this and help India be top 50?
Arbitration is a global phenomenon. And if we can find a way to enforce awards within 1 year, change the face of arbitration in India. That the courts will take it seriously and say, look, we have a Commercial Courts Act. This must be done in 1 year. Let's find a way to do it. Let's find a way to streamline the process, even if at the stage of admission, throw out matters and say, look, award is fine, we're not going to consider it. Like the Supreme Court and like an SLP, dismissed. It's not permissible because we have to give reasons, but you don't have to give reasons in a 200-page judgment. You can give it in a 3-page judgment or a 2-page judgment and say, these are facts, this is the law, the arbitrator has a right to do it, let's finish it. So please, at the earliest stage, even at admission stage, deal with the arbitration. If it requires serious consideration, of course, take it further. But a lot of the challenges are quite frivolous, and please deal with them that way and give the courts the power to do so.
Thank you so much, Mr. Advani, for sharing your time and thoughts with us today. It's been lovely having you for a Global Legal Summit. Thank you once again.
Thank you very much. Thank you.
Thank you. Thank you, Mr. Advani.
Bye.
Over to you.
Thank you, Ashmina. So ladies and gentlemen, now with this incredible conversation we've just had, it is now time to watch one of our AVs. Why don't we have the BW Legacy AV? Over to you.
BW Business World presents a rich legacy of curated events that enable conversations on policy issues in India.
Because of the state of our cities, we have no option but to build smart and resilient cities.
Digital India is more for the poor, underprivileged and the deprived.
Covering a range of topics, BW Business World events look to create a strong narrative around smart cities, digital India, healthcare, Swachh Bharat, human resource issues, education, banking and finance, among others.
The world is fast changing. Best practices are available now on the net.
विकास डेवलपमेंट पूरी राजनीति में ये फोकस बन गया है.
BW Business World events provide a speaking platform to the voices that matter.
स्मार्ट से ताल्लुक यह है कि हम जो बेसिक एमिनिटीज हैं उसको हम चुस्त दुरुस्त करें.
You don't have to be a technologist. You need to understand how technology influences the world.
Mahatma Gandhi was a great man. He was the leader of the freedom struggle.
We believe that e-governance and IoT will play a very, very important role.
BW Business World is an excellent exhibition platform that helps you showcase your services to the right audience. To be a part of our legacy, write into us at partner@businessworld.in.
In the world of business, when you think BW Business World. Spanning across platforms from print to the fast-growing digital space, from custom events to insightful industry books, BW Business World continues to capture a critical market space. Enjoying over 1.2 million engaged reader base, we have replicated this success in digital, with a 6-fold growth in the past 1 year. So who is the BW audience? Our magazine readers are the cream of the crop business professionals spread across industries and niche communities. BW Digital engages with a much larger audience, hailing majorly from India and US. We also reach diverse markets including UK and Saudi Arabia. The BW Print universe comprises of BW Business World, BW Smart Cities, BW Hotelier, BW Applause, BW Education, and BW People, each profiling industry leaders and niche sectoral stories. BW Digital communities target niche segments like startups, CIOs, smart cities, defense, amongst a range of other fields, with a following of millions of unique digital users. BW Business World is an industry leader in curating a plethora of IPRs. With multiple industry stakeholders under one roof, BW IPR events generate superlative content. BW Engage offers bespoke brand solutions across functions with inputs from the award-winning BW editorial team. We design and execute a 360-degree marketing model, resulting in top-of-mind recall and a large BW Engage client patronage. Why engage with us? We have an award-winning editorial team. We forecast new scoops and future trends before any of our competitors. We provide 360-degree brand solutions, and our clients are always happy with the ROI. This is just a glimpse of our client endorsements. To subscribe to our print patronage, visit subscribe.businessworld.in. Follow us on Facebook and Twitter. You can also connect with us on WhatsApp on businessworld.in/WhatsApp.
Ladies and gentlemen, the day is only getting better. And for the next keynote speaker, ladies and gentlemen, we have somebody who's been a crusader for justice in her illustrious legal career. Please allow me to welcome Advocate Ms. Karuna Nandi, and she's going to be talking on the edges of tech, the courts, litigation, and road ahead. Also joining on the stage and screen would be Ms. Ashima Ori, Managing Editor, BW Legal World, who's going to be taking the conversation forward. But before Ashima, you join in and, as we have Karuna right here. Karuna, firstly, thank you so much for taking in your valuable time and being a part of this wonderful summit. I'd just like to squeeze in a compliment. You're looking absolutely radiant today. And thank you for joining us today. Ashima, over to you.
Thanks, Bhavna. You stole the words out of my mouth. Ms. Nandi, it's a great pleasure to have you. You're looking great. And if time allows, I'll join you back. But for now, over to you for your session, please.
It's a pleasure and it's an honor to be here. because it's in our legal community, and particularly a legal community that is global and thinks deeply about tech issues and works on them, where sort of future directions in litigation and setting the boundaries of what is allowable is incubated, if it were. So I am going to speak from experience from 3 of the cases that I have been involved in. And I am going to try and leave some time so that this illustrious audience can join in a conversation rather than Q&A. So I would encourage you to make comments and speak from your experience rather than just asking questions. Now, it is a truth universally known that technology is always ahead of, and indeed speeds ahead of regulation. This is by its very nature. However, at what speed is it ahead? And to what extent should governments and intergovernmental bodies indeed regulate? To what extent should there be self-regulation or indeed regulation by the technology itself? And does that ever work? Now, taking the last question first, I have had the privilege to represent Paytm in a very interesting litigation to enforce a blockchain technology, which is distributed ledger technology, in order to make sure that the telcos, principal entities, as in clients of the telcos, but also people who, companies that represent users who they want to communicate with on a mass basis, and then users themselves, contribute to the common understanding of data through blockchain in terms of whether the data is accurate, in terms of triangulating consent between the telcos, between the principal entities, and between users, and therefore obviating as much the need for regulators like TRAI to, and ideally the courts, to come in to determine questions of veracity of fact, or questions of whether in a particular case there was consent for use of the particular data or not, right? Now, that's a lot to unpack. I think the role of blockchain technology was somewhat overstated. It was called the sort of basis for the 4th industrial revolution. As we have seen, technology has its very important place, but it's only as good as the users that use it, right? And only as good as the regulation that is enforced. Now, Indian courts have been somewhat supportive of the technology. So in the Bitcoin case, for example, the Supreme Court set aside the RBI notification, which made illegal various aspects, which would have actually made illegal various aspects of the technology itself. But the Supreme Court very clearly, in a robust judgment, set it aside. Now, this judge, in this process, it's still sub judice, but so I'm only speaking of facts that are undisputed, and the findings of the court so far. In our case, what is under discussion is the TCCCPR, which is the regulation that looks at, as I was saying, a spam, mass communications sent by companies to their users and also to non-users in promotions, etc. But also, according to us, fraud that is committed through that unsolicited communication, right? I think that already we are seeing that the fact of the technology itself, once it is implemented, and I think there's very little being asked for. It's essentially one expected it to be entirely non-adversarial litigation, but all that is being asked for is for the law to be implemented. And already one is seeing results. I think one of the big takeaways from this is that regulators are not in the future going to be able to regulate in the same way as we understood regulation before. The nitty-gritty of the everyday, it's not going to be possible because there's a way in which the speed of tech overtakes any kind of regulation in this regard. And so what does this mean? I think it means that there has to be strong regulatory oversight, but also that while having a respectful and hands-off approach to that strong regulatory oversight, the role of writ courts is actually quite important, because it means that for writ courts to make sure that in an environment where the tech is being entrusted to private players and in collaboration, and so it's a kind of domino effect, right? Like, so if one falls, the others fall. That where there is a failure, I think it's very important for the writ courts to step in and to step in fast. Another aspect of tech that has been in the news quite a lot is intermediary liability. And I'm in terms of mass media, I'm speaking, of course, of one of the most recent examples of it is the WhatsApp new privacy policy, which says that certain kinds of data are going to be shared with Facebook, right? Now, the interesting thing there is that we see in very blatant terms and in very significant terms, the differential upholding of rights with regard to, in this case, Europeans and us. So we have the comparison of full page ads in Europe, which say that the data will not be shared, essentially. And we have sort of much more sugar puff advertising here, giving various assurances, but not these concrete assurances that are perhaps being sought by a lot of users. What's the difference? The difference is the GDPR. And the GDPR is determinative in a variety of ways. Now, of course, it's not that the GDPR has not been critiqued. The GDPR has been critiqued in terms of its extraterritorial jurisdiction, in terms of hiving off Europe and European users from the rest of the world in a particular way. For example, the Google Spain case, where it was spoken of in terms of where sort of privacy rights was spoken of in terms of the right to be forgotten, and in a much less catchy way, what it actually is the right to be de-indexed in internet search, right? However, I think that the various concrete, on balance, the various concrete rights, the privacy rights that are protected, the data ownership that is protected by the GDPR, the minors that are protected in a particular way by the GDPR is very significant, and we, of course, do have a data protection bill that borrows to some extent from the GDPR, but I think there are a number of problems with it. For example, I think there's over-delegation of powers, where the Justice Shri Krishna Committee bill, the draft bill, required a certain amount of proportionality, the necessity test, etc., which is now, it's just a codification of what our constitutional law with regard to privacy and data says already. That is basically done away with. And the constitutional categories of 19.2 are replicated, Article 19.2 of the Constitution are replicated, and the rest of the decision making is given to various, men and women that we don't know what they'll decide, right? So the need, of course, I think, is for a data privacy law which is much more robust than the one that currently exists. In addition, I do think that we all agree on the need for regulation, but what that regulation is, it's got to be through widespread consultation. It's got to be through not just talking to industry, though I think talking to industry is very important, but talking to civil society groups, talking to also other interest groups, talking to women's rights groups and children's rights groups, because we have seen repeatedly that otherwise it kind of bites you from the other side, right? For example, in the Sabu Mathew case, as many of you will know, I was an arguing counsel in the Shreya Singhal case, and the Shreya Singhal case set out law that is good to a significant extent, 5 years later. What it said was knowledge of a violation of law and regulation, the intermediary will take down and otherwise act on that intimation, and if they don't, they will lose their safe harbor, which is provided by Section 79 of the of the Information Technology Act, right? Now, what is that actual knowledge? Earlier, it was not clear. Was it the notice and take down regime that Europe has had? Which is that, if you send a notice and there's a reply and sometimes the intermediary makes a decision, or if it's just a notice, is that actual knowledge? What Shreya Singhal said was two things. One is that a court order will suffice, but it also said something secondly, which I am less happy about, is it said that a governmental direction will also suffice, right? Now, it's been modified in a few ways. There's very recently been, there's been a few judgments with regard to trademark and IP law, and MySpace versus Super Cassettes, as well as the Amazon judgment. However, with regard to speech, with regard to pure speech, the 19.2 categories must be followed. And also, now I realize I'm speaking in a very dense way because I'm mindful of time, but we'll open it up. And if any of this is unclear, please do ask any questions you have. But what I was really speaking to was the Sabu Mathew case. And the Sabu Mathew case essentially says that if there are particular words, then they can be blocked, that they should be blocked, right? And this, of course, is a problem, because if you have particular words, then you have various, you have scientific knowledge with regard to the PNDT Act. You have scientific knowledge being blocked, you have papers being blocked, you have all sorts of things, all sorts of intellectual inquiry, scientific research being essentially halted in its tracks. So what does this mean? I think that in terms of a few takeaways, a few larger takeaways of how I think as a jurisdiction we can deal with technology, I'm just going to set them out very, very quickly. One is that I think in terms of, the first thing is that we've got to have robust regulation by government. And my own view has changed since 5 years ago in Shreya Singhal, which is that actually even then I had a somewhat more conservative view than many of my colleagues. But I don't think that everything can be left to intermediaries or indeed to courts, because with intermediaries, there's too much self-interest. Plus the problem is that speech is very frequently, when we're speaking of speech is very frequently crowdsourced, and in-house regulation is not. So if you have a few people sitting in Dublin, in Ireland, or indeed in Hyderabad, it's not going to be sufficient, because they're not going to know what is hate speech. The people in Dublin are not going to know what hate speech is in Mogadishu. These are very context-specific things, right? And a few people in Hyderabad are not going to adequately compensate for that on a national level because there just aren't enough people. So I think the tech companies, particularly the big tech companies, need to wake up and need to invest a lot more. When Twitter was trying to, they were trying to sell Twitter, they realized that actually there was this business impact, and the price offered went down because of Twitter's massive hate speech problem, right? And that's when they really woke up. At court level, our bandwidth is too small. Courts' bandwidths are too small, and rich jurisdiction is too differential of these issues to go into them in such concrete ways. So government regulation, that's what is really required. It's got to be robust. It's got to be something that is good. It's got to be good regulation. Extraterritorial jurisdiction. Many of these companies are, in fact, Ashima, I'm seeing you here. Are we running out of time?
Yes, Ms. Nandi, this is Bhavna here. Yes, we are running out of time because our next slotted schedule is actually at 4:40, so we're a little bit 6 minutes already over time.
Okay.
But we'd love to hear your concluding remarks, please, ma'am. Take it forward.
Should we just stop and take a couple of questions?
No, Ms. Nandi, I'd love to have a conclusion from your side because right now our next speaker is already online. Mr. Bhasin has very kindly joined in and given in his time. So I'd just like, if you have some concluding remarks, we'd love to take that forward.
Sure. I think the second issue is extraterritorial jurisdiction. Given that a lot of the tech companies are headquartered in the United States and sometimes California, sometimes Delaware, depending on their tax structures. We want to make sure that there's a level of extraterritorial jurisdiction that is achieved. This happens, I think, sometimes by a finding of veil piercing, because in effect, there are lots of statements from Facebook as well as WhatsApp showing that in effect that they are now being run as the same company. There's an identity of interest, there's direct control. And so by our own judgments in Renu Sagar and Kapila Hingorani, etc., that veil piercing seems adequately reasonable, but also I think it's very important for us all to collaborate and to work with people who are active in other jurisdictions so that we can actually choose our forum in adequate ways, because our veil piercing law might be more liberal and might be easier to pierce veils here. However, in the United States, you have much more developed tort law, you have punitive damages, and you have ease of enforcement of judgments. I'm going to end there. Feel free to tweet at me if you want to discuss something. And thank you. Thank you, BW. It was a pleasure.
Thank you, Ms. Nandi, for giving us your valuable time. We're so sorry we had to cut in a little short due to our other speaker being ready right now. So thank you, and yes, I'd encourage everyone to please tweet in, as Ms. Nandi rightly said, to take the conversations further, as after all, this is the virtual world and this is how we'll stay connected. So thank you once again. So ladies and gentlemen, what a great day it's turning out to be. And now for our next keynote session of the day, we're extremely privileged to be joined by none other than Mr. Lalit Bhasin, the Managing Partner, Bhasin & Co., President of SILF and the Bar Association of India. Well, with this, I'd request Mr. Bhasin to kindly join us on the stage and screen. We'd request you to please put your video and audio button on so that we can place you on the stage, and we'd love to get your view started. You're right there. Thank you so much, Mr. Bhasin. Firstly, it's so good to see you after so long. It's been almost like a year and a half or two, I would say.
Thank you, Bhavna. Can you hear me and I am visible?
Yes, Mr. Bhasin, you're looking radiant as always. Thank you for joining us. Over to you.
Thank you very much. And I assure you I won't exceed my time limit. And you see, my subject is a bit controversial in the sense that many people are now supporting, you see, the virtual hearings which are taking place. By my starting submission to all the participants here and to the organizers is that you cannot administer or render justice sitting or working from home. This working from home concept will not work, you see, so far as the administration of justice is concerned. There are obvious benefits, you see, which one can see. That is, matters are being disposed of, important matters, crucial matters. The courts, the judges, lawyers, and clients are becoming more technology savvy. Even people like me in my age group, we also have learned, you see, how to open our laptops and how to operate and participate in these very educative, informative discussions which are taking place. This has also resulted, you see, in reduction in costs of litigation. For instance, if a matter is fixed in the Supreme Court, the clients earlier had to bring a lawyer from Bangalore or Chennai or Kolkata. But now that cost factor, you see, is not there. The lawyers, senior eminent counsel can participate from their respective places, wherever they are located. They have the benefit of assistance from the instructing lawyers who are also in that location. And for having conferences, preparatory conferences with the senior counsel, the counsel based in Delhi, they don't have to, you see, travel either to their location or ask those counsel to come to Delhi. So these are the cost reduction features which one can notice. But you know, as Ghalib said, कि दिल के बहलाने को गालिब ये ख्याल अच्छा है. It is all right, yes, matters are being disposed of, but what is the nature of these matters and which courts are disposing of these matters? Yes, Supreme Court is functional, the high courts are functional through virtual hearings, but the matters which come up before these courts are only matters which are considered to be urgent or important, as may be decided by the registry of these courts. Kindly look at the scenario. We are talking of virtual hearings for the wider participation of those who are in the system of administration of justice. Does it percolate down, you see, to the disposal of matters at the district level? In India, we have 3.5 crore cases which were pending at the beginning of the year 2019. Now I am told, and I say with some daring certainty, that the arrears have gone up to nearly 4 crore cases, and last about 50 lakhs in the last 8-9 months, nearly 50 lakhs cases have piled up in the various courts. So what are we seeing through these virtual hearings, about these virtual hearings? What we are witnessing is, yes, disposal of some eye-catching matters which make headlines. But what about the cases of the common citizens of this country? Are those cases being disposed of? I have seen, because I participate every day either in the Supreme Court proceedings or in the various High Court proceedings, that yes, some urgent list comes up, which is called the supplementary list, that is taken up, that is some interim orders are passed or some directions are given. Then so far as the main cases are concerned, they are just adjourned. They're just adjourned to some dates in April, May, June, and thereafter. That is how the Supreme Court and the High Courts, you see, they are functioning. There is no disposal of the matters. Yes, interim orders are being passed, but the cases of the ordinary citizens, the common man, of this country are not being taken up at all. They are just being adjourned. Again, that famous saying, Tarikh pe tarikh, tarikh pe tarikh, tarikh pe tarikh, that is all going on through these virtual hearings. My submission to the participants here is that, yes, virtual hearings should be there, but these should be like the emergency provisions and not a substitute for normal physical hearings. Like in every constitution, in our constitution also, there are certain emergency powers. There are certain powers given, you see, to be exercised in a state, in a condition where some pandemic or other things arise. But that should not become a substitute for regular hearings. What is alarming is that people are already talking of making the virtual hearings a permanent feature. My appeal is that please don't do that. In India, particularly since we have inherited the British system, all the laws, procedural laws, and the substantive laws are attuned to this. You see that their physical presence is required, particularly in the matters of evidence. And has the technology, you see, served the purpose? I have again experienced personally, you see, a complete breakdown of the technology while the hearing is going on. And even the Honorable Supreme Court, in the two benches, had to comment on that. They can't either hear the lawyers or the lawyers can't hear what the honorable judges are saying, or there is some noise element, or there is virtually a complete breakdown, blackout, and nothing happens. Therefore, technology has not come to that extent that there should be like a smooth hearing, uninterrupted by these technical snags. Virtual hearings should not become like truncated hearings, because there is no substitute, you see, for a regular, proper, effective hearing. One should not try to compress, you see, the rights of the citizens to place their point of view effectively and properly as best as possible before the courts, and that is not possible. And that is my firm view, is not possible through virtual hearing. Then I have already said about the fate of, you see, the common citizens of this country. What has happened? Administration of justice is not just confined, you see, to Supreme Court or High Courts. As a matter of fact, it is more required so far as the district level courts are concerned. And the fallacy in this approach, which has been adopted by the government with the approval of the judiciary, is that virtual hearings have started from top to bottom. That is from Supreme Court, then High Courts, and then you see they go down to the district level, whereas it should have been the other way around. If at all you have to adopt virtual hearings as an effective mode of disposing of the cases and hearings, it should have started at the district level itself. The district courts, you see, do not have that sort of infrastructure. And that also we have seen, whether it is the district courts in Delhi, and then much less in district courts in other smaller districts and in the far corners of this country. Virtually the matters are just adjourned. The judges don't even come to the courts. Sitting at home, you see, dates are given. So this is no substitute, you see, for a regular, proper hearing. And what the government should do with the help of the profession and of course with the help of the judiciary is that they must strive to revive, you see, the physical hearings as early as possible, but not as a substitute, you see, for virtual hearing. It should be proper introduction as we had status quo ante before COVID. That should be restored with sufficient safeguards in the form of social distancing, in the form of insisting upon masks, you see, when one is not arguing. But the requirement is that the district court level, particularly in smaller districts, the government, the state governments have to come forward to provide some basic tools of technology to those in the profession who cannot afford. Lawyers in district courts, you see, they are virtually starving now. I can tell you with some daring certainty. They are starving. They don't have work to do because firstly, they are not accustomed to these virtual hearings. Secondly, they don't have the tools. They don't have, you see, that facility of a laptop sitting at home that they can do it. Some of them don't even have email IDs as yet. If at all they have the facility of virtual hearing on the mobile phone. But use of mobile phones are discouraged by the courts, you see. Therefore, during this period, when physical hearings ought to be reintroduced, there is a need for the government and the profession also to step in and help those who do not have the necessary tools or the knowledge how to use those tools, you see. In the absence of these, I think we are all doing a lip service to the cause of administration of justice. Therefore, first requirement is that the government should take some steps to provide some financial assistance to the lawyers, particularly in the district courts, remote corners of this country, to meet the cost of the laptops and also to provide masks and sanitizers to the clients and the lawyers. Another step, you see, which government ought to take, and that is where the government has to take the step, you see, with the help of the Bar Council of India, is to help to mitigate the present hardships being faced by the legal profession, particularly at the district level, is to give a waiver of income tax for the year 2020 up to 2021, so far as income tax is concerned, for lawyers whose earnings are below 30 or 35 lakhs per annum. That would be a big help, you see, to the legal profession. These are my views on this very important issue. Yes, the technology has saved the situation, but for some time. It is short-lived. If we look at the overall scenario of the pendency of the cases, then it does not deal with that issue at all, and it can never be treated as a substitute for physical hearings. Therefore, time is now ripe for reintroducing physical hearings so that the lawyers who are actually starving at district court levels, you see, they do get some work. And if that is not possible, then the government should provide financial assistance, you see. And the Bar Council of India should also step in. They have enough resources, you see, to help the underprivileged and less privileged lawyers in the profession. So these are my views. I would not like to take time, but I would be very happy to answer any questions or queries on these very controversial matters which are there today. Thank you.
Thank you so much, Mr. Bhasin. Firstly, it's always a pleasure and honor interacting with you, and I'm sure all the ones who are viewing it live would equally be looking forward to your session and with your expertise be taking the legal career of theirs forward. So thank you once again for giving us your valuable time. Mr. Bhasin, also joining us on the stage and screen is Ashima, who's the managing director or editor at the BW Legal World. And I
Yes,
believe she'd
Ashima.
like to have a conversation with you on the same. So over to you, Ashima. Take it forward.
Good evening, sir. I just wanted to come in and thank you for being here with us on BW Legal World Global Legal Summit. It's always a pleasure to have you, and thank you so much for being with us today.
No, it has always been a pleasure, and please convey my regards to Mr. Batra also. I think these are brilliant initiatives which Business World Legal has taken, and keep on having these events, because during this period, at least this brings us together. That is one of the virtues of these virtual Zoom meetings, you know, that you bring us together. So please keep it up. Thank you very much. Thank you.
So it's lovely to have you. Thank you so much, sir.
Thank you, Mr. Bhasin, and thank you so much, Ashima, for joining us once again. Thank you, sir, for your valuable time. So ladies and gentlemen, with the time being right, it is now going to be time for us to go on to the next panel discussion. Well, right now it is 5:05 Indian Standard Time, and we're going to be talking about the collar crimes, evolution, trends, and the way forward, the white collar crimes. And we have a distinguished panel of speakers for the same. First up, we're going to be joined by Mr. Zulfikar Memon, the founder and managing partner, MZM Legal. We are also having Ms. Alina Arora, partner, Shardul Amarchand Mangaldas & Co. We are going to be joined by Mr. Sherbir Panag, the chair of Panag and Babu. We also have Mr. Bharat Chuk, the independent counsel session chair. We also have Mr. Samir Shah, Chairman, India International Institute of Dispute Resolution, Risk Management, Hong Kong, Senior Partner, Trust Legal. So Mr. Shah is going to be our session chair. Thank you so much, Mr. Shah, for taking out your valuable time. And with this, I'd like to pass it on to you to take it forward with your incredible panel. I'd like to once again personally thank all our panelists for giving us your valuable time. With this, I'd request everyone to please unmute yourself and put your video button on. Thank you, and over to you, Mr. Shah, for taking it forward.
Well, thank you, Bhavna, and good evening to all participants here, and a very good evening to the esteemed speakers today on this panel. We are to discuss about a very interesting and equally intense topic of white collar crime. This word has now become a sort of common area of discussion in today's world. So before we actually go into much detail with our speakers onto this, how it has evolved, so the trends happening, and what is the way forward, I would just like to put in some few thoughts, my thoughts on this particular topic, and then I would invite the respective speakers to have their views and share their thoughts on it. You see that so far as crime as such is concerned, it's nothing new. I mean, it is in our existence since the birth of mankind. In early days, the actions or the acts, what we now term as crime, were very normal, because everything was based upon the concept of survival, domination. And therefore, it was nothing wrong if the acts of violence took place as such. However, with the concept of development of rule of law, these acts were then defined as crimes. Crime against person, crime against property, crime against state, and so on and so forth. But as I said initially, these acts were more violent, and they were looked from, that's what the angle that was looked from for being as crime. However, with the development of the economies, and especially the concept of monetary exchange having evolved, a new set of crime or actions came into play, which now we know as the financial crimes. Now, these crimes were, done, carried on by everybody. Can be carried by anyone, and for that matter, devoid of his or her position or designation. But with the development of society, a particular section of our society came to be closely associated with these crimes and what we now known as the white collar crimes. These were the people who are in position, who are in power, who are established both financially and otherwise, and who have all the requirements for their worldly enjoyment, but still they commit this crime. That is what we know as the white collar crime. So that takes us, takes me to a thought as to why these crimes are committed. What's the motive? To me, I think one important motive for committing such crime is greed. Now, greed has no boundaries. Though it's subjective, depends upon person to person, but it is there in everyone. So the question then further is this the only motive? Is greed the only motive, or there is something else which makes a person commit such crimes? And then with this, the other thought or question follows is, what are we doing for this? Are there laws for curbing out these crimes? If there are, then let us understand what those laws are. And if they are not, then what more is required? What is the situation of current laws to curb these crimes, and what more further is required? So on this outline, I would be now inviting the esteemed speakers to give their or share their thoughts, their knowledge in this on this topic. But before I do that, I may just remind the panelists, and I'm sure they are also will be aware of this, of the time slot which is allotted, and to just be within the timelines. So with this note, let me start with Mr. Menon on sharing his thoughts on what these white collar crimes are, how they have evolved over a period of time in different jurisdictions, including India, and what are the trends in that? Mr. Menon.
Thank you, Samir. Good evening, everybody, to all the participants, and thank you very much to have me on this extremely talented and dynamic panel on a discussion which I think, taking cue from what you said, Samir, is the most common discussion on every dinner table today, everywhere. This is what we read. This is what is fed to us on a daily basis, because media is playing such an important role on glamorizing crime, criminals, and its effects in the society. Being a second generation lawyer, I've had firsthand experience on the evolution of white collar crime. Growing up, seeing and watching and learning from my father, who's predominantly a criminal lawyer. At that point of time, the basic criteria for any criminal lawyer was a pass out from a law school was to understand the IPC, CRPC, and the Evidence Act. That was it. And you were more or less surrounding in relation. Your matters were more or less regarding bail and petty offenses. But as time went by, the way you put it up so nicely, Samir, that greed is a dominating factor, and then the economy, came up, and then there were large companies and corporations, and then there was this rat race. So greed is a much larger word, but then within that there is the race, the corporate race to be number one, the dominant factor that is required, the territorial jurisdiction, territorial power. All of that culminates into the fact that it forces people in power and position to commit crime. So over the years, we've seen that how offenses have changed, quantum of offenses have changed. We are seeing numbers that we never saw or never read of, or probably never even imagined that we will calculate or be in a discussion with probably 20 years from now. But in the last about 2 decades, or maybe more particularly a decade, we have seen obscene numbers, sometimes overinflated numbers, but numbers which are there, and the kind of the magnitude of what scams and organized crime that has been done only in relation to gaining the financial power. So over the years, this evolution has happened. Crime, which, as I said, which emerges from greed, But at the end of the day, the financial mess is what it is all relating to. So as we discussed, laws have also come up. I mean, over the last few years, we've seen PMLA, ED, so various PMLA and ED, SFIO, all of these different agencies which have come up. There are changes in legal system that has been done. The government is playing its role, but I think there is a constant development that is happening as far as lawyers are concerned. It is very important now for lawyers to learn so many different terminologies as far as crime is concerned. It was not like earlier, as I said, that only 3 basic legislations were important. But right now, as we are going ahead, we are seeing crime as far as cryptocurrency is concerned. So there is a lot of complication that has been evolving. And as we go further, it will be very important for us to keep learning and growing and evolving.
Well, thank you, Mr. Menon, for that enlightening thought on the evolution of white-collar crimes. May I ask Sharbi to just share your thoughts on the current trends which you have seen or which are now coming up in this area of white-collar crimes?
Thank you, Samir. Samir, I think where we started off from and where the manner in which Professor Sutherland, who sort of coined the term white-collar crime, which is what we colloquially use today, for a very vast genre of financial, business, corporate, corporate and crimes, basically that have a fiscal undertone. There's been a significant movement in the genre they've taken. So traditionally from fraud, money laundering and corruption, the nuances under each of these categories have definitely changed. Mr. Memon spoke about cryptocurrency. We see, the moment there is a new mechanism of fiscal transactions, such as a wallet, for example, you start seeing issues there. The use of mediums such as the internet, that sort of becomes an area of exploitation. So I think white-collar crimes, just like any other crime, are very, very attuned to changes in society and changes in technology that come along with any given period of time in history. I think when we come to India, I'd see 3 very clear trends. I think first and foremost is the trend that that prosecution in any country is not ideal, contrary to popular belief, and neither is it in India of white-collar crime. But we are seeing an increased number in cases that are being prosecuted. I think that segues into the second issue, which is the more structural issues with what we are seeing which sort of speak to the Indian criminal justice system, which is that we have a multitude of agencies and law enforcement authorities that are addressing very similar conduct. So bribery doesn't happen in a vacuum. There's an element of forgery, there could be an element of cheating. The moment that happens, it's a predicate offense for money laundering. So there are 5 or 6 statutes that can come into place. And of course, then how did a company or an individual work that around from a tax perspective? So you have 5 or 6 different agencies, each of whom is prosecuting virtually the same conduct, each of whom has a different lens, are fairly disjointed in their prosecutorial effort. And this has 2 impacts. I think one is the impact to the victim of the fraud itself, that by virtue of having so many proceedings, the proceedings get delayed. There are issues with one law enforcement authority could trickle into the other. A good case for tax may be impacted due to an acquittal as far as the bribery side is concerned, since the underlying transaction gets a different flavor from court. So by virtue of not having centralized prosecution, I think to some extent the victim of the fraud is getting hurt, and the authorities, as far as their core mandate and objectives, are also being diminished. The second, of course, becomes the accused person, because the fundamentals of white-collar crime do not change. They remain the fundamentals of criminal law. Trial. And there has been while there is a sentiment, yes, white-collar crime, large-scale frauds that Mr. Memon spoke of, all are very, impact society in different ways. But at the same point of time, we can't take away from the fact that the rights of an accused are sacrosanct. We can't create new classes of offenses by virtue of public sentiment when the legislature has not deemed it prudent. And I think the third aspect that sort of so the first aspect being how they've moved, the second being increase in prosecution, the third being structural deficiencies in our criminal justice system, which now also need to segue into exploring other methods through which punishment and penalties can be implemented.
Well, thank you, Shabir. It does make us go further into detail of what's the current trend of tackling this white collar crime, especially in our country. And that makes me request Arina if she wanted to add to what Shabir just mentioned about the prosecution system so far as tackling these white collar crimes are concerned.
Thank you, Samir. I think all very well points, and I think Shabir has highlighted the issues that exist per se with multiplicities of agencies looking at the same corporate offense or issue that emanates. I think what I would like to bring out here is that corporate crime per se is something that has not been so evolved in our country. It's primarily the concept of criminal law has been prosecuting individuals, and our laws traditionally have catered to that. In fact, if we talk about white collar crimes like corruption and issues of corruption, and we've all been seeing a lot of scams happening, it is only very recently that our laws have started being modified and amended to cater to these situations and is moving in the right direction. And a lot of this is happening because of our presence and predominance in the global economic world. We need to get there, and sophisticated crimes are happening at the corporate level. Now, if we are to look into the future and we look at the large corporate crimes, whether it is a corruption issue, whether it is a money laundering issue, whether it is a fraud, and we've seen a lot of large financial frauds and issues that have come about. These involve the use of technology, concepts, and jurisprudence that is still evolving. Corporate criminal liability, I think, as a legal concept is still evolving. We still haven't reached the levels to have very clear laws and clarity as to how we go about it. And given the multiplicity of agencies, we are really not closing out on these cases such that precedence is established and there is a deterrence to prevent corruption in the corporate world, other economic offenses and financial issues that are, in a way impacting the economic development and the corporate world's evolution in India and therefore obviously at the global stage. So if we need to move forward and look forward as far as white collar crimes are concerned, whether it's cyber offenses, technology use, financial frauds, etc. One, we definitely need to look at our laws, revisit them, which are quite archaic, and modify and amend them to make them future-looking. We need to introduce efficient ways of investigating and prosecuting these offenses. And traditionally, we haven't seen many successful closures, whereas if we look at our counterparts in the developed world, whether it's in the US, etc., I think we can learn a lot and evolve and modify our structure going forward to come up with the construct of what I've seen in the US is deferred prosecution agreements as well as, no prosecution, depending on voluntary disclosures by corporates when red flags are identified and negotiating a settlement with the regulatory authorities and paying penalties. At the end of the day, when a large white collar crime happens, there are large amounts of public funds involved. There is a loss to the country, there's a loss to the economy. There are people who've suffered as a result of a large white collar offense or fraud. And therefore, to that extent, we need to ensure and bring about some semblance. And this may be the fastest way of at least trying to bring about that deterrence and closure and normalizing or equalizing the financial losses that we are being hit with time and again. And therefore, to that extent, when you look at these models and evaluate these models, even from a corporate's perspective, Because at the end of the day, we have to remember that a crime vis-a-vis a corporate crime or a white-collar crime, while the liability or the penalty might hit the company as well, there are individuals who are doing it. And no matter what a corporate does to try and prevent these crimes or frauds, it can never be 100%. Business has to go on, and there has to be a way to move forward and keep developing while deterring corporate frauds and offenses. And therefore, to that extent, I think we need to marry the two. There should be prosecution of individuals that are involved. There should be deterrence and there should be liabilities for that. But at the same time, we need to marry the interest and look at a solution to move forward on corporate crimes. And I think we are at a stage, whether it's cyber crimes, again, laws evolving, data privacy issues, financial information, and all the others, when you merge it together, it's a very complex and evolved and developed problems, issues that we're dealing with, and our laws still need to evolve. And I think the corporate world and the legal world needs to work together to try and come out with ways to improving corporate governance and ethics, and therefore taking business forward in a more compliant, reliant manner and reducing corporate frauds and crimes and the issues that emanate from it, which is basically financial loss at the end of the day to the large masses and the country.
Well, Alina, I think you took us to a very interesting aspect of the corporate governance part and the corporate fraud part, and especially the position so far as the US is concerned. I, in fact, had read one very interesting analysis that the amount and the scale of fraud and corruption in US is much, much higher than in our country. But the only difference is that there it does not affect the common man. But here in our country, these kind of actions or crimes directly affects the common man as such. That's the problem. Now, I'll now put this question to Bharat, who has the experience of both the bar and the bench. So far as the current situation of laws in our country on white collar crime, as Alina just pointed out, if you want to share your thoughts on that.
Sure. Thanks, Samir, and thanks everyone for contextualizing the issue really well. Before I answer that question, Samir, give me the liberty to just quickly, take a minute on the causes of white collar crime, and I think that's important because that makes today's conversation so germane and important. We've talked about greed as being one of the main motivators of why people do it, but a lot of people have looked beyond greed as well, and it turns out that it's a complex interplay of various factors which make somebody do a white collar crime. And I would strongly recommend this author, Eugene Soltys, who's written this fantastic book called Inside the Mind of a White Collar Criminal, Why Do They Do It? And he talks about this fraud triangle of preparation, opportunity, and rationalization, where there are different circumstances that shape our behavior, and pressure, opportunity, and rationalization, where and this makes it so important for the conversation today, because of COVID and all these financial pressures and companies struggling to make their targets. There is obviously a pressure on executives and decision makers to make their numbers, to survive another quarter, and that becomes one of the motivating forces. Opportunity, again, with so many government bailouts and stimulus packages, there is a greater opportunity for people to commit white collar crime, and that makes it relevant in the COVID time. The third, of course, is rationalization, where the people who are traditionally thought to be people who commit white collar crimes are people who are extremely intelligent, and they are people who have the ability to think long term and not just short term. These are not, after all, crimes of passion and crimes done at the spur of the moment. They have this extraordinary ability to rationalize their decisions. For example, an executive who's fudging an account can think, I'm just doing a small change on a spreadsheet after all. I'm not taking lives, right? And I'm doing this to save jobs. I'll put the money back in the next quarter so lives are not lost. So these three things, make a very dangerous cocktail of why people do it. Coming to the legal issues, the trends have been very, very nicely outlined by everyone else. The way I see it is, I borrowed the phrase, the good, bad, and the ugly. That's how white collar crime has proceeded. Starting with the good, I think the Prevention of Corruption Act, which largely deals with cases of illegal gratification, where a public servant is accused of having taken a bribe for having favored a particular entity. A lot of good changes have happened in the Prevention of Corruption Act, where now bona fide business decisions are not criminalized anymore. For instance, a public servant taking a decision to grant a tender to a particular entity, if that person has taken the decision, and it's a business decision after all, that you take after keeping in mind a lot of different things, just because 5 years later that decision turns out to be financially imprudent, you cannot, with the benefit of hindsight, prosecute the public servant. We've had examples of some of these scams where public servants were prosecuted for certain allegations. And as Sherbir and I were discussing, most of these cases have ended up in acquittals and discharge. So Prevention of Corruption Act stands amended. Now bona fide business decisions are protected. Corporations who are prosecuted for corruption allegations can now take the defense of having adequate procedures within the organization to prevent such a thing from happening. And if they can substantiate and prove before the court that there were checks and balances, there were procedures that a company had within the company, that can be a valid defense to a criminal prosecution. So that's the good for me, at least. The bad, of course, is over prosecution. We seem to be swinging between two extremes of no prosecution and over prosecution. And what do I mean by over prosecution? There are certain, so for example, a failed business is not a crime. Many of the cases that we today see, the so-called white collar criminals who are the poster boys, and that's how they're cut out to be, many of those prosecutions emanate from a business failure, which may not be criminal at the end of the day, which may not be fraudulent at the end of the day. But since nobody wants to be seen as being soft on white collar crime, and populism seems to be the prime motivator of legislation and executive action in some of the cases, these cases are prosecuted, and an over prosecution is extremely dangerous, because if you prosecute a business for having failed or for not having been able to repay its installments to the bank, that is a big problem, because that discourages business, discourages investment, and changes the whole climate. So problem is over prosecution. Sometimes an investigator is only thinking about making that immediate arrest, attaching property of a big corporate house as an end in itself. But that's not an end in itself. Ultimately, it's about how do you investigate, how do you try these cases. If some money has been defrauded, for instance, from the public, have you been able to disgorge those profits? Have you been able to recoup that money? Have you been able to take that money back to the pensioners or the investors who've lost that money? But nobody is looking at any of that. The problem is we are trying to look for short-term solutions. We are prosecuting people. We are making those arrests, we are making those interim attachments, but we are not able to take those cases to a fruition. And we are not, conviction rates have been dismal for the longest time. That's bad for me. Too many agencies, Enforcement Directorate, SFIO, CBI, local police, economic offenses wing, often all of them working on the same set of facts, is again a huge problem. We don't have a central agency investigating an offense. That leads to, again, over prosecution. We've seen that a single accused for a single transaction is first taken into custody by the ED, then the CBI, then the SFIO, then the local police, and it's almost like a relay race happening. And you can't normally keep an accused, as an under trial and remand him for more than 90 days. But all these agencies would take the remand in a relay. So that's problematic to me. And from the good, bad, and the ugly for me is again a compromise with, and this I say as a student of criminal law, the compromises that we are ready to make with due process and personal liberty when it comes to white collar crime is extremely, extremely disturbing. As I said, no investigator or the powers that we don't want to be seen as being soft on white collar crime. And that is the reason, if you look at PMLA, for instance, if you look at the Companies Act fraud provisions, getting bail, which one should be entitled to as a matter of right, and we've all grown up learning that bail is the rule and jail is the exception. All of those things have been turned right on their head when it comes to a white collar crime, where jail becomes the rule and bail is the exception. And all of these are legislative issues that we have. I can go on and on. We have the issue of reverse onuses in many of these laws, where if you are an accused of a white collar crime for money laundering, for instance, or fraud under the Companies Act, the investigator and the court would start with the presumption of guilt. The cardinal principle that you are presumed to be innocent until your guilt is proved beyond reasonable doubt is turned right on its head, and that's problematic to me. And I'll square it off and stop here. with one last point, which again is deeply disturbing, is the kind of vague laws that we have. For instance, if you look at the fraud provision under the Companies Act, the definition says fraud includes, and it lays down some incidents which are fraud, but it's an inclusive definition. So fraud may be these things, it may be other things too. So it's almost like, Alice in Wonderland, where Humpty Dumpty says that words mean what I want them to mean, nothing more, nothing less. Here in this case, if you are somebody who's running a company and you've done something which the investigator feels is fraud, and since the definition is so vague, open-ended, and it doesn't lay down clearly what is crime and what is not, this gives the ability to the investigator, for instance, to go aboard and prosecute in cases which might be proper business decisions and not criminal at all. We've all read that there cannot be blurred signposts to criminality. So this is my view broadly on the legal landscape and the trends, and what sort of disturbs me as far as the present legal position is concerned.
But you mentioned, if I just take up your thoughts on two parts. First, you mentioned about the reason behind why these crimes are committed. If I may just add one more, according to me, is many times these crimes are committed because of compulsion, because a person is put in such a situation, So don't you think that even by compulsion also is the compulsion of force, for that matter, different circumstances can be another reason.
Samir, you're absolutely right. Am I audible?
Yep. Yeah, go ahead.
I'm sorry, I lost you for a moment. Am I audible now?
Yeah.
Samir, you're absolutely right. Many cases it is compulsion. It is, as I said, in that fraud triangle, the first piece is pressure. So that pressure may be of two kinds broadly. One pressure may be the kind of incentive structures of executive compensation that we have. For instance, 60% of a major decision maker's salary is attached to the kind of profits that you're able to make in a quarter, right? So that is pressure. Pressure is also, of course, peer pressure. These are high-performing individuals who want to be seen as successful, who want to, do their best and appear to be doing good. That's pressure. Then again, there's another pressure, which again brings me back to the Prevention of Corruption Act. For example, there is a company who wants to do business legitimately in India. And doing business in India is, we know the kind of beast that is and how difficult it may be. It wants to do business in total compliance and respect for law, but it may find at some point it's absolutely impossible. Indian system, or there are some problems that make you, and you don't want to do business in a certain way, and that may not be entirely honorable or ethical. And if, for example, in the Prevention of Corruption Act, now a bribe giver, just to simplify this, a bribe giver is also somebody who can be made an accused in a typical situation. However, if the bribe giver, soon after the incident, reports the offense voluntarily, and that it is established that the bribe was given under circumstances where it wasn't a decision that was voluntary or done out of free will. So again, compulsion being a motivator, and that compulsion, now to come back to your point, may be something that affords you a defense under the law as well. Yeah.
I want to just make a follow-up comment to both at
Maybe you're not audible.
I believe there's some audio issue. If you could just correct that, maybe some internet connection. Thank you.
But taking cue from what Bharat said, I think, Samir, compulsion is a very small component in this. I think, from a corporate structure perspective, I think compulsion is very minuscule. I think it's predominantly greed and territorial power. And, because the way things are going today, I think when you see there is so much competition and race of upmanship in large corporations, that forces them to generate more and more power, establishing contacts with government agencies and investigating agencies. And these investigating agencies are used in multiple ways. I mean, I have been experienced. Sorry, I think no, Shebir, you're breaking.
I'll come in after you.
Yeah, so I'm, in my experience, I've realized how the system has been manipulated even by in corporate wars. I mean, between two large corporations, how one company is using the prosecution machinery against the advantage for the disadvantage for the other companies, wanting to initiate income tax raids, wanting to initiate ED raids, trying to keep pursuing with the enforcement directorate or with the economic offenses wing to say that, okay, this is the fraud, try and keep harassing the other company or trying to invoke some of the other forms of legislation to make sure that they are put on the back foot, and then negotiating larger deals with them to either acquire their company or not. And everything is out in the open. We all know that this is happening. So it's using, misusing, but also the fact about centralized prosecution, the fact about the escape route for the companies, in which the company should be protected and that the individuals. I think a large problem that what we face in India is the public perception. The media plays such an important role, and I think, Samir, this is also such a large, massive discussion of what is the role of media in the entire white collar crime space. Because what happens is that the public perception really forces the investigating agencies to keep delivering, performing, arresting, conducting raids, seizure, bank account, artwork, take everything, destroy everything, go and auction out everything while even the trial is pending, just to have that bravado in the media that, oh, we've done this and that. Well, until the trial is concluded, until you have realized that the person is actually guilty by way of a completion of a proper trial, how can we go ahead and we do these things today? But the public perception plays such an important role in this, that it is only to please the media or to please the public in general, that yes, these are the wrongdoers and this is what they should be punished. I mean, growing up, as I said, that we've always gone through this whole phenomena that because we are poor or because we are because we are somebody who don't have the influence, we are suffering. It's the other way around. Nowadays, for the last 10-12 years, we are seeing that the rich, the powerful, the influential, howsoever hard he may have worked to build an empire, it's a preconceived notion that if he's rich, if he's powerful, he has to be a criminal. Seedhe raste se nahi kiya hoga. That's the whole idea. So bring them down. So that whole sadistic pleasure with the media, public in general, also is a complementing factor which contributes to these multiplicity of investigation in different areas, where like Bharat and Shebir said, an EOW registers a complaint for any offense which is financial fraud over and above the pecuniary jurisdiction of 5 crores. And then the ED steps in based on that FIR and then says, oh, there must be money laundering. And then the CBI wants to come in, and then the SFIO wants to come in, and then the income tax wants to come in through the Benami Act and through the Black Money Act. So, where all, what all, I mean, good for lawyers, but at the end of the day, it's just a destruction of value and everything for the corporation and for the individual as well, from a reputation perspective.
No, I think I completely agree with what both Mr. Memon and Bharat have said. And I want to raise one cardinal point, which is sort of at a cross section of issues that we see on why they happen and how they get prosecuted or how they don't get prosecuted. The quantum of empirical evidence that there is on what is the cause of white collar crime is extremely skewed. In fact, I remember, Bharat, you brought up Eugene Scholtes. I was in a discussion with him about 2 years back at Harvard, and one of the key findings that he had, one of the key narratives that he brings about in his book is about the lack of women in white collar crime. And I was, in fact, when I was traveling to the United States, I stopped over in London at that point of time to look into a very complex fraud for a pharma company, which was done by an all-women team of 6 employees. So to put across that, the reactive response on what is the genesis is pretty much like any other crime. And at best, we have anecdotal evidence. We've never come up with firm evidence. The second piece of where this evidence takes us is that even in terms of what works in terms of deterrence, I think, Samir, you made a point that the United States has a very large scale industry of fraud and corruption. And, I think we've, even in terms of how we quantify fraud, corruption, business crimes is again fairly challenging. I think we should take solace in the fact that the largest global survey on corruption is a perception index. and it's never moved beyond that. And a perception is something which is inherently subjective. The same translates into what works as deterrence. On one part, there is an entire industry, somebody calls it EPA, somebody calls it something else, that about how behavior has changed and behavior alteration has occurred because the United States penalizes foreign companies or penalizes companies from the United States or listed on US stock exchanges. And there is no empirical evidence and whatsoever globally to demonstrate that behavior alteration has occurred principally because of penalties. And a classic example is HSBC in money laundering. HSBC with a compliance program of close to, this is a public matter. I'm just using an anecdotal example, not taking a dig at them. With a public spend of several $100 million, has a large scandal, pays a fine, and the end result is that we're going to have another couple of $100 million with a total compliance spend going over $1 billion US. And the question is that you have this spend, you have all these nice sounding jargon words of tone at the top and, proportionate procedures, but they don't translate. And that's because at some point, I think what Elena and Bharat and Zulfikar, all of us have tried to come back to, we don't have trial. And the US system of DPS, NPS also doesn't create trials. It creates fact patterns and settlements. So our overall pool of what we are working off is very limited. What will work as deterrence in one scenario may not work as in another scenario, and our original theories of punishment as far as white collar crime also need a relook. But I think one thing that I want to come out very, very aggressively and strongly on is that I don't think any of us would like to defend the position of saying that someone who has committed a crime should not go punished, or that justice should be dispensed just because it's a white collar crime. I think the point all of us want to get to is that we cannot play with the rights of an accused in an adversarial system merely because the public wants to draw blood. And that becomes, I think that becomes the cornerstone of any powerful criminal justice system, of how you treat those accused of offenses and what yardstick you apply to them. Whether it's on matters of bail, whether it's on matters of the powers of a high court being superseded as part of existing criminal procedure because the apex court believes that the trial court should report into them. These are all aspects that erode the faith in the criminal justice system and take away a key component of it, which is fairness. When on one part, even on matters of bail, it's not just the jail is the rule, bail is the exception aspect. Even when you come back onto this particular element, when on one part, the legislature defines the gravity and seriousness of an offense by the quantum of its punishment, as that being the final metric, the final empirical point, there are offenses with greater punishment than those where individuals are accused of white collar crime out on bail. But now we have jurisprudence emerging which says that these are such serious cases which they shouldn't be on bail. I think this really flies in the aspect of where innocent prosecution ends up occurring, faith in the system comes down, and more importantly, when the state's inability to prosecute comes up because of 6 agencies and so on and so forth, which everyone's spoken about, it doesn't cause deterrence. It doesn't tie back to the main point we were all starting out with to say, how do you deter instances like this? We've all agreed that there is a problem. We've all agreed that it has a major societal impact, but how do we stop?
That's a very, very nice question you have put up, Shelby, at the end of your presentation. That how do we stop this? I mean, what I hear out from you all is, in spite of the current laws, both in terms of penalties and punishments, still we don't find the deterrence. So how do we do that? Alina, would you like to share your thought on that?
So Samir, I think it's very interesting to hear different views, and they're all my colleagues. And I think the key point here is, as far as crimes are concerned, what is the cause? How does, why do businesses engage in corporate crimes? I think first and foremost, one thing we need to remember is corporate crimes are different from other crimes. there is a crime or a liability for the corporate, which is a different entity and juristic person, and they are people who are at the helm of affairs or individuals who would be responsible. So while the deterrence for the company can only be financial implication, the deterrence for the individuals who are the decision maker would obviously be a successful prosecution and possibly, going behind bars for the actions that they have taken. Now, how do you change all of this, and how do you make, the difference going forward? To my mind, it is going to happen only if there are multiple changes that come about. And foremost amongst that is the culture. It is the way we operate. Now, the problem is, Shelby said, tone at the top. It's a very nice jargon. We always hear it, that the tone at the top has to change. And the senior management has to let the company know and the employees know that we have zero tolerance to corruption or fraud. And, we are going to take action if any employee within the system does anything that's fraudulent or corrupt. Having said that, there is the counter pressure of performing, because everybody or every employee's performance is linked to them facilitating business. We move beyond the corporate's position to the environment in which it operates, which is, our entire ecosystem in the country. How easy is it to do business in India? Ease of doing business. One of the co-panelists brought out the issue of how difficult or the issues that are prevalent in this country to do business. Now, unless all of these factors together are taken into account and addressed, I don't think the change is going to come just by telling the CEOs or the board of a company saying that tone at the top, we are not going to indulge in any corrupt practice or fraud. But at the end of the day, when you percolate down and you have to do business, what do? You just cannot do business. The system has to change to facilitate business, so that when the tone at the top is coming about, they know when they say it, it is possible and doable. So to my mind, this change has to be a combination of change in laws, change in the business environment, ease of doing business, as well as a cultural change. I think employees and citizens of this country that work in the space of the white collar space, as we call it, need to realize and understand, and there has to be knowledge and awareness. I think this chalta hai attitude, I think Zulfikar mentioned, that aise hi hota hai, chalta hai, that's because that's the way it's always happened. The change hasn't still come about. There is the beginning of the change. We are talking about it. Corporates are talking about it. Prosecutions are happening. But has it really culminated into that environment where you can do business in an ethical manner with proper governance? I think the good thing for me is I'm seeing change in law. I'm seeing change in corporate governance standards. I'm seeing change in the Prevention of Corruption Act. But is that enough? I don't think so, because there is a lot more that needs to be done. And a lot more needs to be done because the manner in which we are doing business is a lot more tech enabled, and the awareness of offenses with tech enabled, especially in the white collar crime space where you're dealing with most of the businesses being online. I think if we go down to the laws and start, seeing where we are, you will see a huge gap. So first challenge was just simple corporate crimes, addressing the jurisprudence and the laws for that. And I think by the time we've started catching up to that, the technology piece has changed the way the business and the corporate world is functioning. So we have a huge gap. Simple examples, and all of us have done multiple investigations, all of the panelists, where we realized that if you are to go and simply explain data theft on a cloud space, it's difficult to explain it, whether you are, going to a cybercrime cell or whether you're standing in a court of law and trying to explain what happened. And the challenges we face while trying to do that, the only consequence we see is next date, deferred. The cop is not understanding, even though it's the cyber cell. So how do you move ahead where the entire environment in itself is not ready? But the fact remains, trends have changed, businesses changed, knowledge has not been imparted. The evolution of the regulatory authorities, the judicial system, as well as the people who are working in this space hasn't happened. So to my mind, everything has to change, and it's all brewing and it's all happening, fortunately. But I think we need to do it at a far greater pace to bring about that change.
Just to add to Alina, 5 seconds. Quality of prosecution also is a very, very important. Prosecution lawyers, I mean, that really needs an upshift. I mean, we've been seeing, because the quality of defense lawyers is par excellence in this country, but you know, to do justice at the end of the day, to match that bandwidth of prosecution lawyers is just, there's absolutely no match. I mean, no disrespect, but the fact is that this is something that the entire judiciary, all the academies, we all have to work together to enhance the quality of prosecution lawyers. I mean, that will really make a lot of difference, in addition to whatever Alina said.
Right. If I may.
Yeah, please. I was
quick.
Are you going to open with wanting to become a prosecutor? That will complete your time.
We lost you. Sure, we lost you.
Go ahead, Bharat. I think I'm on bad network.
No
I was
problem.
going to say that, are you going to complete your legal journey by becoming a prosecutor as well? And then I think you would have virtually been on every side of the aisle as far as a courtroom is concerned.
That's right. That's what my mom keeps telling me. You're the jack of all. But yeah, that would sort of complete the whole thing. So very quickly, 5-6 points on the way forward, according to me. I agree with Sherbi that certainty of punishment is a bigger deterrent than gravity. We've had in China, for instance, death penalty for white collar crimes. It hasn't stopped them from happening, right? So certainty of taking a case through to trial, ensuring that the trial is an effective one, is a greater deterrent. That sends a very strong message out there that if you've done something, there would be consequences. Second, white collar crime is different. The way we prosecute and investigate has to be different. Our 1860 IPC or a CRPC that was imagined in the 18th century by Lord Macaulay is thoroughly unsuited to the kind of crimes that we are looking at. For instance, the provision for leniency or making somebody a state witness or an approver in a criminal trial is still unsuited to whether it applies to a company or not. What if in a case a company says, okay, there was something possibly off with the corporate culture and we are ready to disgorge the profits and make amends and have a better system? Does that company have an option, or the CEOs and everyone have to be sent behind the bars and you have to parade them out in front of the media? Is that the solution? The answer to me is no. Corporate culture, great point by Alina. I think 2 points which stand out as far as corporate culture and the need to change is looking at incentives once again and encouraging radical honesty, I think, in corporate boardrooms where everyone has a voice, where everyone is afraid to tell the emperor in a given case that he's no clothes, and there are different ways of looking at a situation. So encouraging honesty in decision-making in companies is very important, according to me. Then more calibrated decisions on which cases to take to trial and which cases not to take to trial is very, very important. In many cases, we've seen that a prosecutor firmly believes that there is no criminality here. The investigator understands that there is no criminality here. I've had the opportunity of looking at some of these trials, first as a judge and then as a defense lawyer. The prosecutor says, sir, I understand there is no case here, but if I move an application for withdrawal of prosecution, there would be an allegation against me that I'm sort of trying to favor the accused in this case. Let's give our prosecutors more powers, more independence, try to train them better and give them those facilities. I think whistleblower protection and witness protection is something that we've sort of failed in as a system in multiple ways. I'm consciously using very strong words, and it makes me a little angry because I've seen cases fail for witnesses not showing up, witnesses not being given protection, whistleblowers not being given protection. As far as the Indian legal regime is concerned, apart from income tax laws, or to some extent insider trading laws, we do not have a robust system of incentivizing whistleblowers or protecting them. Finally, prosecutorial intervention at the stage of investigation is again very, very important for me. Mr. Memon made that point that not only there is a qualitative difference, but also a prosecutor also gets involved in a case after it's already a fait accompli in multiple ways, where the investigation is faulty in multiple ways. And when it comes to the prosecutor, he's handed a hand that can't be played, and he has to go along with that case. All the mistakes made during the investigation cannot be rectified now. So let's involve prosecutors there, have more narrowly tailored laws, which define with precision what is criminal and what is not, so that we know what to criminalize and what to prosecute and not. And finally, I think a protection of due process and personal liberty while we do all of the above, because these are the cardinal principles on which any criminal justice system, for it to be fair and reasonable, is based.
Fantastic. Yeah, absolutely.
Yeah. So, Sharbi, do you want to add something, or?
No, I think we've covered it all, and I believe we're also virtually out of time. So I'll leave Bharat with the last word on this.
Or maybe Mr. Menon?
No, I think Bharat has summed it up well for all of us. My only one bit which really frustrates me, is the conducting of an entire criminal trial on prime time on electronic media. I think that it does so much disservice to the entire system by itself that, as I said, that there is a whole different discussion altogether about the role of media in white collar crime specifically, because of the entire perception that operates against it. Makes the life of defense lawyers extremely difficult, where you are labeled as much as like the criminal himself, that you're always representing the wrong person. So I think there are a lot of areas like what Bharat said, but many areas which need a lot of change. And I'm sure that with the way things are going, eventually in the next few years, we'll see drastic changes to ensure that we get effective justice in this area.
All right. That was a really great discussion we had. And just to sum up all what we discussed, is that definitely the laws are very much there, but they still needs more revamp to make it, to achieve the deterrence, what is required to curb on the white collar crime. But over and above that, laws have been there, laws were there, laws still are there, and there will be laws again. But everything boils down to our own mindset, as Alina just very specifically put about the cultural change, which I think is the mindset change which is required towards putting I won't say a total curb, but at least reduced and gradually the commission of such crimes. So thank you very much to all the speakers today, and thank you Business World for giving this opportunity. And we just finished in time, I suppose.
Thank you.
Thank you so much. Well, Ashima, over to you if you'd like to connect with our panelists. Over to you.
Thank you, panelists. Thank you so much for that absolutely illuminating and edifying discourse today. There are so many key takeaways, and we are so grateful for your time. Thank you so much for joining us on BW Legal World Global Legal Summit.
Thank you for having us.
Thank you.
Your thoughts again some other time.
Thank you.
Thank you.
Thank you, Arina. Thank you, Sharbi. Thank you, Zulfikar, Samir, and Bharat.
Thank you.
Thanks, everyone. Thank you. Bye.
Thank you. Ladies and gentlemen, now moving on, it is time for the final panel discussion, and this is the last panel discussion for the day before the award ceremony begins. Well, we're going to be joined by domain experts from across the globe. We're going to be discussing on judicial and arbitral bias and how to deal with it. Well, ladies and gentlemen, we're going to be joined by our key panelists. First up, Ms. Ferista Setna, Partner, DMD, Attorneys at Law. Ms. Shyamala Venkatachalam, the Chief Legal Officer at Z Entertainment Enterprises Limited. Mr. Abhinav Bhushan, Director, South Asia ICC Arbitration and ADR International Court of Arbitration, International Chambers of Commerce, who joins us all the way from Singapore. We are also going to be joined by Mr. Divyam Agarwal, Partner, J. Sagar Associates. And the session chair, ladies and gentlemen, is going to be Mr. Mohammed Zaman, the Barrister, Queen's Counsel at Number 5 Barristers Chamber in London, UK. So thank you so much to our eminent panelists for taking out their valuable time and being with us today. And with this, I'd now request our session chair, who's joining us live along with his eminent panelists, to take it forward. Mr. Zaman, over to you. Thank you for joining us.
Hello, good evening.
Good evening.
The topic tonight, as you know, is judicial and arbitral bias and misconduct. The starting position is that judges are bound by their oath and arbitrators are bound by their declaration. And of course, the oath universally throughout the common law jurisdictions requires the judge to say that he will decide without fear, favor, affection, or goodwill. But of course, I'm reminded of the words of the 17th century English philosopher, Jeremy Bentham, who said this about oaths. They are useless. The oath is taken by everybody violates it, nobody's punished for it, and nobody is ever put to shame by the violation of it. Bias and misconduct by judges and arbitrators is unfortunately one of those issues that arises when least expected, and a good legal team needs to know how to react. In my career, every 3 or 4 years, I come across a real big humdinger of an application against a judge or an arbitrator based on his or her bias or misconduct. I could spend hours telling you about cases I've done over the years, but I'm going to just dwell on one of them. Several years ago, I was doing a case in the Dubai World Tribunal, and I believed I was conducting it vigorously and with force. I had a very big legal team, a junior counsel, 2 partners, a paralegal. The other side was similarly well represented, and the trial went on for 3 days. At the end of the 3 days, it looked like we had won. And we all flew back to our respective jurisdictions back from Dubai, expecting a victory. A week later, an application was made by the defendants for a retrial based on an allegation that the judge had fallen asleep during the trial. One of the 3 judges, the Dubai World Tribunal actually has 3 judges who sit. And in fact, the judge who was alleged to have fallen asleep was the Chief Justice Huang from Singapore. And whilst in most ordinary cases you would have no evidence of what did or didn't happen in court, in Dubai, the proceedings are videotaped. So the parties were given the videotapes, and the defendants were all worked up saying, look, he's clearly asleep. Now, of course, we weren't prepared to concede that he was asleep, but we were prepared to concede that he was apparently inattentive. And of course, the matter went for a full application before the 3-man tribunal, and we had a very interesting debate as to what test ought to be applied. Is it sufficient that the judge or the arbitrator looks as if he's asleep, or is it enough to prove that he was asleep? In fact, the test that was actually applied by the court was the test that came from an English case called Betson, which simply amounted to this. It wasn't enough for a party to allege that a judge or arbitrator was asleep. They needed to prove that he missed something relevant. And on that basis, I was able to uphold the decision in my favor. But anyway, I digress, because this is just an example of the sort of thing that arises. Many jurisdictions, in fact, jurisdictions across the world, are trying to establish a standard that they expect from judges. And actually, India can claim to be at the forefront of this, because there was a United Nations convention, an initiative on a code of conduct for judges. And it was established in 2001 and developed what are known as the Bangalore Principles of Judicial Conduct. They contain 6 values, and the 6 values are that there should be judicial independence, which is a prerequisite to determination of issues, that there should be impartiality in the holding of the judicial office, that there should be integrity, which is essential to the proper discharge of the judicial office, propriety and the appearance of propriety, ensuring equal treatment, and competence and diligence. Now, it's great to have those 6 Bangalore principles set out in writing, but actually the test I always like to apply to these things is the test that I apply to my children when they've misbehaved. Stop it. You know when what you've done is wrong is wrong. And of course, in England and Wales, we now have a guide to the judicial conduct which judges are supposed to follow. And if they misbehave, the ultimate sanction is that a judge might be disciplined. Now, you might say, how many examples are there of judges who have actually been removed as a result of judicial bias? And the answer to that is none. There was one judge who was the subject of a High Court judge who was the subject of disciplinary proceedings arising out of bias. It never got to a hearing because he resigned before the hearing started. I could then go on and tell you about the tests that apply in respect of bias. Of course, actual bias, if you can prove it, is a slam dunk victory. But you're never going to be able to prove actual bias. I mean, it'd be very rare for a judge to say, I'm sitting in this case and I am only going to listen to one party and I'm going to find for them. So very rarely are you going to come across that. What you've got to look for is whether or not the judge or arbitrator has an interest in the outcome of the litigation or is demonstrating apparent bias. Now, that's so much by way of general introduction, because my role, as I see it today, is to invite comments from our panelists. And what I'd now like to do is to turn to the first of our panelists, Abhinav Bhushan, who is the director of the ICC in South Asia, who joins us from Singapore. And I wonder if he can help us with some input on how the ICC deals with such matters. Over to you, Abhinav.
Thank you, Mohammed, and thank you. It's good to see friends and colleagues. I think I've not had an opportunity to meet Shamla, but it's really good to see Farishte and Vivian on screen. And thank you, BW Legal, for inviting ICC to be a part of it. I know we have almost 60 minutes and much to talk, so I'll jump straight to the point. At the ICC, because arbitration rests on the most fundamental of the pillars, which is independence and impartiality, the ICC court obviously therefore looks at bias and issues that may come out of conflict very seriously, and I cannot stress on this enough. The procedure that the ICC adopts is that, in light of course, the general principles, and I'm talking about to the Indian audience, and in India, we have this subconscious understanding that it's my arbitrator. I have nominated the arbitrator, and somehow that arbitrator should favor the party which has nominated the arbitrator. Well, unfortunately, that is very, very far away from reality and the way an arbitrator should act in an arbitration. So an arbitrator, notwithstanding who has nominated that arbitrator, should remain impartial and independent throughout the proceedings. And that obligation is a continuing obligation. So should there be any circumstance that may arise during the arbitration, the arbitrator is obliged, at least under the ICC rules, and I understand most rules, to disclose that perceived conflict. To quickly sum up the procedure, the moment an arbitrator is nominated at the ICC, the ICC sends that arbitrator a form, and that form is called the Statement of Acceptance, Availability, Impartiality, and Independence. And I think for the purposes of this webinar, the two operative words are impartiality and independence. Amongst other details, the arbitrator is required to disclose any conflict which the arbitrator may think may impugn his or her judgment in acting on that matter independently. And we also have a supplementary note. That note is, again, freely available, freely downloadable on the internet. And that note is called Note to the Parties and Arbitral Tribunal on the Conduct of Arbitration. That note actually lists about 8 or 9 non-exhaustive criteria as to what the arbitrators may look into account. Now, from experience, I can tell you, there can be thousands of different permutations and combinations of a conflict, and no list, whether it's the IBA list, red, orange, or green, there's no list which can exhaustively cover every conflict, and therefore it is left to the conscience and the integrity of the arbitrator and the arbitral process as to how they may want to go about it. That form is then sent back by the arbitrator to the ICC. The ICC then circulates that form to the parties. If there is no disclosure, no problem. If there is a disclosure, then each side is asked to comment on that disclosure. If one side objects to the disclosure made by the arbitrator, then the Secretary General or the ICC court, as the case may be, has the discretion to confirm or not to confirm the arbitrator. If the disclosure is serious enough, or the test that we apply, and we will talk about it in the course of the webinar, what tests are applied, then the arbitrator is not confirmed and the party is requested again to nominate another arbitrator. That is for confirmations and non-confirmations. And then the other question is perhaps when a challenge takes place. So the criteria that the ICC court applies at the time of not confirming an arbitrator, or whether or not to accept the challenge of an arbitrator, because mind you, challenge happens after the confirmation. This is a step that ICC takes prior to confirming whether or not to confirm in the first place. And the reason behind that is that this is a pre-check. Because of this process, ultimately challenges get reduced later in the procedure. Because what you don't want is that you spend a year or two or maybe less, as the case may be, so much time into the matter, and then suddenly there's a conflict that nobody had thought or seen about, and then the arbitrator needs to be removed, and all the time and the energy and the money that has been spent on that arbitration goes for a waste. So because of this procedure, the number of challenges that I think the ICC receives are far less as compared to the number of objections to the confirmations that ICC receives in case of a conflict. That is the procedure broadly. I will stop here because I will talk about the objective bias and the reasonable person's test and the objective test and the criteria that the court takes into account perhaps a bit later.
Sure.
Or Mohammed, if you'd like me to address that now.
I was just going to ask you, actually, while we're on that topic of the way the ICC invites the declarations from the arbitrators, there is, as you know, the very recent decision of the English Supreme Court in the case of Halliburton and Chubb, which I suspect many of you will be aware of, which is now the leading judgment on declaration of interests and conflicts by arbitrators. And can I share my own view with you on this before I ask for your comment?
Please.
The judgment seems counterintuitive. As you know, in that case, the arbitrator had been appointed in an ad hoc arbitration, and he was subsequently appointed in another ad hoc arbitration. And as you know, all arbitrations are confidential. And of course, the arbitrator in his mind had got the idea that somehow he couldn't disclose the second appointment because he might be breaching his confidence. I think that the court, and I'm paraphrasing it, found that that wasn't the right approach and that he ought to have declared in the first arbitration his second appointment. But they still upheld his appointment, didn't they? And I think the ICC made representations. And what do you say? I mean, never mind the fact that it's a Supreme Court judgment. What are your views on that?
My sense is that, without, of course, with much certainty, that if this challenge were to be decided at the ICC court, perhaps, and this is my personal opinion, the outcome would have been different. That is the best I can comment on that judgment. But and here's another additional factor. I think the test that the UK courts applied, the test that we apply actually is and internally we actually laugh about it, or the term internally is the smell test. If it doesn't smell right, then you have to sort of dig into it deeper. And the test that I think ICC applies is a very objective test, and it's a justifiable doubts test. And that justifiable doubts test that the court often applies is that the relevant question is that whether a reasonable and a fair-minded person who has knowledge of all the facts and circumstances would entertain a reasonable suspicion that if the arbitrator is not removed, then the judgment would be affected the judgment would be affected with the arbitrator's bias. So if a reasonable person thinks that if the person continues to be an arbitrator, then there's a likelihood of the award to be affected with bias. That's the justifiable doubts test that the court applies.
Which actually is very similar to the English law test, which is if on examination of all the relevant circumstances,
Correct.
the court concludes that there was a real danger or possibility of bias, brackets, objectively, close brackets. I mean, in a sense, this comes back to the way I paraphrased it. My children know when they've done something wrong. I don't think that will ever make it into a judgment. But you're right. The way you describe it, the smell test, the objective criteria really is, if anybody looking at it thinks this isn't right.
Correct.
And
the optics of it matters too, right? I mean, the optics matters so much. I can give you a plethora of examples, but what I can say with certainty is that the principles that ICC applies are actually broader. They're broader than the IBA. They're broader than national standards, because we are the guardian institution. The parties, when they put their faith putting into an ICC arbitration clause, I think the least they expect is an impartial and an independent procedures. So the standard historically that the ICC court has applied is far broader. And in a case, what happened, the example that you gave, Mohammed, I think the outcome may not have been, but every single case, and I've been around for 9 years now, there have been no two challenges or two objections that have been similar. There is one little detail that is different from the other one, and that changes the whole thing. Even as simple as, I had two examples, like the court decided in one of the cases to accept the challenge where the president's law firm and claimant had an financial commitment, which is that the president's law firm was engaging that counsel in various matters. And then finally, the president was challenged and the court accepted that challenge. Now, just a little twist to that, there was a co-arbitrator nominated by respondent, and in which the arbitrator and the respondent's counsel had a close professional relationship. And the respondent's counsel's law firm and the arbitrator handled disconnected lawsuits collectively. So there was the arbitrator was generating revenue or was earning fees from the law firm, and the court accepted that challenge. One more example to give you, that the court also decided not to sort of confirm an arbitrator who had been nominated 3 different times. Now we're going back to Chubbs, right? 3 different times by the same counsel. The additional fact there was that the arbitrator had also been acting as a co-counsel in 3 unrelated matters with the same counsel firm. And the court decided not to accept the appointment. The court decided to accept the challenge to the arbitrator. These are just 3 examples. I mean, before coming to the webinar today, I was reading examples. There are thousands in the court. Now, every single challenge is decided independently, but the court does draw reference to its precedents. Those precedents, of course, are available only to the eyes of the Secretariat and the court. And we present to the court at the time of drafting the memoranda that the court, in somewhat similar circumstances, the court has taken this decision. But in many cases, despite that, the court takes the decision which is opposite to what the court had done earlier because of that one little detail that was different.
Now, of course, the ICC not only relies on the integrity of the arbitrator, the proposed arbitrator, who ought to have knowledge of at least the IBA guidelines, which everybody knows. But they also have the benefit of your own guidance, don't they? Which you send through to them to consider in detail before they sign off their declaration.
Right.
But you still get challenges.
You still get challenges. Sometimes situations change after signing that form. Often happens.
Yeah, okay. I wonder if we can just move on from that to the changes in the new 2021 arbitration rules. Is there anything in the new rules that you would like to tell us about that?
It's just very quickly. There have been a plethora of changes in the new rules. The new rules come into effect from 1st of January 2021. To summarize very, very briefly, all contracts entered into after 1st of January 2021, the 2021 new rules would be applicable to those contracts. And there have been lots of changes, but specific to conflicts, I think we have now formally addressed the issue of funding. So the rule, and I can quickly quote it actually, in order to assist prospective arbitrators and arbitrators in complying with their duties, each party must promptly inform the Secretariat, the tribunal, and other parties of the existence and identity of any non-party which has entered into an arrangement for the funding of claims or defenses and under which it has an economic interest in the outcome of the arbitration. So now, if there is a funding element involved, it must be known. This was more informal before. It was available in the notes differently. Different institutions have it in different ways, but now this is the new Article 11.7, and this goes directly to the heart of independence and impartiality. So that's
I've seen that in your rules, and of course, reading around on that particular change, as you say, the objective of the ICC in that is to find out whether the party or its advisors are in fact being funded by somebody whose identity ought to be known in order to have a wider understanding of the scope of potential conflicts.
Correct.
Just out of interest, are you expecting in that, and I'm very interested as to how this works with Singapore, are you expecting declarations by lawyers to say that they are in contingency fee arrangements? Yes. I imagine that the answer is yes.
Yes, because arbitrators would never know. And I mean, the only person who would be declaring it would be the parties, because at the time of appointment, the arbitrators are unlikely to know whether the arbitration has been funded or not, unless that forms part of the pleading. So somebody would come up and say, hey, this is funded by X and X. And that's either going to be claimant or respondent party. At which point in time, the arbitrator will have to take a look that, hey, is there a conflict with this new entity, which he or she did not know at the time of commencement of arbitration.
But that declaration, of course, makes its way to the other party as well, because they need to know. Has anybody else got anything to add onto that before I just ask a few more questions? I mean, I would like this to be a discussion if anybody has anything.
I was just wondering, why would there be a requirement to declare contingency funding of the type that might involve a claimant or a respondent, as the case may be, entering into an arrangement with their lawyers, which would not necessarily have anything to do with third-party funding, but say by a subsidiary of the claimant, which for all intents and purposes may be a group company, and would therefore not fall within the ambit strictly of third-party funding. I assume that the answer to that is that would not be amenable to disclosure. Would that be right, Abhinav?
First, hard to say, hard to tell. In your perhaps strict example, maybe not, but you know, if there is an economic interest of a third party, which directly comes from the outcome of the current arbitration, then such arrangement must be known to those who are adjudicating the dispute. Now, yes, there could be a group company structure and it may not be directly related, it could be indirectly related. Yes, and that's a technicality. But if you ask me the smell test, it doesn't smell right to me, right? Because the funding is for the current arbitration. Is that correct?
Absolutely. And in my example, Abhinav, I'm talking about a company that would have entered, say, a jurisdiction on an inbound investment, lost all of its assets, unable to fund itself, looks to a subsidiary to effectively bear the cost of the arbitration on some fee arrangement, whatever that be. So that technically would not necessarily be the claimant, but a subsidiary, and therefore technically a third party to the arbitration. Now, how would you account for that? I was just curious, but of course I don't want to spend any further on that is necessary.
I can only speak my mind. I mean, because it's a subsidiary, I would imagine it would make it subsidiary of the party which is a party to the arbitration. I would say that the impact would be slightly less, in my view, as opposed to a third party which is not related to the company at all. because in any event, everybody who's adjudicating the dispute would be impacted in a manner that, look, at the time of appointment, if I am being nominated by the parent company, however, I have in the past acted for a subsidiary in any capacity, my obligations anyways require me to disclose those connections, right? So I think that should be covered. But time will tell. We've never had that case, by the way. And I'm sure because it's coming from you, I'm sure there's more to this. So I will keep my eyes and ears open.
I just want to come back on that myself, actually, because I'm looking at the particular rules. There, as you know, in some jurisdictions, the lawyers enter into contingency fee agreements that are permissible in their jurisdictions. I know, in Singapore, maybe the domestic legislation prohibits the recovery of contingency fees. So there it's a complete no-no and it might not arise. But imagine you are in a jurisdiction where the lawyers are on a contingency fee. On the strict reading of your new rule, it looks like the claimant would have to make when making its case and setting out its position, the claimant has to disclose that its lawyers are in a contingency arrangement because they're a third party to the claimant.
Mohammed, I'm not very sure about it because in the past we've had lawyers from the US and other jurisdictions where contingency fees is allowed. I've never seen such a disclosure.
It's the formulation of the new rules. Previously, right. I think it wasn't as anyway, let's leave that for another day. And I'm sure there'll be challenges or not, as the case may be. I just wonder briefly whether you could give us a 60-second snapshot of what it is that the ICC applies by way of criteria.
Yes, so and that is what I was referring to earlier. It's the objective test. It is not the subjective test from the views of the eyes of the parties, and the justifiable doubts test. These are and the smell test. Let's just put it, these three different criteria that the court looks into account while citing challenges and confirmations.
Excellent, thank you. What I'd now like to do is to move on to Divyam Agarwal, who, as we know, is a dispute resolution partner at J. Sagar Associates, an advocate on record, and a dual qualified as an English solicitor. Divyam, can I invite you to give us some of your insights on challenging arbitral bias in the Indian courts?
Good evening, panelists. Mohammed, thank you very much for the introduction. Good evening to Farishte, Abhinav, and Shyamala. It's a pleasure to be part of this discussion. And while I completely endorse the views taken by Abhinav and the other panelists, I would like to start by referring to Lord Denning's statement, and then I correlate it to what is going on currently under the Indian scenario. So Lord Denning in Metropolitan Properties versus Lennon said that in considering whether there was a likelihood of bias, the court does not look at the mind of the justice himself or at the mind of the chairman of the tribunal. The court look at the impression which would be given to the other people. So taking cue from Abhinav, it should smell bad not to the arbitrator or judge himself, but to the party before him. So for that, Indian Arbitration Act has created a very robust system in section 12 to 14 of the Arbitration Act. Most of these, there has been an amendment introduced in 2019, which has brought it in line with IBA guidelines, and I'll mention about that as well. Primarily under section 12, there is a requirement that an arbitrator must disclose existence of any direct or indirect, present or past relationship, or interest in any of the parties or in relation to the subject matter in dispute, which is likely to give justifiable doubts as to his independence or impartiality. Obviously, he has to disclose whether he can devote sufficient time to the arbitration or not, considering now there is a requirement to finish it as per 29A. India has, as I said, adopted the IBA guidelines in interpretation of certain grounds as stated in the red and orange list of IBA guidelines, which have now been incorporated in the 5th and the 7th schedule of the Arbitration Act. So, and there is a fine distinction which has been drawn between 5th and the 7th schedule. 5th schedule has 34 entries and 7th schedule has 19 entries. The distinction between them is that the relationship and circumstances that may give rise to justifiable doubt as to the independence or impartiality of the arbitrator, but not necessarily render the arbitrator ineligible, is a situation in the 5th schedule, as opposed to relationship and circumstances with one of the parties to the arbitration or its counsel, which makes the person ineligible to act as arbitrator, is prescribed in the 7th schedule. So what is required to be done is that as soon as an arbitrator is called for a nomination, he's requested to look into the 5th schedule, the 34 entries I mentioned, and he has to come up with an answer that whether there is a justifiable doubt or not. A disclosure is required to be made, and the disclosure would be in the form whether there is a relationship with parties or counsel, relationship to the dispute, relationship to indirectly or directly related to the subject matter. Is there any kind of a relationship between the arbitrator and the counsel? Is there any relationship between the parties? And also, very importantly, which is the point of discussion you were having, whether there is any financial interest of the arbitrator involved. This disclosure is expected to be made immediately upon the appointment. Though the standard for such disclosure has been laid down by various courts in India, and it is not whether there is an actual bias, but whether, considering the facts and circumstances, a reasonable person is likely to apprehend the possibility of bias. There is no consequence further prescribed for this non-disclosure. Mere existence of these conditions, illustrations are just furnished in 5th schedule, does not necessarily result in the disqualification of a person being appointed as an arbitrator. So in a challenge where grounds stated in the 5th schedule are disclosed, which give rise to justifiable doubt as to the arbitrator's independence or impartiality, such doubts as to independence or impartiality have to be determined as a matter of fact in the facts of the particular challenge by the arbitral tribunal under section 13 of the Act. If a challenge is not successful and the arbitral tribunal decides that there are no justifiable doubt as to the independence or impartiality of the arbitrator, the tribunal must then continue the arbitral proceedings under section 13 and make an award. It is only at the stage of the award that the party challenging the arbitrator's appointment on grounds contained in the 5th schedule may make an application under section 34. Now let's come to, and I will, being conscious of time, I'll straight away jump to a situation of the 7th schedule, which is also colloquially known as the de jure inability. So the consequence of de jure inability is like a situation where the inability goes to the very root of the matter. Interestingly, out of the 34 entries in the 5th schedule, the first 19 entries are lifted and identically put in the 7th schedule. Now, those entries are put in such a fashion that if those entries exist, then there is an inability, and that inability result in the divestiture of jurisdiction of the arbitrator and can result in a requirement to file an application before the court to terminate the arbitrator's mandate. So section 12.5 read with the 7 schedules makes it clear that if the arbitrator falls in any one of the categories specified in the 7th schedule, he becomes ineligible to act as an arbitrator. Once he becomes ineligible, it is clear that under 14.1a, he then becomes de jure unable to perform his functions, and he's regarded as ineligible. In order to determine whether an arbitrator is de jure unable to perform his function, it is not necessary to go to the arbitral tribunal. That's one fine distinction between the 5th schedule and the 7th schedule. Since such a person would lack inherent jurisdiction to proceed any further, application has actually to be made to the court under section 14.2 to be precise, and then his mandate is considered to be terminated on the ground mentioned in the 7th schedule. So it's a very interesting construct of the Act right now, wherein the declaration has to be made in the 5th schedule in the 34 entries. And if that declaration is bad, then you can challenge it before the arbitrator, who looks into the facts of each case and see whether there is any justifiable doubts or not. As opposed to 7th schedule, where once out of those 19 entry, if the arbitrator falls into it, then the tribunal will not look into it, and it will straight away go to the court seeking termination of the mandate.
That's very interesting. I mean, I thought I would do a comparison between the Indian Arbitration Act and the English Arbitration Act. And the Indian Act is very detailed in terms of its provisions. I mean, you have these schedules which set out all the various possibilities that need to be considered. And, you know, I mean, bearing in mind that all the jurisdictions are aiming to have similar arbitration acts, it's interesting that actually in England, we just have the very broad provision, the very broad provision that there should be a justifiable doubt as to impartiality. And it's not proscriptive in the same way. So there's no schedules, there's no checklist in the same way that applies. And the courts are left really to their own devices to determine whether in a particular case, this is or is not going to amount to a situation where the arbitrator will to be disqualified. In a sense, I'm not sure which is the right way, whether you should be going down the checklists or whether you should be doing it just as a general test. I suppose probably the net result is more or less the same. It's just the way we do it in England, I suppose. Any comments or observations from any of the other panelists on this? I think from that silence, I can figure out that it's time to move on to our next panelist, who's Farishta Setna. Farishta does not really require any introduction to anybody on this. I mean, she's the founder and managing partner of DMD Advocates, well known for their bilateral investment treaty work. I wonder, Farishta, whether you could share with us some stories about applications by you in respect of judicial or arbitral bias.
Sure, thank you. Hi, everyone. I thought perhaps I would devote experiences across three genres, which really is one, my experience in a singular jury trial in the Bombay High Court. The next, again, a matter involving alleged judicial bias in the Bombay High Court. And finally, our experience in arbitration. So I'll try and cover that as quickly as I can. So starting off with jury trials, as all of us know, jury trials were abolished back in the late 1950s, insofar as concerns criminal juries. And of course, by the late 1970s, they were just completely done away with in India. But there is certainly one surviving jury trial that continues to present day, which is made up of a jury scheduled to hear contested dissolutions of marriage in a particular community. The jury trial in this genre of work traces itself back to over 150 years historically. And obviously, when I received instructions to handle a jury trial on behalf of a defendant, I found myself unable to decline instructions. The particular jury is comprised of 5 persons, as typically you would expect of persons of good character, chosen from all walks of life, all co-religionists inevitably, severally performing their own dutiful jury duties year after year, sometimes in up to 3 sessions a year, with each session ranging from anything between 3 to 5 court working days. And obviously, when you get before that jury, which as we know is no doubt ultimately supervised by the court, you have to essentially address them on how you will conduct the case. In our case, interestingly, we had, shortly after opening arguments, focused on the inadequacy of the pleadings of the plaintiff in order to establish that there would be a considerable body of evidence to be led. And to my utter surprise, I found that the foreman, whom, as you know, is the head of the jury, he speaks to the court on behalf of the jury, informed the court that it may not be necessary to conduct evidence of the nature that we were contemplating be led. Obviously, we asked for the bench to permit us to make an application. The bench invited us to make the application. We submitted that clearly, if the jury spokesperson, the foreman that is, was speaking on behalf of the entire jury, then he must clarify that to the court, because clearly that was not something that was available to him to do, to interfere with how we should conduct our trial. In any event, to cut a long story short, eventually the matter moved to chambers. The judge invited everybody into chambers, and what followed was very interesting. The entirety of the jury insisted that the jury foreman was absolutely well within his right to have stated what he did, and that we should in fact circumscribe our trial. We asked the court for permission to move an application. We asked for the matter to be stood over to the following day, and the next morning we moved an application asking for the entirety of the jury to be disqualified. The court allowed our application, and that is the one experience that I have of jury bias, an unusual one, no doubt, in our courts, because as I mentioned, jury trials have been long abolished, barring this one particular genre that we're actively still seeing in play today. And obviously, we had a judge who was completely inclined to, on the basis of what he had himself encountered and his own perceptions of what was going on in that court, and his impression of what that trial might inevitably end up looking like, is what obtained us the complete disqualification. And I'm told that in the last 150 years, this is perhaps the only case in which we have had all of the 5 members of jury disqualified successfully. So that is my experience insofar as concerns jury trials. Coming to court in an extremely critical litigation, a corporate litigation, which incidentally is still underway currently at the level of the Supreme Court, we had occasion to have an ambush on the judge, a judge of the finest integrity in the Bombay High Court again, assailed on account of some completely specious, untenable position that was advocated by our opponents. And to our surprise, the judge readily recused. Now, faced with a circumstance where you have a judge of the highest integrity, someone who nobody in his right mind would begin to question the bona fides of and the integrity of, faced with a situation where he is told that one of the parties does not have the confidence in him being able to dispense justice in the matter, without giving any substantive supporting reason, is to my mind a complete anathema and effectively requires this entire issue of judicial bias to be revisited. And the reason I say this is because it's not unusual, and in fact our chair mentioned a situation where typically it is inevitably the adversary who thinks that he might not be able to succeed in the litigation, that might resort to stratagem, contrivances, devices, what have you. It is precisely to avert that kind of situation that we need to have measures in play to protect judges. Now, in our situation, the judge readily recused. But why did he recuse? He recused on the footing that he would not want to court controversy. And he figured that obviously there was going to be another set of judges after him. So what if this particular matter was not heard by him? But there's no doubt in my mind that that is something that was impermissible. That step that was taken was impermissible. And I do believe that in that case, the persons who initiated that kind of an ambush strategy were bound to be held accountable. Do we have a mechanism to establish that kind of accountability? The answer is no, we don't. And I think that judges are too often sitting ducks for these kinds of situations. Some of them will no doubt obviously deliver in terms of ensuring that under no circumstances will they be challenged. But there are others who will fall prey to these kinds of ambush strategies. And I do believe that as members of the bar, we have a duty and a responsibility to ensure that judicial bias is dealt with in a very circumscribed and a very careful manner, not in the callous way in which we experience it was dealt with. And in my submission, there has to be a robust framework developed to ensure that the judiciary is insulated from these kinds of assaults, which we see, I must admit, somewhat more frequently than we would like. Coming then to arbitration, we've seen far too many challenges to arbitrators fail, in particular in institutionalized arbitration. I have to say that the kind of mechanic that the ICC, which Abhinav spoke of, has so much relevance, because you have, as he said, the pre-check mechanic, and then you have the obvious post-confirmation challenges that come about. And we've seen those challenges both in commercial arbitration and in BIT work in terms of a lot of what I would call futile challenges being pursued from time to time. Most recently, we had occasion to consider a 2014 challenge, which was delivered in the context of a Turkmenistan BIT. And very interestingly there, the arbitrator was challenged on the grounds that, in fact, were alluded to in terms of what we have in our schedule to the Act. It was something along the lines of, oh, well, the arbitrator has been appointed previously by the same law firm, and, oh, well, he has had occasion to consider precisely the issues that are under consideration in the present matter, because there is a commonality of the interpretation of the BIT insofar as it concerns certain aspects of jurisdiction, threshold jurisdictional issues, whether they be relating to exhaustion of local remedies or MFN applicability and the like. And interestingly, the unchallenged arbitrators declined the challenge. And that is necessarily the way to deal with these applications, because where you have full disclosure, in this case there was full disclosure, where you have a complete set of circumstances which are independent and can't be correlated in the manner in which was sought to be done, those sorts of challenges which are futile and are apparently futile should simply not be entertained, because they have dilatory consequences, they have significant impact on parties' abilities to pursue their arbitral rights and remedies. And obviously, at the end of the day, one has to ensure that the system preserves itself and preserves the position of the arbitrator, that an arbitrator is not put to the risks that would typically come from a challenge, and particularly to be forced into recusing because one of the parties decided that the arbitrator may not necessarily be able to see things their way. So in my submission, at the end of the day, yes, judicial bias is something we certainly encounter. And as our chair mentioned, of course, every 3 to 4 years, sometimes more frequently, we do have visibility into situations that shouldn't be allowed to play out the way they're playing out, whether in court or in an arbitration forum. Those are matters that, unfortunately, for various reasons, we will never ever be able to satisfactorily address, because the level of requirement to establish the threshold minimum standard that you have to establish is inevitably a difficult one to achieve, because it's obvious, but how do you prove it? And that typically is what you encounter. So I think at the end of the day, what I'm advocating for, though of course it's slightly off topic, is I think there is a critical crying need for accountability for those who move challenges. And unless that level of accountability were to be brought in, I would think that we will continue to see a spate of frivolous applications, and you put arbitrators through that overhang. It carries through the arbitration, through into an annulment proceedings or a challenge proceedings, by whatever nomenclature you term it. And I think it is just entirely unfortunate. And when you have a particular arbitrator who's frequently on the circuit and has 13 or 14 arbitrations, he's inevitably impacted, because effectively, by bringing that one challenge, you are casting that shadow of doubt over him, which is so completely unwarranted in most circumstances. So there has to be a robust framework to protect arbitrators, to protect judges. And I do think that there should be a critical path committee formed at whichever level, at whichever body, to specifically address consequences of frivolous challenges. I think that's the need of the hour. And I appreciate that it's not on topic, but I do want to make this point given that we've had this opportunity. Thank you.
That's very instructive, Farishta. If I may say so, that rings true in the English legal system, where judges are actually, the judicial guidance is that you must not too easily recuse yourself. It isn't simply an application has been made and this is the easiest course is for me to disqualify myself. And there have been several reported cases where judges have refused to disqualify. If I may, there's one very funny case that, in fact, it's funny in that the judge did recuse himself, and his phrase when he recused himself was to say this was an opportunistic application made by a party that has always wanted to get me off this case.
Absolutely.
And so that sets the principle that you were just raising, but actually he did recuse himself. And one wonders whether or not maybe the application was justified. The facts of the case very briefly, where he was a judge sitting on a British Airways case, competition case. British Airways was a respondent to this case that had all to do with antitrust matters. It was going to go on for years. And I think he was right, because in his judgment, he'd always said, they challenged him even early on, saying he didn't have sufficient experience in this area, which was code for we think we might lose in front of you. He actually bought a ticket to fly to Italy on British Airways. And his luggage was lost. And when the matter came on before him, he wasn't so much interested in the case as asking for the chief executive of British Airways to attend before him to explain why his luggage had been lost. Now, I leave it up in the air as to whether the smell test applies in that case, because what is it actually? The judicial function doesn't require him to call the CEO of British Airways to explain himself. And so maybe when he recused himself, he knew which way it would go if it went to an appeal. But anyway, I digress. What I'd like now to do is to move on to Shamla, who is our fourth panelist, who, as you all know, is the Chief Legal Officer of Z Entertainment Enterprises. And Shamla...
Hello.
Hello.
Hello, can you hear me?
I can, Shamla. You're on there somewhere, but I can't see you.
Okay. I can see you though.
Excellent. You're on now. Shamla, I know that you're a corporate lawyer and therefore not involved in disputes day to day. I wonder whether you have anything you would like to share with us about your experiences in arbitrations.
Yes. Hello, everyone. And as you rightly mentioned, throughout my professional career, I've always been in-house corporate counsel, and my role has been to, manage the litigations and the arbitrations, including the arbitrations from a company's point of view. And it was more to do with actually giving in the business perspective and the fact sheet and, and that part of it. And I've always been guided by, all the esteemed law firms and the counsels who have been guiding me in managing those litigations and arbitrations. So hence, I must actually confess that first, before I go on, I must say that, so it's been extremely enlightening, and it's been a pleasure to hear all my co-panelists share all their views and, detail, all the details, and which I am actually not so privy to, because my association with arbitrations and litigation is limited to what I've been handling for my company through the several companies that I have worked for, actually. So having said so, first I want to thank you all, and it's been extremely enlightening to know the day-to-day rigors of this field. But I would actually, having said, I want to actually move completely off the topic to share some of my perspective, and it's actually not to do with during the arbitration, or it's to do with post-arbitration, and the challenges that we've as corporates been facing is that I've had a couple of arbitrations that I've dealt with, including the overseas with London Court of International Arbitration was my first one, and then of course in India as well. My thing has been that we've managed to get a successful award for the company, but the challenge arises after that to execute that award. So it's just not the end of that story. As a corporate, we have always found it challenging that we won an arbitration, but the stakeholders still say, okay, we have a long way to go. then starts a different kind of a challenge as to how do we execute the award and get the real benefits flowing in. So, that has been a major challenge that I have faced with all the arbitrations that I've dealt with. And even when, while dealing with litigations for the company and, and managing those litigations, my experience has been not biased generally, the difficulty in expressing to the judges or to the bench to say that how to convince them, many times because you represent corporate giants, many times it becomes a challenge to actually explain the position from a company's point of view and to find this way to, because normally courts in India, there is an overwhelming sentiments for consumer interest. Public sentiments normally takes over anything. So in that scheme of things, I've always found it challenging how to bring this balancing interest to convince the judge to say, there's always a corporate interest. Profits are not bad. We do take care of the consumer interest, and, to convince the judge and to deal with that kind of bias. Sometimes judges come with a mindset. So it's been a challenge to actually, work through that mindset to put forward the real case, to say that, hey, we are not really so bad, and this is the thing that we are challenging. That's, if I may say so, these has been some of the challenges and interesting things that I have had to deal with.
Yeah, Shamla, that's a very interesting perspective, because sometimes as litigation and arbitration lawyers, we get lost in the depths of trying to get the award, and actually getting the award or getting the judgment is just the beginning of the battle.
Rightly, yeah. So it becomes
you need to win the war.
Yeah.
You need to get the enforcement at the end of the day. I just wonder whether now, I'm mindful of the time. I think we've got about 4 minutes left. Whether I can just tell you one amusing story about one of the most notorious recusal applications in the English courts. And it's a case called Howell and Lees Millais, in which the Court of Appeal sat on 3 days' notice. It was a very quick application to deal with a hearing a judge had conducted the previous week. And the lead judgment said, it may well be that the judge became somewhat carried away in the heat of the argument, which I think is an indication that they allowed the recusal application. And the facts of it were as follows. This particular judge, who had been sitting as a High Court judge for something like 7 years, had really decided that actually he wanted to go back into private practice. And he'd got into negotiations with a major international law firm to become a consultant. The negotiations didn't go to a full conclusion. And there was an email exchange between the law firm and the High Court judge, in which the judge said, I found your first email insulting and your second one condescending. I do not think that the response should have been from you by such emails. You really should have had the courtesy to speak to me. Having had that email exchange, that law firm then found that one of their cases was listed in front of him for a trial. And they asked their QC to make an application for the judge to recuse himself. And that was done by an email, to which the judge replied, if you have an application to make it. So he turns up in front of him with the lawyer who'd done the email. And hello. And just at that stage, the judge decided that he would ask the lawyer he'd been negotiating with to give evidence and be cross-examined by the High Court judge. The recusal was allowed in that case on appeal. There you go.
That's interesting.
I thought that we might as well finish on that note. It's been a very interesting and informative discussion, and I think we are probably now running out of time. So I'd like to thank you all for your contribution.
Thank you.
Thank you. Thank you very much.
Thank you.
Thank you so much for joining us once again and being a part of this incredible panel discussion. I'd really like to humbly thank you. I'd also request Ashima to kindly join us on the main stage and screen, as being the managing editor, she'd also like to put in a few words. Over to you, Ashima.
Thank you so much, Bhavna, and thank you, panelists, for this illuminating conversation that you've had and shared with us today. We also have Dr. Batra with us, so we would request him to come and address you all as well. Dr. Batra, can you hear us?
Just requesting you, Dr. Batra, to unmute yourself, please.
Yes, I have. As the Prime Minister and the Finance Minister try to unmute the economy, I've been successful in unmuting myself. I'm sure they'll be successful in unmuting the economy. But on a serious note, my gratitude to all the panelists and who've given their time to, kind of deliberate and create content which the community of BW Legal World would cherish. So my gratitude. Don't want to stay between them and the awards. And I know our jury members have joined or will join absolutely on time. The former Chief Justice of India, Shri Deepak Mishra, is our jury chair, and so I don't want to be late. So just want to express my gratitude. These are early days for BW Legal World. This is the second edition of the Global Legal Leaders Award and Summit. Last year we did it physically at the Imperial, but of course this year we are doing it virtually. So I'm sure it will grow. Thank you for your contribution. Back to you, Bhavna.
Thank you, Dr. Batra, and thank you once again to all our panelists for giving us your valuable time. Thank you once again.
Thank you very much.
Thank you so much. So, well, ladies and gentlemen, now it is time for the awards. Well, BW Legal Leader Awards are conceptualized in 2019 to recognize and reward the law firms and lawyers who've made a mark in their practice areas. Well, this is an annual initiative conceptualized to fuel excellence in the legal ecosystem by identifying and enabling law firms and individual lawyers who have the potential to lead the way. Well, this year the awards shall be presented in 33 categories and cover 34 winners. We feel absolutely honored to have the distinguished jury panel for this year's BW Legal World Legal Leaders Awards. And we're absolutely grateful to our august jury comprising of Honorable Mr. Justice Deepak Mishra, former Chief Justice of India, who's our jury chair. Honorable Mr. Justice Deepak Verma, former Judge of Supreme Court of India. Honorable Mr. Justice KPS Radhakrishnan, former Judge, Supreme Court of India. Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India. Senior Advocate and Member of Parliament, KTS Tulsi. Mr. Neeraj Kishan Kaul, Senior Advocate. Ms. Geeta Luthra, Senior Advocate, VP, Indian Council of Arbitration, FICCI. Well, thank you so much for taking out this precious time to interact with the nominees, evaluating their accomplishment and choosing the legal leaders for this year. And now, ladies and gentlemen, without any further ado, let's have a look at the AV. Could we have the jury AV, please?
When you talk about experience, it has to be stated with certainty. It has been an excellent and beautiful experience. You meet young minds and middle minds, come to know their CV and their achievements. Being a part of the jury, sometimes it becomes difficult to finalize, but our duty is to give the stamp of approval to the winner. In spite of the task being difficult, it's a pleasurable duty. And if I can put it in a different way, to borrow a phrase from a great poet in English language, it's an unbearable pleasure to explicate the pleasure is really quite a lot. As has been told, there has been a number of categories we have considered with keenness and due deliberation. Our attempt has been to judge from various angles and in a holistic manner. The persons who have joined this award competition, I must congratulate them for their sense of participation. Anyone might have achieved anything in life in this profession, but what matters is the public recognition. I must congratulate the participants, and I must congratulate without any kind of reservation the business world to organize such an event. Thank you very much.
For the first time, I am making a jury of selection of large number of awards. I was a jury for selecting 1 or 2 awardees, but this business world has taken so many awards, turning into almost 30 awards, more than 30 awards. I think it's, you are promoting the legal fraternity in all fields, so they will be encouraged to do much more, especially youngsters. Some of the topics you have selected is very good. New emerging lawyer, new lady lawyer. I think you are representing all sectors, from juniors to the senior most. Good that you are doing wonderfully well. And some of the awards I think we have to rethink next time. But by and large, it's absolutely a wonderful experience.
There has always been an intimate connection between the law and business. However, with the exponential growth of economic activities in recent years, that too having cross-border ramifications, legal issues are also becoming complex. In this scenario, role of lawyers is becoming more and more significant. It needs to be duly recognized and appreciated. With the launch of BW Legal Leader Awards, BW is doing a great service to not only the legal community but the business world as well. Though only in its 2nd edition, these awards have already achieved tremendous reputation. I congratulate BW for this pious and pioneer venture.
Well, what a great AV that was. Thank you to all our jury members for taking out your valuable time and being a part of this incredible awards. Well, ladies and gentlemen, the BW Legal World Legal Leaders Awards. Now, if I may request Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Business World, BW Legal World, and Exchange for Media Group, to kindly come on the screen and say a few words. Over to you, Dr. Batra.
Thank you so much, Bhavna. First of all, my gratitude to the jury chair, former Chief Justice of India, Justice Deepak Mishra, for making time and leading the jury and being constructive with the suggestions and making sure that the process was, it involved all the jury members and took their viewpoints into consideration. As I've said before, we are only custodians of the award. We do not decide who the awardees are. Our jury decides, and whatever the jury takes a call on is final. So really, they are as honest and transparent. And of course, this is the 2nd year. We have a lot to improve. We will improve. Justice Sikri was part of the jury in the 1st year. In fact, he chaired the jury in the 1st year. And he rightly used the word pious. We do it with absolute honest intent. And we will grow next year in terms of number of firms participating, number of professionals participating. And also there are learnings from this year's jury meet, which our jury has given to us. We'll incorporate all of those. And hopefully next year, instead of doing it virtually, we'll be doing it face to face and get an opportunity to meet all of you face to face. But I want to congratulate all the shortlisted entries and also the winners. They will be in BW Business World and BW Legal World. We haven't yet brought out a single print edition of BW Legal World, but in February we will. It'll be the first edition, and it'll be a collector's edition, I can tell you. So I want to congratulate all the winners. But our awards are a lot about our jury. So my big gratitude to Justice Deepak Mishra, to all the jury members who really made the awards up. And I won't stay between you and the awards. So back to you to invite Justice Deepak Mishra to say a few words, and then we start the awards. Thank you, Bhavna.
Absolutely. Thank you so much, Dr. Batra, for joining us, and definitely waiting for the collector's edition. Now, ladies and gentlemen, with this, I may request the jury chair, Justice Dr. Deepak Mishra, former Chief Justice of India, to kindly come on the screen and say a few words for our winners. Over to you, Dr. Deepak Mishra.
Mr. Batra, the learned members of the jury, participants, ladies and gentlemen, this is a great evening. The winners will get the award, and I must tell you, this is an award which has its own respectability. It's because there has been number of competitors, or let me say participants, in one category. It was extremely difficult to judge, though it was pleasant. Mr. Batra from the business world has been doing an excellent job by connecting the world of law and legal practice with the world of commerce and economy. This connection, I'm sure, will bring economic growth and upheaval of legal acumen in both the spheres. I do not intend to kill more time, because I know the eagerness of the awardees to receive the awards. And this winter, though all of us are in our cozy rooms at home, but still, let's treat this winter as winter. And I must part because the evening must melt into a quiet, powerful, and singing spring. Thank you. Thank you very much.
Thank you so much, Justice Deepak Mishra, and thank you for joining us. With this, Dr. Anurag Batra and Justice Deepak Mishra, we're going to be starting with the awards. And for this, if I may also request our jury member, if I could have Neeraj Kishan Kaul, Senior Advocate, if he could join us on the stage and screen to felicitate our winners. I'd now request Mr. Neeraj Kishan Kaul to kindly join us. Thank you so much, sir, for giving us your valuable time and joining us today. So, ladies and gentlemen, without further ado, it is now time to celebrate the winners. It is now time to move on to the first category of the evening, with our jury chair being present amongst us. Well, ladies and gentlemen, the first category of the evening is the Banking and Financial Services Law Firm of the Year. Let's see who the winner is. Can we have the winner, AV, please? Yes, ladies and gentlemen, Banking and Financial Services Law Firm of the Year goes to SMG and Partners, and may I request Anju Gandhi to kindly join us on behalf of the winners team. Requesting our winner to kindly join us on the stage and screen. Anju Gandhi, over to you. Congratulations, virtual applause. Let's get some momentum, ladies and gentlemen. Virtual applause for the lady out there. Over to you.
Congratulations.
Thank you very much. Thank
Yes,
you very
please.
much, sir.
Congratulations.
Grateful to the jury, really grateful for mentoring us and for picking us amongst the various eminent lawyers that we have. We strive as a firm, and this recognition is very, very important to us, especially from the jury who is, this is just an amazing moment. So I'm at a loss of words, frankly, but really grateful. Thank you very much. Thank you, everyone.
Thank you, thank you. If I may request our jury chair, Justice Deepak Mishra, to kindly say his congratulations. Over to you, sir.
I have already congratulated. They really deserved it.
Absolutely, at the very start, sir. Thank you so much. Dr. Batra, would you like to say any few words? Would you like to contribute?
I'm sure this is the first award of the year, and I wish you more accolades. Over to you, Mr. Neeraj Kishan Kaul. I was really not, except for being there for the first 1 hour, another 10 minutes, I was not, so I had no contribution, but the jury chair and Mr. Neeraj Kishan Kaul, who's very respected in the legal fraternity, they really decided. So, Mr. Kaul, we'd like you to say a few words.
Congratulations, Anju. I think your firm has done some wonderful work in many fields, especially in regulations and banking, and all the very best going forward to you.
So thank you very much, Mr. Kaul. Really grateful for this award and for the recognition. Thank you very much.
Thank you and congratulations once again.
Thanks. Thanks to Business World. Thanks a lot. Take care, everybody.
Thank you.
Thank
so, ladies and gentlemen, with this, let's move on to the next category, which is the Tax Law Firm of the Year. And it is now time to see who the winner is. Could we have the winner, AV, please? Ladies and gentlemen, Tax Law Firm of the Year goes to BMR Legal Advocates. And may I request from the winner team, Tarun Jain, to kindly join us on the stage and screen to accept the award. BMR Legal Advocates. Well, if I may request Tarun Jain to accept the award. If we do have Tarun Jain in, yes, right there. Over to you.
Respected members of the jury, Business World team, ladies and gentlemen. It's a great honor and privilege to be a part of this ceremony and being called upon to receive this prestigious citation. From our perspective, the recognition is timely as this year marks completion of 10 years of BMR Legal. We accept this distinction with pride and humility and are alive and cognizant of the responsibility it entails. Being one of the youngest in this elite fraternity, I would like to paraphrase Robert Frost. The words are lovely, dark and deep, but we have promises to keep and miles to go before we sleep and miles to go before we sleep. Thank you again.
Thank you and congratulations.
Congratulations to you.
Congratulations, Tarun.
Thank you, sir. Thank you.
Thank you. So Tarun must be feeling great with having everyone congratulate you, all the luminaries on the stage and screen. Thank you once again for joining us.
Thank you.
So ladies and gentlemen, with this, let's move on to the next category, which is the Competition Law Firm of the Year. So it is now time to have a look at the winner, and let's see who the winner is going to be. Could we have the AV, please? competition law firm of the year, it goes to Economics Laws Practice. Congratulations to the entire team, and may I request on behalf of Economic Laws Practice, Suhail Nathani and Ravi Shekhar Nair to kindly join us on the stage and screen to accept the award on behalf of Economics Law Practice. With this, if I may request our winners to join us on the stage and screen. Over to you. Congratulations. Please do accept our virtual applause.
Congratulations, Mr. Nathane. Congratulations.
Thank you, sir. Honorable Justice Mishra, eminent panel, Business World team. It is a great honor for us to receive this award because of the quality of the jury and the quality of the peers who are being considered for these awards. We take great pride in building practices, and I'm going to request my young partner, Ravi Shekhar Nair, who has been doing a lot of work with me in this area, to say a few words.
Thank you, sir, and thank you to Business World and the eminent jury. This really is a recognition that we hold close to our heart. It's heartening because of the company in which we were considered. And again, we take pride in this, and it just propels us to do better. So thank you very much for this, and really grateful for this. Thank you very much.
And a shout out to our entire team for making this possible at our end at Economic Law Practice. Thank you.
Congratulations, Sohail and Ravi. Congratulations.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you and congratulations once again. Well, ladies and gentlemen, what a great time it is turning out to be. And let's move on to our next category. Once again, congratulations to all the winners. Ladies and gentlemen, now for the Dispute Resolution Law Firm of the Year, it is now time to find out who the winner is. Could we have the winner, AV, please? Yes, ladies and gentlemen, for the Dispute Resolution Law Firm of the Year, it goes to Singh and Associates, Advocates and Solicitors. May I request Manoj Kumar from the team to kindly join us and accept the award on behalf of Singh and Associates. Requesting Manoj Kumar to join us on the stage and screen.
Thank you, Bhavna. Thank you very much. And thanks to the eminent jury and Business World for this award, and acknowledging our hard work in dispute resolution. As a growing firm, dispute resolution has always remained at the core of our growth. We have tried continuously to excel in the area by bringing in the new innovative way of creating the knowledge base within the firm, and then try to help the client in a different ways. And the idea is not only to run into the dispute, the idea is to prevent the dispute also. I mean, this is the philosophy, and definitely we are finding quite a favor in the industry on these issues. And this award is very special. Let me tell you, my friends has already, in fact, echoed that. The eminent jury here is, I mean, I had an occasion to work with all of the jury members one time or the other time, and it's an honor. I'm saying it. It's an honor to be here to receive the award from such an eminent jury. I feel really recognized today. Thank you very much for this.
Congratulations, Mr. Singh. Congratulations.
Congratulations, Manoj. Congratulations.
Wow, I absolutely love the energy and congratulations. I'm sure it's a very a moment filled with pride for you. Congratulations once again on that.
Thank you. Thank you, Bhavna. Thank you very much.
So ladies and gentlemen, now it is time to move on to our next award, and it is on the ADR Dispute Resolution Law Firm of the Year. Could we have the next winner, AV, please? and gentlemen, ADR Dispute Resolution Law Firm of the Year goes to PNA Law Offices. Congratulations. May I now request Akshat Hansaria to kindly join us on behalf of the PNA Law Offices as being the winner of this category. Congratulations once again. Akshat, if you're around, do join us on the stage and screen. Thank you so much. Accept our virtual applause. Over to you.
Thank you so much, Bhavna. It is indeed a pleasure and a gratitude to all the jury members who comprise of Justice Mishra, Justice Radhakrishnan, Justice Sikri, and other eminent senior advocates whom we have the occasion to work very frequently with. And it is the appreciation that matters. However, I would like to add, no award or no law firm can work without a team of associates who really start the work and who really help us achieve what we can. So this award I accept on behalf of Mr. Pathak, and more importantly, all the associates of my firm. And this just reminded me what the great basketball player Michael Jordan once said: talent wins games, but team wins championships. Thank you so much.
You remind us of the performance of the Indian team, Indian cricket team. Congratulations, Akshat.
Thank you so much, sir.
Thank you, and congratulations once again, Akshat.
Thank you very much.
So ladies and gentlemen, with this, let's move on to the next category, which is the Intellectual Property Law Firm of the Year. Could we now have the winner, AV, please? So ladies and gentlemen, well, as you can see on the stage and screen, the award goes to Intel Advocare. And could I now request Mr. Hemant Singh and Mamta Jha to kindly join us on the stage and screen to accept the award for the Intellectual Property Law Firm of the Year. Hemant Singh and Mamta Jha.
Thank you.
Congratulations, Mamta.
I'm so grateful, and it's a privilege to be here. Thank you to such a great luminaries. I'm speechless, and it's an absolute privilege to receive this award. When Justice Deepak Misra is there, Justice Mr. Neeraj Kishan Kaul is there, they all have been our ideals, and Justice Sikri being the jury. It's an absolute privilege. I really thank my mentor and our founding partner, Mr. Hemant Singh, who under whose leadership the entire team has really grown from pillars to pillars. Thank you for this recognition.
Congratulations, ma'am.
Congratulations, Mamta.
Thank you so much, sir. Thank you.
Thank you and congratulations, Mamta, and do pass it to Hemant Singh as well for taking it there. Thank you once again.
Congratulations, Ms. Jha, and congratulations to Mr. Hemant Singh also.
Thank you.
So ladies and gentlemen, with a lot of congratulations coming right there, let's move on to the next category, which is Restructuring and Insolvency Law Firm of the Year. Could we have the winner, AV, please? So well, ladies and gentlemen, for the Restructuring and Insolvency Law Firm of the Year, it goes to Shardul Amarchand Mangaldas & Co. And may I request Mr. Anup Rawat to kindly join us on behalf of Shardul Amarchand Mangaldas & Co. to accept the award. Over to Anup.
Thank you, the eminent jury and business world. This is
Anup, would you like to put your video on, just in case? Would you like to put your video on? Your video is not on.
I think it's... Yeah, for some reason I can't, just one second, just give me a moment. Just give me a
Yes,
moment.
because it's a huge moment for you. So I'd really like to get
Yeah,
you on the
just
stage
give me a
and screen.
moment. Yeah, just give me a moment. Yeah.
So ladies and gentlemen, this is all happening right here. What a great and incredible day this is turning out to be. And right now we're on our 7th category, which is restructuring and insolvency law firm of the year. And we've got Anup Rawat on behalf of Shardul Amarchand Mangaldas & Co. accepting the award. Anup, over to you.
Yeah.
It's okay, Anup. If in case you're not able to, I
Yeah,
can see you now. Perfect.
Yeah, I had to join through the separate device.
Yes,
Yeah.
please go ahead.
Yeah. It's a proud moment for the firm, and thank you, the eminent jury and business world. Each member of the insolvency practice deserves the applause for this award. This wouldn't have been possible without the leadership and the conviction of our national practice head, Mr. Shardul Shroff, who has been a great leader and has always motivated us for the excellence. I would close the speech with the passage from the movie Astronaut. You don't change the world by simply looking at it. You change it through the way you choose to live in it. Look up the sky lies open. We'll always aim high and we'll always reach there at the highest position. Thank you so much for the jury. Thank you for this award.
Thank you and congratulations once again.
Thank you.
Congratulations.
Thank you, sir.
So ladies and gentlemen, with this, we'd like to thank our jury, Neeraj Kishan Kaul, for joining us and giving us his valuable time. Thank you so much, Neeraj, for giving us your valuable time today. And if I may now invite Lalit Bhasin, Managing Partner, Bhasin & Co., to kindly join us on the stage and screen for the next set of awards alongside Justice Deepak Mishra and Dr. Anurag Patra. If I may request, Mr. Bhasin, if you're there, if you could just put on your video, and we'd love to have you for the next set of awards. Yes, you're right there. I know, Mr. Bhasin, you have to leave a little earlier. Just let us know whenever is the right time. I'll just get on to the awards till then. Thank you so much, sir, for your time.
Thank you.
So ladies and gentlemen, with Mr. Bhasin joining us on the stage and screen, it is now time to move on to the next set of awards. First up, Technology, Media and Telecommunications Law Firm of the Year. Ladies and gentlemen, let's have a look at the winner, AV, please. Well, it couldn't get any better. We've got two winners in the Technology, Media and Telecommunication Law Firm of the Year, Lex Counsel Law Offices and Nayak and Nayak and Company. Congratulations to both of them for winning Technology, Media and Telecommunications Law Firm of the Year. Now, first up from Lex Counsel Law Offices, if I may request Seema Jingan to kindly join us on behalf of Lex Counsel Law Offices to kindly accept the award. Seema Jingan, requesting you to join us on the stage and screen. Over to you, Seema. Congratulations.
Thank you so much. Thank you, the esteemed jury, business world. It's such a recognition for the firm, for us. I have been a witness to the start of the growth of the TMT sector in the last 2.5 decades. And it started with the opening of the telecom sector to consolidation of the policy for private participation to now to a more mature licensed regime. Our team has been very, very fortunate to represent quite a few businesses in helping them into satellite areas and slot coordination. And this would haven't been possible but for the wonderful team that we have at our firm. We hope to continue our work. We hope to be part of so many more recognitions in the same place. Thank you so much, Business World, once again.
Congratulations, Seema.
Thank you so much, Mr. Bhasin. Good to see you again.
Thank you.
Thank you, and congratulations once again. And ladies and gentlemen, I'd just like to call upon the winner. It is a joint win between Lex Counsel Law Offices and Naik and Naik and Company. Now, from Naik and Naik and Company, if I may request Madhu Godadia to kindly join us on the stage and screen. It's a prideful moment. Madhu, if I could request you to kindly put on your camera and join us on the stage and screen. You're right there. Congratulations. Over to you.
I accept this award on behalf of the team, the entire Naik team. Our managing partner, Mr. Amit Nayak, he could not be a part of this because his father, it is his father's birthday today, his late father's birthday today, and it's a very special moment for him, so he could not make it. But he said to express his humble gratitude for this award. I must say that this year has been a great learning for all of us, and especially because we are getting the TMT award. This year has been the year to learn new technology and new avenues on technology, and to learn how we could live in a virtual world and operate everything through the virtual world. And I think one of the best instances is the way the entire awards has been conducted virtually, with the jury flawlessly interviewing, conducting everything. So I must say that this is a very, very special award for us. Thank you very much. And I would just like to end with a very special quote, a poem, which is my managing partner's favorite poem. The woods are lovely, dark and deep, but I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. This is a Robert Frost poem. It's his favorite. So I thought I should end with this. Thank you so much on behalf of the team.
Thank you and congratulations. Quite a poetic turn right there, but definitely with a lot of wind coming there. Mr. Bhasin and Justice Deepak Mishra, if you'd like to say a few words. Mr. Bhasin first.
Yeah, just tell Amit Nayak, you see, that all the congratulations, and it's a very, very well-deserved award along with our other colleague Seema. So it's a great pleasure for us. Thank you.
Thank you, sir. I will tell him that.
Congratulations to both of you.
Thank you, sir. Thank you so much.
Thank you and congratulations once again. Ladies and gentlemen, now it is time to move on to the next award. First up, we're going to be going first to the Litigation Law Firm of the Year. Could we have the winner AV for the Litigation Law Firm of the Year? So ladies and gentlemen, for the Litigation Law Firm of the Year, it goes to Karanjawala and Company. And could I request Mr. Ryan Karanjawala to kindly join us on the stage and screen and accept the award on behalf of the Karanjawala and Company for the Litigation Law Firm of the Year. Congratulations.
Thank
Over
you.
to you.
I have many people to thank for this award. First of all, I must thank my friend Anurag and BW for initiating this award and for awarding such a prestigious award in such a prestigious function. I also have to thank the jury, the eminent jury, for being so kind and generous to us. A law firm, as you all know, is a collaborative exercise. And therefore, my largest and most special thanks goes out to my partners and all my colleagues, both present and past, because if it wasn't for their effort, we wouldn't be where we are today. There are two other categories I'd wish to thank. People who've been part of this collaborative exercise. One is, of course, the legal officers and the law officers, the legal managers and law officers of the various companies that brief us, because it is their input which ultimately shapes the litigation. And last, but certainly not least, to all the counsels that we brief within India and from abroad, who give the cutting edge to the arguments that allows the firm to win as often as it does, so that it ultimately is able to receive an award of this kind. Ultimately, this award will lie in the mantelpiece in my office, but in a sense, it really belongs to all of them. Thank you.
Congratulations, Mr. Karanjawala.
Sir, thank you so much.
Ryan,
I must say, I appreciate your concept of belonging and making it a collaborative effort along with all. That's really appreciable.
Thank you, sir. Thank you so much.
Yeah, Ryan, there could not have been anyone else but you and Karanjewala and Co. All the best. Thank you.
Thank you. Lalit, you've always been a great friend and a great supporter. Thank you. And stay healthy, stay well.
Thank you.
Thank you and congratulations. What a great win this is. Thank you so much, Ryan, for joining us, Mr. Karanjewala, for giving up his valuable time as well. Well, ladies and gentlemen, now it is time to move on to the next award category, which is the Private Equity Law Firm of the Year. And let's see who the winner is. Could we have the winner, Avi, please? For the Private Equity Law Firm of the Year, it goes to Lex Counsel Law Offices. Well, congratulations to Lex Counsel Law Offices, and may I request Dhruv Manchanda and Ankit Sahu to kindly join us, the winners from the Lex Counsel Law Offices. Dhruv and Ankit, if we may request you to kindly unmute yourself and join us on the stage and screen. Dhruv, I can see you. Thank you. And so can I see Ankit. Congratulations. Virtual applause coming right there for you.
Thank you, Bhavna. Good evening, everyone, and thank you so much to the respected jury, Dr. Anurag Batra, and the entire BW team for recognizing us for this award. It's a great privilege and honor for me on behalf of my entire team to receive this award. And thank you so much to all our partners and my entire associates team who has actually made us, win this award, do some great work, which has been recognized. Over to my colleague, Ankit.
Good evening, everyone. I would thank Business World team and the eminent jurists for bestowing this award onto us. I am accepting this award on behalf of my team with utmost honor and pleasure. I would also dedicate this award to my firm for providing this platform to do work which is award worthy. Thank you very much.
Congratulations.
Thank you, sir.
Bless. Thank you, sir.
Thank you, sir. Thank you.
Thank you.
Congratulations, congratulations, Dhruv and Ankit. I think you are a young and emerging law firm and many, many miles yet to go. So carry on with your good work. Thank you.
Thank you for your wishes. Thank you so much.
Ladies and gentlemen, some encouraging words right there from our jury. Thank you once again and congratulations. Well, ladies and gentlemen, now it is time to move on to the next category, which is the General Corporate Law Firm of the Year. Let's have a look at who the winner is. Could we have the winner, Avi, please? Gentlemen, for the General Corporate Law Firm of the Year, it goes to Cyril Amarchand Mangaldas, and congratulations to the entire team. May I request now Namrata Kolar to kindly join us on behalf of Cyril Amarchand Mangaldas on getting General Corporate Law Firm of the Year. Over to you, Namrata.
Thank you, Bhavna. It is indeed an honor and privilege for Cyril Amarchand Mangaldas to be receiving this award for this year. It has indeed been a very challenging year. And it is so great to see that the firm does not seem to have skipped a beat. And this award truly belongs to every single member of the firm, whether it's staff or whether it's the partners or the lawyers. And I take great pride in receiving this award on behalf of them. I thank Business World and the honorable jury members for recognizing this effort this year especially. And I'm truly grateful to both of you for awarding this to our firm. We only look forward to bettering our performance and services this year, staying true to our motto of being truly ahead of the curve. Once again, thank you so much, everyone.
Congratulations, Namrata ji.
Thank you so much, sir. Thank you so much.
Amrita, thank you very much. And please convey our best wishes and greetings also to Cyril and Vandana. Thank you.
Absolutely, sir. I will. Thank you so much, sir. Thank you. Truly grateful.
So, ladies and gentlemen, with Namrata getting the award on behalf of Cyril Amarchand Mangaldas, congratulations once again, Namrata. And ladies and gentlemen, with that, let's move on to the next category, which is Startups and Investments Law Firm of the Year. Could we have the winner, AV, please? Ladies and gentlemen, for the Startups and Investment Law Firm of the Year, it goes to Bergen Law LLP. Congratulations, and may I request Roma Priya and Abhay Vora to kindly join us on the stage and screen to accept the award for the Startups and Investment Law Firm of the Year. Roma and Abhay, if you're there, we'd love to. Yes, I can see Roma right there. Thank you so much and congratulations. Over to you, Roma.
Thank you so much. Thank you, Business World. Thank you, jury members. I think it's such an honor for a young firm like ours to receive this award. We are so honored to be here. I take this award and I receive it on behalf of our team who've striven to do everything they can and to get better every day. And also our clients who've been a big part of this journey and have supported us. It's such an honor to receive this award. And we hope to continue good work, and we continue serving our clients better. And thank you so much.
Congratulations.
Thank you.
Congratulations, Roma. This is the age of startup now. Therefore, from startup now you see to the other fuller activities. All the best wishes.
Yeah, thank you so much, sir. Thank you so much.
Thank you and congratulations once again, Roma.
Okay, thank you.
With this, ladies and gentlemen, I'd like to thank Mr. Bhasin for his valuable time. Thank you so much, Mr. Bhasin, for giving us your valuable time and being a part of the awards today. Thank you so much.
Thank you.
Thank you, Mr. Bhasin, for making time.
Thank you. Thank you so much. And ladies and gentlemen, with this, if I may request Geeta Luthra, our jury senior advocate, to kindly join us and grace her with her presence today for our next set of awards. Geeta Luthra, if I could request Ms. Luthra to kindly join us on the stage and screen. Well, ladies and gentlemen, this is all happening right here at the awards. Yes, Ms. Luthra, thank you so much for gracing us today and being a part of our jury. Thank you so much.
It's an honor.
So, ladies and gentlemen, with Ms. Luthra joining us, it is now time to move on to the next category, which is Capital Markets Law Firm of the Year. Could we have the next winner, AV, please? Capital Markets Law Firm of the Year, it goes to Link Legal India Law Services. Congratulations, and may I request Milind Jha on behalf of Link Legal India Law Services to kindly accept the award for Capital Markets Law Firm of the Year. Milind Jha. Congratulations. Virtual applause coming right there. Over to you.
Hi, good evening, everyone. I hope I am visible and audible.
Yes, you are. Please continue.
So, good evening, ladies and gentlemen. It's an honor for me to accept this award on behalf of our firm, Link Legal, and a wonderful team who puts in hours and hours of unflinching hard work to make us worthy of this recognition. I would also like to thank the publishers, Business World, BW Legal World, and the esteemed jury members for selecting us for this honor. and would also like to congratulate all the other winners and nominees. This is indeed a pleasure to be in such a distinguished gathering, and really a special feeling to be receiving this. Thank you so much for this honor.
Thank you and
Congratulations.
Thank you.
Justice, our jury chair, Justice Deepak Mishra, would you like to say something?
Okay. Congratulations. And I must appreciate the hard work you young people put in. And eventually you must accept and realize it's the hard work that pays.
Absolutely.
Congratulations again.
Thank you, sir. Thank you for your kind words.
Ms. Luthra?
So, Link Legal is a very renowned name in the legal field. They are leaders in many spheres, and I think we were all very happy to recognize them as the leaders that they are. So congratulations to Atul, to all of you who have made Link Legal what it is today.
Thank you. Thank you, ma'am. Thank you for your kind words.
Thank you and congratulations once again.
Thank you.
So ladies and gentlemen, moving on to our next category, which is Real Estate Law Firm of the Year. Let's have a look at the winner AV. Could we have the winner AV, please? So ladies and gentlemen, for the Real Estate Law Firm of the Year, and that goes to S&G and Partners. Congratulations, and may I request Sadhav Mishra on behalf of S&G and Partners to kindly accept the award for the Real Estate Law Firm of the Year. Over to you, Sadhav.
Good evening, everyone. Good evening, eminent jury. Good evening, team Business World. I am greatly honored and humbled to have received this award on behalf of S&G and Partners. I sincerely thank the eminent jury. The team S&G has been putting in for over many years, and it means a lot to lawyers like us who have started their career and who wants to kind of grow and wants to grow miles and miles. So this kind of recognition is definitely a great motivation to us, to the team S&G. Thank you so very much, the jury. Thank you so very much, Team Business World, for recognizing the work that we have been put in. I would like to sort of close my speech by saying just one simple sentence that मेरी मंजिलें अभी दूर है, मुझे रास्तों की तलाश है. This is just the beginning. Thank you so much.
Thank you and congratulations. May I request our jury chair, Justice Deepak Mishra, to kindly say a few words.
Congratulations. आपको मंजिल मिल जाएगी.
Thank you so very much, sir. Thank you.
Ms. Luthra?
Well, I can only say from what S&G has been doing and its partners have been doing that you're performing excellently, and clearly your sights are very high because you're already doing brilliantly well.
Thank you, ma'am. Thank you so much. Means a lot. Means a lot. Thank you so much.
Thank you and congratulations once again. Well, ladies and gentlemen, with this, let's move on to the next category, which is the Oil and Gas Law Firm of the Year. Could we have the winner, AV, please? for the Oil and Gas Law Firm of the Year, it goes to Singularity Legal LLP. Congratulations to Singularity Legal LLP, and may I now request Jimmy Shah on behalf of Singularity Legal LLP to collect the award for the Oil and Gas Law Firm of the Year. Jimmy Shah, over to you.
Thank you, Bhavna. Thank you so much to the jury members and Business World for giving this opportunity and the recognition. It really feels great because oil and gas is the dispute resolution field records the highest number of disputes from the oil and gas sector. And being a dispute resolution boutique, we feel really great to have been recognized for Oil and Gas Firm of the Year. Thank you so much to our clients, peers, well-wishers, and our team at Singularity. Thank you.
Congratulations.
Thank you, Mr.
Congratulations, Ms. Dalal.
Thank you, Mr. Batra. Thank you.
If I may request Ms. Luthra.
So it's really wonderful to see such young people doing so well. We can
Thank
only
you so
clap
much.
our hands in glee.
That's
Congratulations.
very kind. Thank you so much.
Absolutely. Thank you so much, and congratulations once again, Jimmy Shah.
Thank you, Bhavna. Thank you, Bhavna.
So, ladies and gentlemen, a lot of congratulations coming right there, and the young faces as well. That's great to see. And ladies and gentlemen, with this, let's move on to the next award category, which is the Insurance Law Firm of the Year. Let's have a look at who the winner is. Could we have the winner, Ravi, please? So, ladies and gentlemen, for the Insurance Law Firm of the Year, it goes to R&S Associates. Congratulations to R&S Associates for getting the Insurance Law Firm of the Year. May I request Neeraj Singh to kindly join us on behalf of R&S Associates. Thank you so much and congratulations. Neeraj, over to you. If I may request Neeraj Singh from R&S Associates to kindly join us on the stage and screen. Do we have Neeraj joining us? I just request one of our team members to kindly confirm on the same. Ladies and gentlemen, we're all right now at the legal awards happening currently, and we're right now on the 17th category, which is the Insurance Law Firm of the Year. So I believe Dr. Batra, Neeraj is unfortunately not with us right now. I cannot place him on the stage and screen.
When he joins again, we can resume it.
Yes,
I'm sure sometimes you have technical glitches. We should move on.
Yes, perfect. Thank you so much for the confirmation. Well, ladies and gentlemen, with this, let's move on to the next category, which is Environment Law Firm of the Year. Could we have the winner, AV, please? Ladies and gentlemen, for the Environment Law Firm of the Year, it goes to Trust Legal Advocates and Consultants, and we're going to be joined by Patel Chandok, who's going to be joining us on behalf of the Trust Legal Advocates and Consultants. May I request him to kindly join us on the screen?
Lady, Bhavna, it's a Miss Patel Chandok.
I'm so sorry. May I request
Unless until...
Yes,
thank you, Bhavna. Thank you very much. I sincerely thank the esteemed jury and BW for recognizing the firm Trust Legal for this award. It is truly, truly wonderful to having received it from Justice Mishra and Ms. Luthra. So environment law practice is a core practice of the firm and is very close to our heart, especially our managing partner, Mr. Sudhir Mishra, who's spent most of his practice years in this practice. So I really received this award on behalf of our entire team, led by him, Mr. Mishra, Mr. Sudhir Mishra, and truly an honor for all of us. Thank you very, very much.
Thank you.
Congratulations, ma'am.
Thank you so much, sir.
Ms. Luthra?
Yes, congratulations, Petal. Congratulations to Sudhir. I know environment, wildlife, all that is so close to your hearts, and you've been doing a great pioneering work. So congratulations.
Thank you very much, ma'am.
Thank you and congratulations once again, Petal, for joining us and giving us your valuable time. Ladies and gentlemen, moving on to our next category, which is the Policy Law Firm of the Year. Could we have the winner, AV, please? Ladies and gentlemen, for the Policy Law Firm of the Year, and it goes to HSA Advocates. Congratulations, HSA Advocates, for getting the Policy Law Firm of the Year. And may I request joining in from HSA Advocates, Pooja Priyadarshini and Shresh Sharma to kindly join us on behalf of HSA Advocates. Pooja and Shresh, thank you so much.
Thank you very much, Bhavna. Thank you very much for this recognition. My partner Pooja and I accept the award on behalf of the firm, and thank the eminent jury who's taken time out for considering us and granting this honor. I repeat that this is an absolute honor for us, coming from such members of eminent jury who not just inspire us to be better individuals every day, but better professionals as well. We also take this opportunity to thank our clients who have put their honest faith in us to perform and give us the time to showcase our ability. Also, I take this time to thank our team and Mr. Hemant Sai, our founding partner, who has been working tirelessly over the number of years to achieve this opportunity and perform. Over to Pooja, who would like to say some words as well.
Good evening, everyone. We are very, very grateful for this recognition. We'd like to thank the esteemed jury and the BW team for recognizing our efforts. And we'd also like to thank our clients and colleagues for enabling us in every step of our journey. Thank you so much.
Thank you very much.
Congratulations to both of you.
Thank you, sir.
Thank you, sir. Thank you very much.
Congratulations to Hemant and congratulations to both of you for doing the kind of work you do in the policy area. So, congratulations.
Ms. Luthra?
Congratulations to both of you. Congratulations to Hemant. Your field, you are doing super work, and that's why you are number one. Great.
Thank you very much, ma'am. Thank you very much. So kind of you.
Thank you and congratulations. But also to bring to your notice, thank you first once again to the winners. We just announced the winner, which was the Insurance Law Firm of the Year, RNS Associates. And that was the 17th category. And we do have the winner joining us live right now. So Neeraj Singh is going to be joining us live right now on the stage and screen. Neeraj, if you are around, I just request you to please kindly unmute yourself and put the video button on. Neeraj Singh. So ladies and gentlemen, just requesting Neeraj Singh, RNS Associates Insurance Law Firm of the Year. Neeraj, if you're around, this is our second attempt. We're hoping we can get you on the screen. Yeah, over to you.
First of all,
congratulations.
Thank you very much for this special recognitions and the award. I am very thankful to the jury member, Honorable Justice Deepak Mishra, Geeta Luthra ma'am, and others for considering my law firm RNS Associate for this special award in the insurance sector. These awards I dedicate to my whole team, my associates, my partners, my juniors who have assisted me in giving the best services to the clients in the insurance related litigations. And it is just because of the support of my associates, my junior partners, and my other staffs, and trust of the clients, I have delivered the results in the insurance sectors, insurance-related litigations. And as you know that in the present pandemic situations, everybody has realized what is the importance of the insurance sector, whether it is health or industry or business. Thank you very much. And congratulations to all the winners. Thank you.
Mr. Singh, congratulations. And in the light of it, you can ensure this award.
Thank you a lot, sir.
Thank you, Justice. Congratulations, Mr. Neeraj Singh.
Thank you, sir. Thank you.
Ms. Luthra? Ms. Luthra, you're on mute. Just requesting you to unmute yourself, please.
Is that fine?
Yes.
Congratulations. Well done. And may you go a long way.
Thank you, ma'am. Thank you.
So a lot of congratulations coming right there, Neeraj. Congratulations once again.
Thank you.
Ladies and gentlemen, with this, let's move on to the next category, which is the Legal Tech Leaders of the Year. Let's see who the winner is. Could we have the winner, AV, please? For the Legal Tech Leaders of the Year, it goes to Lawyer, and may I request Himanshu Gupta on behalf of Lawyer to kindly join us in the acceptance of the award for the Legal Tech Leaders of the Year. Himanshu Gupta.
Thank you, Bhavna. Good evening, everyone. On behalf of my co-founder Ashish and the entire Lawyer team, I would like to thank the respected jury members for recognizing us and the good work that the Lawyer team is doing in the legal tech space. Special thanks to the business world for providing such a wonderful platform and honoring the winners. On this day, let me take the privilege to recite a shloka from Srimad Bhagavad Gita. It says, Karmanye vadikaraste ma phaleshu kadachan ma karam phal hetu bhurmeta samvatsva karmani. It rightfully teaches us that you have to perform your prescribed duty, but you're not entitled to the fruits of action. During COVID-19 pandemic, the entire Lawyer team kept working hard to make things better for the legal ecosystem. And it is indeed an honor today to accept the recognition of the hard work that the entire team was doing. Without forgetting to mention the friends and family members with their undying support and the investors for having their faith in us, this is definitely a team award. To conclude, I would like to quote, "The woods are lovely, dark and deep, but I have promises to keep and miles to go before I sleep. And miles to go before I sleep." Thank you so much, guys.
Congratulations.
Thank you.
And I must presently say that a young man quoting a shloka from the Gita and understanding it correctly is really appreciated.
Thank you so much, sir.
And I must tell you, you are the fourth person quoting Robert Frost today. We have gone Frostian. That's good.
The same couplet. And Justice Mishra, I must tell you that when I was younger, when I was 10 odd years, my father put it on my table. He was a professor of chemistry. He eventually became a principal. So he used couplet as my guiding light. So, you know, it's good to hear it again and again.
No.
So I wanted to say, I thought Justice Mishra, who's the authority on all the shlokas, would supplement it with something for us. I was waiting for sir.
No. You see, this is not the occasion. Otherwise, I'm happy that he has quoted it properly and appropriately also. Good. Congrats.
Thank you so much, sir. Thank you so much.
Congratulations.
Thank you so much.
Great.
So ladies and gentlemen, with Himanshu Gupta on behalf of Lawyer getting the Legal Tech Leaders of the Award of the Year, let's move on to the next category, which is the Best Service Provider to Legal Sector of the Year. Could we have the winner, AV, please? gentlemen, for the best service provider to the legal sector of the year, it goes to Legal League Consulting. Congratulations to the entire team. May I request now Deepika Anand and Nipun Bhatia to kindly join us on the stage and screen on behalf of Legal League Consulting to accept the award for Best Service Provider to the Legal Sector of the Year. Deepika and Nipun. Yes, we can see you, ma'am.
Yeah.
Over to you.
Yeah, all right. Thank you so much, everybody who's there. The journey of 10 years of Legal League Consulting has been very fulfilling, challenging, and interesting. And we are privileged to be able to value add to the legal profession in different facets. This award goes to all our clients, all those who have supported us in this endeavor, which has been so unique and different. And finally, my team, and with a very, very special mention to Nipun Bhatia, who's right there. And we also thank the esteemed jury and business world, and of course, Anurag, whom I have known for very long and is indeed a dynamic businessman and has done great and is doing now great work for the legal industry. Hats off to you, Anurag. And also cheers to all of you. Thank you so much. Nipun, you want to say something?
It's a very exhilarating moment for all of us because 10 years of hard work, and thanks to BW Legal and such a coveted platform for recognizing our work. I thank to all our clients. A lot of you are present here. Thanks for giving us a chance. And it's been amazing to work for this maverick woman, Bitika, whose vision to transform and bring professionalization to the whole business, to the whole legal sector. It's been great, and I thank all of you. Thank you so much.
Congratulations, Bitika ji, and congrats, Mr. Nipun.
Thank you, sir.
Thank you. Thank you so much.
Thank you, Bitika, and congrats, Nipun. And it's the first time somebody called me a good businessman, so I feel like I got an award. So thank you so much. I do things out of passion, and we try to be a perfectionist. It's really the jury that makes the awards and the time they spend. So I'm really grateful to the jury. That's what differentiates. We're only custodians of the process. And as the award goes by to third, fourth year, I think we'll be close to perfection. So really grateful again to the jury members.
Absolutely.
Ms.
Geeta Luthra and Justice Deepak Mishra for being here today, as well as making so much time on the day of the jury meet. And I'd like to let all the winners know that the first day we could not complete. That some of you have to come on the second day, and Justice Mishra was kind enough to allocate time and were so were a lot of other jury members. So really grateful to them again. These are early days for BW Legal World, but we would make a difference. So thank you so much again to the jury, and congratulations to you, Bitika and Nipun.
Thank you, Dr. Batra. Ms. Luthra.
Anurag's being very kind, but thank you, Anurag. You are the force behind it all, as you know, and I think you're doing a brilliant job. Thank you, Bitika. Thank you, Nipun, and congratulations. Great job. May you keep doing as well and even better.
Thank you. Thank you, ma'am.
Thank you and congratulations. Well, ladies and gentlemen, with Bitika and Nipun joining us from Legal League Consulting, now it is time to move on to the next category, which is the Counsel of the Year, Independent Practice Above 50. Could we have the winner, AV, please? Gentlemen, the winner of the Counsel of the Year Independent Practice Above 50 is Gaurav Banerjee. Congratulations, Gaurav Banerjee, for winning this title. We'd request you now to join us on the stage and screen. Over to you, Mr. Banerjee.
Well, 2020 has been an extraordinary year for all of us, and I must thank the distinguished jury for this signal honor. It came as I'm really overwhelmed by this. At the outset, I wanted to seek the blessings of my elders in the profession and my colleagues. All of you know me well, and I just wanted to add a couple of things. This would not have been possible but for my juniors, past and present. So it is not an award for me, it's really an award to them and the way they've supported me through the years. And last but not least, I would like to thank my family who have supported me through very difficult times initially and who support me still. Thank you, Chief Justice Mishra. Thank you, Business World. Thank you, Geeta. Thank you for this.
Congratulations, Gaurav. It's really a pleasure to recognize you as most great independent lawyer of 2020.
Thank you, sir.
2020 can never be forgotten, and you shall not be forgotten.
Thank you, sir. That's so kind of you. I really, it's such a major milestone for me. Thank you, sir.
Dr. Batra?
Congratulations, Mr. Banerjee. And I may add, when it comes from justice, I do many jury meet, but I can tell you with the kind of seriousness Justice Deepak Mishra and with the kind of thoroughness and all other jury members conducted it, somebody like me who still has some years to go, no hair to go, but some years to go, I just marvel at the kind of meticulousness and the intensity Justice Deepak Mishra and all the other jury members like Geeta Luthra bring, and so you're right, when you get it from seniors and respected jury members who are in the legal profession are so respected, plus have seen the heights of the profession, it is really special. So I congratulate you, and I again I'm grateful to the jury, because really awards are only about the jury and the jury process. So really congratulations to you, Mr. Banerjee.
Thank you, Dr. Batra. Thank you, Chief Justice. Thank you, Geeta. Thank you so much.
Yes, great accolades to you. Congratulations.
Thank you.
Nice.
Congratulations. Well, ladies and gentlemen, after Gaurav Banerjee getting the Council of the Year Independent Practice above 50, it is now time to look at who has won the Pro Bono Lawyer of the Year. Could we have the next winner, AV, please? Ladies and gentlemen, right now for our next winner, which is the Pro Bono Lawyer of the Year, it goes to Vivek Narayan Sharma. Congratulations, Vivek, on winning the Pro Bono Lawyer of the Year. May I now request you to join us on the stage and screen. Thank you so much. Over to you.
Namaskar, and thank you so much. Thank you, Ms. Bhavna. Thank you, eminent jury and respected members. Thank you, Business World, and mostly thankful to the utmost thank to Mr. Dr. Anurag Batra. And I feel that he is really worth a bigger award than all of us have got together, because he is able to pioneer something which has not been there in legal field. And definitely recognition makes people do wonder. And this is a very special moment, as I feel today's recognition would inspire youth lawyers to help build a better nation each passing day. This award is dedicated to all those who gave me the opportunity to be by their side, and to my family who has always been by my side. And I congratulate all the winners today, and happy Republic Day in advance. And my utmost thanks to the jury members, Honorable Mr. Justice Deepak Mishra, whom I had been a great fan always, and I will ever remain. And Ms. Geeta Luthra, learned Mrs. Geeta Luthra, and she had been a remarkable lawyer. And my thanks to all the jury members at the same time. Thank you so much.
Congratulations, Vivek. Just carry on. Just carry on.
Ms. Luthra?
Congratulations, Vivek. I've been seeing you for last many years and great work. Please carry on, as Justice Mishra said.
So ladies and gentlemen, a lot of congratulations coming right there. Thank you so much, Vivek. And once again, congratulations on the Pro Bono Lawyer of the Year. So ladies and gentlemen, let's move on to the next category, which is the most innovative lawyer of the year. Let's have a look at who the winner is. Could we have the winner, AV, please? So ladies and gentlemen, for the most innovative lawyer of the year, and that goes to Safir Anand. Congratulations, Safir Anand, for getting the most innovative lawyer of the year. May I with this request you to kindly join us on the stage and screen. Over to you.
Thank you so much. I'm really humbled by this recognition. There's nothing more meaningful in life than to get a pat from legends. And as a child, I have seen many of your jury members already so successful in life that they've always been a source of inspiration. My special thanks also to Dr. Anurag Batra, who I've known for many years. I don't think Dr. Anurag Batra ever rests. Every time he wants to innovate. So in a true sense, he's an innovator, and he himself is such a source of inspiration. A big thank you to business world and to legal world. A big thank you to the entire legal fraternity, because each one of us complements each other. There's no way there can be a winner without a course competition. And I think in every competition, there are traces of knowledge that add up. And knowledge is the biggest empowerment that a person can ever dream of. I'd like to congratulate all the winners of this evening. All of you make the legal fraternity so complete. I'd also like to thank every member of my law firm, Anand & Anand, of which I'm only a symbolic part. And I'd like to send a word of encouragement to all the young aspiring lawyers. This is one of the most beautiful fields to be in. You would be in control of the past when you study precedents, and you would be in control of the future because you will shape it. So my best wishes to everybody. And I'm really, truly humbled by the award. Thank you so much.
Congratulations. And I would like to share a line with you. Innovation is the Ellen Vital of life. And you are an innovator. Congratulations again.
Thank you for your blessing, sir.
Ms. Luthra?
Congratulations, Safir. Third generation lawyer, one doing better than the other. Each generation is topping the other. So wonderful, wonderful to keep the legacy going.
Thank you for your encouragement. You're always been very inspiring.
Thank you and congratulations, Safir, for getting the most innovative lawyer of the year. Congratulations once again.
Thank you again.
So ladies and gentlemen, now moving on to the next category, which is the best ADR lawyer of the year. Let's have a look at who the winner is. Could we have the winner, AV, please? Ladies and gentlemen, for the best ADR lawyer of the year, it goes to Divyam Agarwal. Congratulations, Divyam, for getting the best ADR lawyer of the year. May I now request you to please put your video and audio on and accept the award. Over to you, Divyam.
It is indeed a huge honor and privilege to receive this recognition. I thank the distinguished jury of Chief Justice Mishra, Justice Sikri, Justice Verma, Justice Radhakrishnan, Mr. Kaul, Mr. Tulsi, and Ms. Luthra for finding me worthy of this recognition and for bestowing me with this incredible honor. I must congratulate Dr. Batra, BW team, BW legal team for putting together this wonderful and flawless show. Many congratulations to all my fellow winners as well. This accomplishment is not something that I did alone, and there are many others who deserve to share this award. I would like to thank my firm, JSA, my colleagues, my clients, counsels, and my seniors at the bar. Last but not the least, I thank my family for the sacrifices they have made for my success. Since Robert Frost is the flavor of the day, I would like to end by saying 2 roads diverged in a wood, and I took the one less traveled by, and that has made all the difference. Thank you very much.
Congratulations. And in fact, you are quoting a different line from Robert Frost, and this is really more difficult road that you have chosen. Congratulations, Mr. Agarwal.
Thank you, Chief Justice Mishra.
Ms. Luthra?
Congratulations. It's lovely to see you on the other side receiving a wonderful award, which you well deserve. Congratulations.
Thank you so much,
Great.
ma'am. Thank you.
Thank you. Well,
Congratulations, Mr. Agarwal. Congratulations.
Thank you, Dr. Batra.
Thank you, Dr. Batra. Well, ladies and gentlemen, we've got a couple more awards, and we have to really speeden up because we've got our eminent jury as well on the stage and screen. So, ladies and gentlemen, up next for the Best Tech Lawyer of the Year, could we have the winner, AV, please? So, ladies and gentlemen, for the Best Tech Lawyer of the Year, and that goes to Advocate Puneet Bhasin. Thank you so much, Advocate Puneet Bhasin, for joining us today. I'd now like to leave the stage over to you.
Good evening. I'm really thankful to the jury members and Anurag Ji for giving me this honor. And first and foremost, yes, thanks to God for making this entire journey possible in this profession, which was absolutely new in terms of tech law when I started off. And today, I think it's gained a lot of momentum over the years. And I'd definitely like to thank my parents, my in-laws, my husband, my sister, everybody who's been a part of this journey to make this possible today. And definitely even to all the competitors who gave tough competition in order to make a person strive harder to achieve everything. So definitely a thanks to everyone out here for making this possible. And more than anything, definitely my clients.
Congratulations.
Thank you, Deepak.
And without the competition, the award has no meaning.
Yes.
That's why the recognition.
Thank you very much.
Thank you, Ms. Luthra.
Thank you. It's wonderful, wonderful, and congratulations. May you keep doing well. May you keep aspiring to do better, and may you achieve even more.
Thank you. Thank you, Geeta ji.
Thank you and congratulations, Advocate Puneet. I believe you were also completing that you'd like to thank your clients also. So if you'd just like to, I believe that's where we couldn't hear it. Would you like to say something beyond that?
Yes. I'd say no award is complete without thanking the clients who have been a part of the entire legal journey. Without them, honestly, there is no legal journey.
Sure, absolutely. Well said. And congratulations once again.
Thank you.
So ladies and gentlemen, let's quickly move on to the next award category. We've got a couple more awards coming up on your stage and screen. First up, for the Best M&A Lawyer of the Year, let's see who the winner is. Could we have the winner, AV, please? So ladies and gentlemen, for the Best M&A Lawyer of the Year, it goes to Ajit Mishra. Congratulations, Ajit, for getting the Best M&A Lawyer of the Year. May I now request you to join us on the stage and screen. Over to you, Ajit.
Hello.
Yes. If you
Can you
would
hear
like
me?
to put your video on, Ajit. Thank you. Yes, we can hear you. Over to you.
I'm trying to do that and I
Yes.
can. Yeah. Hi, thank you so much. Thank you so much. What should I say? Thank you so much, Bhavna. It's my honor to receive this award, especially when jury is so eminent. Dr. Batra is there, who has been working so hard, who has always been an inspiration. But I should say, each and every award That's a celebration, but that brings responsibility as well. Responsibility to do better. So thank you so much for making me more responsible. Thank you.
Congratulations, Mr. Mishra.
Thank you so much, sir. Thank you so much.
Congratulations, Mr. Mishra.
Thank you so much, Dr. Batra. Thank you.
Ms. Luthra?
Well done. Congratulations. Great.
Thank you. Thanks a lot. Thank you.
Thank you and congratulations. Well, ladies and gentlemen, with this, let's quickly move on to our next award category, which is the Best Real Estate Lawyer of the Year. Let's have a look at who the winner is. Could we have the winner, AV, please? So, well, ladies and gentlemen, for the Best Real Estate Lawyer of the Year, and that goes to Namrata Kolar. Namrata, congratulations on getting the Best Real Estate Lawyer of the Year. May I request you to kindly join us on the stage and screen. Over to you.
Thank you, Bhavna. It is indeed an absolute honor and privilege to be receiving this award. I want to thank Business World and the formidable panel of jury for considering me worthy of this award. And what a formidable panel of jury it was. Truly honored and truly grateful for considering me worthy. I have a few people to thank. First and foremost, I would like to thank my entire team, without whose dedication, commitment, and hard work this award would not have been possible. And I'm accepting this award on behalf of them. I would also like to thank my clients for reposing their faith in me. I would like to thank my managing partners, my firm, everybody in the firm who's always been a great pillar of strength to me. And last but not the least, I would definitely like to thank my family and friends whose undying support has made this possible. And of course, not to forget the competitors. As somebody said, it is because of them that we truly are worthy of this award, and it makes us strive harder and makes us work harder to be worthy of this award. So once again, I thank Business World and the jury members for this award, and thank you.
Congratulations, ma'am.
Thank you so much, sir. Indeed an honor.
Ms. Luthra?
Congratulations. Congratulations. Teamwork is important, but so is the leader. So double congratulations to you.
Thank you, ma'am. Thank you. Truly grateful.
So, ladies and gentlemen, with Namrata Kolar getting the Best Real Estate Lawyer of the Year, let's move on to the next category, which is the Best Legal Entrepreneur of the Year. Let's see who the winner is. Could we have the winner, AV? So, ladies and gentlemen, for the Best Legal Entrepreneur of the Year, and that goes to Mansi Chaudhary. Mansi, congratulations on getting the Best Legal Entrepreneur of the Year. And if I may request you to join us on the stage and screen, over to you.
Thank you so much, Business World and esteemed jury, for this award. It is truly an honor to receive this recognition from such an esteemed jury panel who are idols to all of us in the legal fraternity. And this award is even more special because it comes to Pink Legal in its very first year of the enterprise. We hope to continue our work towards women empowerment and gender equality, and today's recognition gives us further impetus to do so. I would also like to thank my entire team at Pink Legal for being the backbone of the enterprise, and my family for being the wind beneath my wings. So thank you once again, honorable jury members and Business World, for helping us start 2021 on such a positive note. And we look forward to a great year and your continued support. Thank you.
Congratulations.
Thank you, sir.
Congratulations, Ms. Chaudhary.
Ms. Luthra?
Thank you, sir. Thank you so much.
Congratulations. may the entire decade be wonderful for you. May you keep doing better and better.
Thank you so much, ma'am.
So thank you so much,
Thank
Mansi.
you so much, ma'am.
Congratulations for the
Truly
Best
honored.
Legal Entrepreneur of the Year. And ladies and gentlemen, we are, in interest of time, moving on to the last 4 categories of the day, which is first up, the Emerging Law Firm of the Year. Let's see who the winner is. Could we have the winner, Avi, please? So congratulations to Newman Law Offices for getting the Emerging Law Firm of the Year. And may I request Arush Khanna and Chaitanya Bhandarkar to kindly join us, Arush and Chaitanya, to join us on behalf of Newman Law Offices. Over to you.
All I can say is that as a young and emerging law firm, we accept this honor with utmost humility and responsibility. And we at Newman Law Offices, it's been a hard 2020 for us. It eroded the revenues, but could not erode the spirits, prefers to be called, and his entire team for this truly unique idea of congregating the finest legal minds in the country. And it's truly a dream come true for us young lawyers. My heartfelt gratitude to all the people, all the honorable people in the jury, especially Geeta ma'am, who's seen me ever since, my nascent years in practice. I've had the good fortune of, traveling around and other conferences. So thank you so much for having faith in us. And I hope that we at Newman Law Offices can make you proud. Thank you, everyone. Have a wonderful weekend. Thank you.
Thank you, Arush. Chaitanya?
It's truly an honor to be receiving this award, having been nominated by such an eminent jury. Being a new firm, it's a very, very great piece of encouragement for us to not let the jury members down and keep serving our clients with the utmost honesty and to help them get better results.
Congratulations to both of you.
Thank you so much.
Ms. Luthra?
Congratulations, Arush. Congratulations, Chaitanya. Super, very, very well done. Considering you have just now taken first steps and have made such a mark for yourself. Very, very good. Great.
Ma'am, thank you so much.
Thank you so much, ma'am.
Thank you.
Thank you and congratulations once again.
Congratulations, Arush and Chaitanya. God bless you.
Thank you, sir.
So ladies and gentlemen, after this, let's move on to the last 3 categories which we have. First up, for the Law Firm of the Year, could we have the winner, Avi, please? So ladies and gentlemen, for the Law Firm of the Year, and that goes to Lakshmi Kumaran and Sridharan. Congratulations. Could I request V. Lakshmi Kumaran to kindly join us on the stage and screen on collecting the Law Firm of the Year. Over to you.
Thank you, Bhavna. My Honorable Justice Mishra and my favorite friend Geeta, and of course my very good friend Anurag, and all the jury members. It is a long journey for a person coming from a remote village in Tamil Nadu with a humble beginning. And this jury thought it fit to give an award to this firm as the best law firm of the year. I would say that all these years, my office was my home. And this year, my home became the office. Nothing changed. The same continuous work, morning till night, hard work, high ethical standards. I am only reminded of the last sloka of Bhagavad Gita. Yatra Yogeshwara Krishna, Yatra Partho Naludhara, Tatra Sujiyo Bhuti, Dhruvan Vimatimama. Where there is Lord Krishna's blessings, and where there is Partha with his Gandhi, victory is destined. I am Krishna Bhakta. My only weapon is law books, nothing else. And today I am told that the good firm of the year, I accept with all humility at my command. I dedicate this award to all the team members of my family, the firm. Thank you very much, all of you. Thank you.
Congratulations, Mr. Lakshminarayan. And you have delightedly and excellently quoted the shloka from the Gitas. Ma'am Gita Luthra was telling some time before that I must also quote. I can compare your activity as you stated that your home became office. Nothing changed. That unchangeability can be compared to this shloka. Nainang chindanti sastrani, nainang dahati pavakaha, na chainang kayandayantopo, na sosayati marutaha. Nothing can destroy the action. And that is what matters. Congratulations again, Mr. Lakshmi Kumaran.
Thank you.
I am overawed by the words of both the awardee as well as my jury colleague. So I have nothing to say but congratulations and congratulations again. Great.
Congratulations, Mr. Lakshmi Kumaran.
Thank you.
Thank you. And thank you, ladies and gentlemen. Thank you and congratulations once again, sir, getting the Law Firm of the Year. Congratulations. Well, ladies and gentlemen, now for the final two categories. First up, the Women Lawyer of the Year. Well, this is getting interesting. Let's see who the winner is. Could we have the winner, AB, please? For the Women Lawyer of the Year, and that goes to Pallavi Shroff. Congratulations, Pallavi, for getting the Women Lawyer of the Year. Ms. Shroff, now it's time we request you to join us on the stage and screen. Over to you.
Oh, I don't know. I have.
Yes, you're very visible and audible. You're center stage. You're center stage.
Good evening, everyone. We have such an eminent jury for this award, and it is indeed an honor for me to be selected as the Woman Lawyer of the Year, and I accept this award with all the humility at my command. I think with getting any recognition or award, it gives us greater responsibility, particularly to the next generation of lawyers and women lawyers who are now in the profession and ever ready to help them and guide them and mentor them to achieve greater heights. I think we at Shardul Amarchand Mangaldas value very much the fact of gender diversity, gender inclusion, and for religious inclusion. And we are an inclusive firm. We believe a lot in women empowerment and make small things happen that encourage women to continue to work and continue to work long hours, such as having a creche, a daycare center within our premises, and having flexi hours and other facilities for them. Such awards are not possible without the blessings of our elders. And I would like at this point to seek the blessings of both my father and my father-in-law, who have been to me a life mentor and a professional mentor. My father-in-law particularly, who's been my professional mentor. And it's their training in the initial years of my career that has actually helped me to be what I am today. And to my father, because I have tried to imbibe all the qualities that he demonstrated, both as a human being and as a judge of this country. And I think the other thing I would like to state is that all of us need to thank our parents. And father I have thanked, but my mother equally I would like to thank, for she has been the backbone who gives us the values of our life by which we live our life. With that, I'd say thank you very much, jury members, for recognizing me and giving me this award, particularly when 2020 has been one of the most difficult years for all of us. I would also like to thank the firm and my husband Shardul for giving me all these opportunities for over the years. And of course, I've taken them, and the firm in particular. And thank you very much, all of you.
Thank you and congratulations, Ms. Shroff. Also, I'd just like to bring to the notice of everyone that the Mergers and Acquisition Law Firm of the Year goes to Shardul Amarchand Mangaldas & Co. And Pallavi Shroff is right here on behalf of the company as well, to the firm as well, to collect the award. So I just wanted to add that as well, and the more the merrier. So congratulations on that.
Thank you. Thank you.
I'll leave it up to the jury to say a few words. Over to you.
Thank you.
Congratulations, Pallavi ji.
Thank you, sir. Really, thank you very much.
And I must say, I'm extremely delighted to know that your law firm is gender inclusive and gender oriented. I'm reminded of Lady Susan, who was the greatest lady that could fight against the system that ignored the ladies for casting votes. And I must add another aspect. You said 2020 was different, but you never fought 2020. You never played 2020. You always played a test match. So congratulations.
Thank you, sir. Thank you very much. Thank you.
Congratulations, Pallavi. I think yours has been the generation, rather ours has been the generation that has in fact broken this glass ceiling in India. And it's great that firms like yours exist, which in fact encourage women lawyers, and are gender neutral, gender sensitive, and encouraging young people to do well and to come into their own. Because it is with encouragement of people like you that would lead the way and that empowers young and the fragile. So great. Congratulations.
Thank you, Geeta. Thank you, Geeta. And it's very nice for you to be on the jury, and having seen both of us have walked pretty much the same journey.
That's right. That's right.
Congratulations, Ms. Shroff. Congratulations, Ms. Shroff.
Thank you.
When you accept the award, you inspire a lot of other women professionals to kind of walk on your path and achieve excellence. So kudos and congratulations.
Thank you very much. My pleasure.
Thank you and congratulations, Ms. Shroff. Well, ladies and gentlemen, with this, let's move on to the final award. Now, this is the Hallmark Award, the Mega Award today, and it is the Managing Partner of the Year. So we need all the grandeur coming in, a lot of applause coming in, and let's see who the winner is. Could we have the winner, AV, please? gentlemen, for the Managing Partner of the Year, and that goes to Dr. Manoj Kumar. Congratulations on getting the Managing Partner of the Year, with a lot of applause, virtual applause coming to your way. Over to you, sir.
Thank you so much, Bhavna. In fact, this is very, very significant for me personally and for our firm. As I walk into 26th year of my practice, and our firm walks into 21st year of its excellence in service to our clients. To start with, I would not miss the opportunity to thank my family for all the sacrifices over the last quarter of a century. They've been able to let me go, let me be where I had to be professionally. My wife Shweta, who has been a very significant part and a strong pillar in the journey. And of course, my children who have grown up not seeing me enough. Having said that, I would like to, this award is a tribute to our clients who gave such challenges across the last 25 years, right from disputes to strategy to policy and things which could never be solved by others, and they came up to us and we were able to unlock value. Thank you to our clients for giving the opportunity to perform. And of course, as a managing partner of the law firm, I have always tried to lead from behind and try to empower and decentralize and create as many Dr. Manoj Kumars as possible within the firm. That has been the hallmark of the way I have worked over the years. And I would like to thank my colleagues, both past and present. And before concluding, my special thanks to my teachers, both in law school as well as in the profession. I have learned a lot from all of them to become a better professional, a better leader, and most importantly, a better human being from where I started, including the luminaries on the screen right now, respected Justice Mishra, Mrs. Geeta Luthra, and of course, a big thank you and to Business World, and especially the great work that Dr. Anurag Batra has been doing over the years. And thankfully, he turned his attention to the legal profession. I'm sure the profession is in a lot more in terms of excellence and recognition over the years to come. Thank you so much.
Congratulations, Dr. Manoj Kumar. So, God bless you and you rise further high, and there should be no limit to your progression. And one thing about leadership, I would like to tell you, the best leader is he who leads, but others don't know that he is leading. And you have done that when you say that I am trying to create as many Manoj Kumars as possible. That's very, very nice thought, and you deserve to be congratulated again. My heartfelt congratulations.
Thank you so much, sir.
Ms. Luthra?
Congratulations, Manoj. Very, very well done. It's an honor, well deserved, and may you go to greater heights.
Thank you so much, ma'am.
Congratulations, Dr. Manoj Kumar, and thank you for the kind words. I hope we make a significant impact and become part of the legal fraternity in a deep way. So thank you so much.
Looking forward.
Thank you and congratulations once again, Dr. Manoj Kumar. So ladies and gentlemen, with this we come to the conclusion of the award ceremony, but we've got our eminent jury who have been so kind and who have stayed till the very end of the awards. So if I'd just like to get a few words from Justice Deepak Mishra. So if you could say a few words before we have the official closing as well. Over to you, sir.
No, I must appreciate that the business world is really doing an excellent activity in this field. And the participants are really committedly taking their presentation. And it's a really an experience that we are getting so many law firms who really want to be acknowledged by a jury. The award may be called the Business World Award. As Mr. Batra said, and rightly, that he is a catalyst, is bringing all the others together. And I must say, as far as I am concerned, I consider myself to be a participant in the jury, and it's a delightful experience. And I am really, really exalted that the legal profession is being recognized in such a manner by a business concern. They deserve thanks. Thank you, Dr. Batra. Thank you, Ma'am Luthra, for everything, participating, and thanks to all participants. And thank you, ma'am, for your anchoring. Thank you.
Thank you so much to our jury chair for being with us throughout. If I may get a few words from Ms. Geeta Luthra as well. Ma'am, over to you.
Thank you. Thank you, firstly, for having us. Thank you for giving us the honor. It was wonderful to be on the jury chair with Chief Justice Deepak Mishra, with Justice Sikri, with Justice Radhakrishnan, with Justice Deepak Verma, and with Neeraj. It's been lovely. And Anurag Dr. Batra is as dynamic as they come. And I can tell you that his team, because everyone's been talking of teamwork, and all I can say is his team is also as dynamic as they come. So all of you have done a beautiful job. You put it together so well. I can also thank you on behalf of the legal fraternity, because these awards, there may be awards in various places, in various countries, but the way that you have put these awards together and the manner of your conducting the awards, the transparency of the awards, the quality of the awards, and to some small part, excluding me, in a large part, the jury, has been so exceptional and so outstanding that I hope that this will continue. That's all that I can say to Dr. Batra, that I've seen him outside the BW world, in awards, in speeches, in webinars, in seminars, and I can only say that he comes as a very dynamic person who's doing great things. Thank you.
Thank you so much, Ms. Luthra, for joining
I just
us.
want to first express my gratitude again to Justice Deepak Mishra, former Chief Justice of India, for being so meticulous, taking the ownership of the jury, and really your involvement and your ownership made the awards what they are today. So my gratitude with folded hand. Thank you, Ms. Luthra, for your kind words. Thank you to all the jury members. But I really want to bring in my team here. Really, honestly, this community and this domain, while I may have a general direction and, from time to time call Garima, Ashima, and Krishna, and I really have very little involvement. I don't even know about the winners. Maybe sometime before the awards, I want to know who the winners are and so on. So really, I trust the team and I really trust them. They know it. I push them sometimes. So I really want to bring, of course, you know Ashima, but Krishnendra and Garima also, because really it's the team. They three really kind of curate all our BW Legal World events and the site and the magazine. So Krishnendra, are you here? Joshi Saab?
Yes, sir. Can you hear me?
Yes.
Yes, sir.
So if we can get you on the camera.
Yeah, I'm on the camera.
See, I can't see you. So anyway, you
My
can
camera
see
is a little, the lens is a little dull.
Yes,
so.
now we can see you. And Garima?
Yes, Dr. Batra, I'm here. I would like to thank everyone. Thank you so much, the jury members, for taking my endless calls. Thank you so much. Thank you, Dr. Thank you so much.
You know, I'm blessed. Ms. Luthra, most of the people are almost all are very sincere. You know, that's the biggest, you know, I can say about Garima, Ashima, Krishnan, and I call them, I don't, you know, I want us to be editorially also number one. So I see a story somewhere, it's not us, and I get a link, I call them and I'm like, I'm pushing them always that we should not miss stories because editorially we want to, so they understand that I want to build something that is impactful, and it's not about, it's not that I don't value what they do, but I really hope that we are able to make a significant impact on the legal community and act as a bridge between the business community and the legal community. So you're as good as the team, and it's not a statement. I can't do what I do without the team and what we do. And I see all my colleagues as very long-term colleagues. I don't see them as short-term colleagues, and I tell them that this is your domain. You got to take charge of it. So I'm grateful to Garima, Krishnendra, and Ashima, and thank you once again to everyone.
Thank you so much for the kind words, and a big heartfelt thank you to our jury. Thank you so much for being there with us on different occasions, sitting with us through all the processes. And thank you so much to Bhavna for doing this today. And of course,
and I want to tell you, when I do awards, I'm worried, and especially the legal community. Last time, I got legal notices for people not winning 40 under 40 and some threats from some people. And I really do things through jury process. But honestly, for those who were shortlisted and presented and didn't win, I mean, honestly, we would have liked you to win. Sometimes there is how you present, what you present, luck. So don't be disheartened. There is always the next time. I know we would have also liked to see you winning this year. And we like to be equidistant from everyone. I have had no role in shortlisting, no role in deciding. Justice Mishra is there. So really, we would have liked, we are equidistant from everyone. And really, Ashima, Garima, and Krishnan know the legal domain better than I do. So they really, if at all there are queries, they take calls. I mean, I may work with them for them to bounce it off me, and which I do. But really, it's really, so if you haven't won, my apologies, but it's through a process, and sometimes it's how you play on that day. So I wish you luck next time. So please be a graceful shortlisted entity, even if you have not won. Be graceful. We are grateful for your participation. We have absolute no agenda for or against anyone. So I just want to say that, and that's the only thing on my mind. I know some people.
And there's always the next time.
Yes, just want to say that. And thank you once again, Justice Mishra. I know I told you 90 minutes, but I think some of the speeches got longer, and so but people who won, we have to be able to share this.
No,
so thank you for giving extra
no problem.
Thank you for giving extra. Thank you, Justice.
Thank you, Gitaji.
Thank you, sir. Thank you. Lovely.
Thank you.
Good night. Take care. Thank you so much.
Thank you, Garimaji. Thank you,
and
thank you, sir. Thank you so much, sir.
On the back end also, there is a BW team, Afifa, who was part of the entries, Prerna and Raghav, who managed it. I mean, there is Mayank. There are other people. I always forget some people's name. So, but I know Prerna, Afifa, Raghav, Tanvi's entire team. I may be forgetting names, so forgive me for that. Garima, you would know better. Who am I forgetting?
Mayank was there, Ratnesh was there, then Raghav was there, then we had Sugandh and a couple of other people from the editorial team. So thank you, BW team. Congratulations to all the winners, and thank you, jury members. Thank you so much.
Thank you.
Good night. Thank you so much.
Thank you so much.
Thank you, sir. Good night.
Thank you.
Thank you. Thank you for giving us your valuable time. Well, ladies and gentlemen, with this, what an incredible day it has been. We'd really like to thank you for coming and being a part of the BW Legal World Global Legal Summit and Legal Leader Awards 2020. Well, on behalf of this amazing community, I'd like to now say a big thank you. And this is me, Bhavna Bhatia, signing off for the day. Thank you for joining us. And we'll see you next year with the next edition. Thank you.